Memos kodi. Next 2:30 ಬೇಡ ಅಲ್ಲ ಮಂಡೇ ಲಿಸ್ಟ್ ಆಲ್ರೆಡಿ ಔಟ್ ಆಗಿದೆ. ಟ್ಯೂಸ್ಡೇಗೆ ಎಲ್ಲ ಟ್ಯೂಸ್ಡೇ ಇಂದ ಕೊಡಿ. ವೆಡ್ನೆಸ್ಡೇ ಕೊಡಿ. ಯಾವಾಗ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಕೊಡಿ.
Any date in the next week, my lord. It's posted for admission, my lord.
Pending matter.
Pending, my lord.
Pending matter will come according to senior.
Lord's petitioner is a senior citizen.
Maybe sir, everybody are senior citizens. Fresh matter kodi.
Simple case for quashing, my lord. Any date.
ಎಲ್ಲ simple cases. ಏನ್ ಮಾಡಕ? Why 2:30?
Causing hurt is alleged in the FIR. There is civil dispute between the parties.
So what? 2:30 ಗೆ ಏನ್ ಬಂತು?
The police and the relatives and the parents were completely unrelated to the incident.
Serve a copy on
Civil dispute is pending and
it's all right, give it.
Malad, this extreme urgency, Malad.
ಏನು?
Attachment warrant was issued.
ಅಷ್ಟೇ ತಾನೆ ಕೊಡಿ.
Malad, in
Why?
Malad, 138 proceedings.
Why?
138
Why attachment warrant is issued?
issued against this.
Why I am asking, you're not telling it.
For the compromise.
Defaulting.
Compromise petition.
Compromise petition.
He is not compromise. Accused number 1 and the
No
complaint
problem.
filed, Malad.
ಕೊಡಿ ಕೊಡಿ ಪರವಾಗಿಲ್ಲ.
He is not the accused.
No problem. Sign ಮಾಡಿಲ್ವಾ ನೀವು compromise?
He is not signed. For please, Malad,
Okay,
yesterday police.
Monday or Tuesday? Yes.
Malad,
Give it.
Malad, close.
So what sir? Pending. Monday list out ಆಗಿದೆ already. Don't no Monday sir. Give it. Today? No chance. Give it.
Lord, for
Give it. Yes.
The problem is that they are, even though Millards, the offense is alleged to have been committed within Karnataka, the police Millards are asking me to assist them for West Bengal Millards just because she hails from West Bengal.
What can this court do, sir? Give it. Yes. We'll take it on Tuesday. Six ಇದು ಬೇಲ್ ಕೇಸಾ? ಬೆಲ್ ಕೇಸಾ? ಯಾರು ಬೆಲ್ ಹೊಡೆದಿದ್ದು? ಓ ಅದು ಇವತ್ತಿದ್ಯಾ? ಇವತ್ತಿಗೆ ಬಂದ್ಬಿಟ್ಟಿದ್ಯಾ? ನೋಡೋಣ, ರೀಚ್ ಆದಾಗ ನೋಡೋಣ. ಇವತ್ತಿವರೆಗೂ ಕಾಲಿಂಗ್ ಬೆಲ್ ಒತ್ಬೇಡಿ.
my lord, for memo for
Arrest, my lord.
Huh?
Grounds of arrest, my lord.
Sorry?
Grounds of arrest, my lord. The matter is.
Grounds of arrest?
Arrest, my lord.
Who's going to give grounds of arrest?
My lord, 420 offense.
ಏನು offense ಏನು?
420, my lord.
ಈ 420 ಏನ್ ಬೇಕು ನಿಮ್ ಗ್ರೌಂಡ್ಸ್ ಆಫ್ ಅರೆಸ್ಟ್? ಕೊಟ್ಟೇ ಇಲ್ವಾ?
ಕೊಟ್ಟೇ ಇಲ್ಲ, my lord.
ಕೊಟ್ಟೇ ಇಲ್ಲ ಅಂದ್ರೆ ಕೊಡಿ.
my lord,
This
I
is
have
a
filed a memo
pending
for
matter.
withdrawal, my lord.
Withdrawal please give.
Please.
Yes, Sangat?
In March, I registered an FIR against the.
Tell me.
March, I registered an FIR against the director for an offense under the IT Act, not cyber crimes. They have obtained the stay. We filed for vacating stay. 9 months later, when your lordships have listed the vacating stay for 5th of February, he goes and gets a complaint filed against me for cheating 9 months later. Then FIR, they are threatening to come.
Give it. 2:30.
Millards, this is a pending matter, Millards.
ಮಾಡ್ಕೊಡಿ.
Millards, check bounce case, Millards.
ಏನ್
Interim order was
bounce ಆದ್ರೂ
granted
ಪರವಾಗಿಲ್ಲ,
on,
ಕೊಡಿ.
Millards, subject to deposit of the check amount, Millards. We have filed.
ಯಾವ್ದು ಅಪೀಲ್?
No, Millards. WP, Millards, for quashing they had filed, Millards. It was granted only subject to deposit of the entire check amount, Millards. We have filed vacating IA and for direction.
ಕೊಡಿ ಬರುತ್ತೆ.
Wednesday, Millards.
Which year?
Wednesday.
Which year?
Millards, 2025, Millards. Wednesday, Millards. Millards, this matter.
Tuesday, my lord. Matter for Tuesday, fresh matter. The urgency is
Tuesday,
this.
Monday move ಮಾಡ್ಬೋದಲ್ಲ?
The only urgency is this. After 2 years of litigating before the family court, my lord, I'm the husband.
That's
9
all
of my
right.
family members
You
now
can
are-
you
nine-
can move it, Siri, for Tuesday you can move it on Monday also.
Today, my lord.
Monday ಅಲ್ಲ ಕೊಟ್ಬಿಡಿ ಮೆಮೋ. ಗೊತ್ತಿಲ್ಲ see
Millards, this,
give
Your
it.
lordship said Monday's list is out, my lord.
Monday's list is already out. It web posted already. Yes.
Finally for Tuesday, my lord. 9 of my family members.
We'll
in
see.
DP
Give
Act,
it. Give it.
My lords, it's a disposed,
date
my lords, it's a disposed matter. We have just filed an IA for masking the name of the petitioner, my lords.
Which matter madam?
My lords, it has been disposed of in 24, my lords, we have filed.
ಅದಕ್ಕೆ ಈಗ ಮಾಸ್ಕಿಂಗ್ ಗೊತ್ತಾಯ್ತಾ?
My lords, it may be listed.
We'll see.
for 2:30, your lordship.
ಕೊಡಿ. ಯಾಕರೆಪ್ಪ ಕೊಡಿ.
Date given matter, my lord.
ಯಾರು ಕೊಟ್ಟಿದ್ದು?
Coordinate, my lord.
ಕೊಡಿ. ಕೊಡಿ ಸರ್.
My lord, the matter may be referred to the mediation, my lord.
Wait. When do you want it?
Wednesday, Tuesday or Wednesday.
ಕೊಡಿ ಮೇಡಮ್.
My lords, on
Mediation reference ಅಂತ ಬರೀರಿ.
Millards, that's a pending matter, my lords. Lords, the urgency being in this matter, my lords,
Other fresh matters, please give it off.
there are goons.
My lords, it's a pending
Other
matter.
fresh matters
My lords,
ಕೊಟ್ಬಿಡಿ.
pending matter.
Pending matters ಕೊಟ್ಬಿಡಿ. One minute, any mentioning I'll hear, wait. Give
But Khalid
reporting
sir-
settlement. What do you want? Please mention the date and give. All right, give it. ಕೊಟ್ಬಿಡಿ.
Anyway, next.
Is the petitioner
Not reach the.
not listed because of the reason that he has executed a affidavit in Dubai, my lord.
Hmm.
He is working in Dubai airport, therefore he.
But who is representing him here? Who is representing him here?
He is executed affidavit in there.
ನೋಡೋಣ ಕೊಡಿ, ಬರುತ್ತೆ ಕೊಡಿ.
Your lordship, one submission with regard to threat of arrest.
ಕೊಡಿ sir.
Your
Give
lordship,
it. Give it sir, fresh
your
matter.
lordship,
No date sir, give it. Please give.
your lordship,
You please, if you want to give it, give it. Give it, take
your
it.
lordship, one small submission, my lord. There is a threat of arrest, my lordship.
2:30.
For, your lordship,
2:30,
today.
yes.
Your lordship, there is a threat of
If
arrest.
it is FR, it won't come.
There is a,
Number ಇಲ್ಲ, FR ಇಲ್ಲ ಅಂದ್ರೆ ಮೆಮೊನೇ ಕೊಡ್ಬೇಡಿ.
there is a threat of arrest to the family members of the practicing
No,
advocate in
no
Bangalore.
problem.
And
FR,
No, your lordship, it's a case number, your lordship.
ಆಯ್ತು.
And office objections has been complied. with.
ಆಯ್ತು ಕೊಡಿ.
Kindly
Threat
have
of arrest 2:30 ತಗೊಳ್ಳಿ ಮೇಡಮ್.
2:30. Sure.
Why? No problem. Tuesday. That's okay. 498 ಆಗಲ್ಲ. ಬೇಲ್ ತಗೊಂಡಿಲ್ವಾ? ಸರಿ ಬಿಡಿ ಕೊಡಿ. ಎಲ್ಲ ಬೇಲ್ ಕೋರ್ಟ್ ಕನ್ವರ್ಟ್ ಮಾಡ್ತಾ ಇದೀರಾ ಇದನ್ನ? ಯಾವ್ದು ಕೊಡಲ್ಲ ನಾನು ಇನ್ನ. No, even 100 members ಇದ್ರು ಕೊಡಲ್ಲ. ಕೊಡಿ. Give it sir. Take bail. Go. Go and participate in the investigation. ಏನ್ ಅರೆಸ್ಟ್ ಮಾಡ್ತಾರ ಬಿಡಿ. ಪರವಾಗಿಲ್ಲ ಕೊಡಿ ಸರ್. ಎಸ್ ಕೊಡಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ, ಕೊಡಿ ಸರ್. ಎಸ್ ನನ್ ಮುಂದೆ ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಡಿ. ನಾಟ್ ಬಿಫೋರ್ ಮೀ ನಾಟ್ ಲಿಸ್ಟೆಡ್ ಪ್ರಶ್ನೆನೇ ಇಲ್ಲ. ಬಿಫೋರ್ whom it was not listed, not reached. Before whom it was not reached. Before me? Then give it. Give it sir. ಕೊಡಿ ಸರ್ ಸುಮ್ಮನೆ. ಎಸ್ ನೋ give it. No, yes give it. $2:30. Want of time in this court at 2:30. Please give. Yes. Please give. Give it, madam. Yes. Why? Register a complaint. Take bail. ಗುಂಡಾಸ್ ಇದ್ರೆ ಪೊಲೀಸ್ ಪ್ರೊಟೆಕ್ಷನ್ ತಗೊಳ್ಳಿ. ಇವೆಲ್ಲ ಸುಮ್ಮನೆ ಹೇಳ್ಬೇಡಿ, ಕೊಡಿ. Don't tell me all this. No problem. Give it, madam. Because of customers, you are here. Come. Yes. Give it. No, nothing doing. Yes.
Your lordship is
Monday
small.
or Tuesday. Move
Your lordship
Move
is
it for
small
Monday.
indulgence for a further hearing.
Give it.
Your lordship is small,
No adjournments, please don't ask.
a small indulgence for a further hearing matter, not listed. I'm moving a memo.
Give it. Yes.
It
Further
was
hearing on
supposed to be
6th.
listed on
Everything on
5/1.
6th. Give it. ಏನು? ಕೊಡಿ. ಟ್ಯೂಸ್ಡೇಗೆ ಆಗುತ್ತೆ. ಮಂಡೇ ಲಿಸ್ಟ್ ಬಂದಿದೆ, ಟ್ಯೂಸ್ಡೇ ನೋಡೋಣ, ಕೊಡಿ. ಎಷ್ಟಾಗುತ್ತೆ ಅಷ್ಟು ಕೊಡೋಣ ಟ್ಯೂಸ್ಡೇ. ಗಿವ್ ಇಟ್ ಮೇಡಮ್. ಸೊ ಲೆಟ್ ಇಟ್ ಬಿ ಫ್ರೀ. ಯಾವ್ದು ಫ್ರೇಮಿಂಗ್ ಆಫ್ ಚಾರ್ಜ್ 2:30 ತಗೋಬೇಕಾಗಿತ್ತು ಮೇಡಮ್? Who knows? 16924. ನೋಡೋಣ, ವಿಲ್ ಸಿ ಇಫ್ ಇಟ್ ಇಸ್, ವಿಲ್ ಟೇಕ್ ಇಟ್ 2:30. ವೈ? ಎಲ್ಲ ಥ್ರೆಟ್ ಆಫ್ ಅರೆಸ್ಟ್ ಅಂದ ತಕ್ಷಣ ತಗೊಂತೀನಿ ಅಂತನಾ? ಸೆಕ್ಯೂರ್ಡಾ? ಥ್ಯಾಂಕ್ ಯು. ನೋ ಪ್ರಾಬ್ಲಮ್. ಎಲ್ಲೆಲ್ಲೋ ಮೋಸ ಮಾಡಿರ್ತೀರಾ, ಅದಕ್ಕೆ. No problem. Monday or Tuesday it will come. Leave it. Huh? Please give, sir. Give all the memos, sir. No 2:30, no Monday. Give it. We'll see it Tuesday. We give it. Yes. And Tuesday 100 ತಗೊಳಕ್ ಆಗಲ್ಲ, ಕೊಡಿ sir. I can take what I can take. That's all. Give it. Yes. No, yeah, ಎಲ್ಲಾರ್ಗೂ urgency. ಎಲ್ಲಾರ್ಗೂ urgency. What should happen to me? Give it, sir. ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ ಸರ್. ನನ್ನ ಕೈಲಿ ಎಷ್ಟಾಗುತ್ತೆ ಅಷ್ಟು ತಗೊಂತೀನಿ, ಕೊಡಿ. 100 times ತಗೊಂಡ್ರು ಅಷ್ಟೇ, ಕೊಡಿ ಸರ್. ಮೇಡಮ್ ಅದು ದುಬೈಲಿ ಇದಾರೆ ಅಂತ ಹಾಕಿಲ್ಲ ಅಂತೆ, ಅದು ಯಾವ್ದು 3ನೇ ಸರಿ ಹಾಕಿ, ಅದು ಟ್ಯೂಸ್ಡೇ. ನೋ ಪ್ರಾಬ್ಲಮ್. ಗಿವ್ ಇಟ್ ಫಾಸ್ಟ್. Will you give it or not? No 230, give it, yes.
My lord, this passport,
Please give them, call the cases, madam.
My lord, for settlement on Tuesday.
Please please give the memos, call the cases, please.
My request,
Not one more minute for memos.
my lord,
Call the case.
my lord, is
For-
HI employee, madam.
Give sir, give sir.
My lord,
Passport
HI employee, madam,
Before-
retirement plus and request, Tuesday ಹಾಕೊಳ್ಳಿ, my lord.
ಕೊಡಿ
Retirement, pending, my lord, stay again.
Pending ಬರಲ್ಲ sir.
My lord, settlement.
Pending seniority ಪ್ರಕಾರ ಬರೋದು, ಯಾವ pending ಮೆಮೋನೇ ಕೊಡಬೇಡಿ.
my lord, for passport renewal.
My matter,
there is
pending
a-
matter, there was a settlement.
No problem, settlement ಇದ್ರೆ ಕೊಡಿ.
ಅಲ್ಲ
Settlement
settlement
on Tuesday.
ಅರ್ಧ settlement ಆಗಿದೆ, ಅರ್ಧ settlement ಆಗಿಲ್ಲ.
ಅರ್ಧ ತಗೊಂತೀನಿ, ಅರ್ಧ ತಗೊಳಲ್ಲ. ಬಿಡಿ. Yes. Nothing, give it.
Next week, any date.
Give it, give fast.
My lord, my lord,
Call the cases, madam.
my lord, for moment, my lord, in this case,
Give sir.
my lord,
No 230.
my lord, for passport renewal, my lord, there's some stay order.
No
granted by
problem,
this
sir.
court, my lord.
File
There's
an
some
application-
urgency.
File an application.
My lord,
I file it, my lord.
Then
I
it
file
will
it,
come
my
to
lord.
it.
Plus,
My
any
lord,
date may be fixed, my lord.
ಕೊಡಿ
please.
sir.
Leave relationship, my lord.
Sorry?
Since 3 years, leave relationship.
So,
Promise to perform the marriage.
So,
376 application.
leave, give it sir.
My lords,
Events are not going to fall, give it.
Lords, petitioner is an
Madam.
IAS officer, my lords, for Tuesday. The urgency is this, it's a DA case, my lords. The problem is, my lords, none of the property is in my name. I'll serve on BB Patil.
ಕೊಡಿ.
Tuesday, my lords, I'm
ಆಯ್ತು,
seeking.
My lord, any date may be fixed, my lord.
Fresh matter.
ಇಲ್ಲ,
Pending.
passport renewal.
ಆಯ್ತು,
must stay.
application ಮೇಲೆ ಬರುತ್ತೆ.
I've already filed, application is already filed, my lord.
Thursday, your
Any
lordships
date.
had passed an order directing the ED not to
Any date.
proceed with further in Puppy's case, your honor.
Puppy.
Puppy's Tools and
all
Travels.
right.
This is a connected case arising out of the same
Other
ECIR.
puppy.
Same ECIR, Swami. May be taken up on Monday.
No.
Because the proceed.
Monday's list is already out, sir.
Tuesdays.
I will see, yes.
so for my lords, for settlement. my lord,
Whenever
on
you want,
Tuesday.
yes. Call the cases.
Being spoken to still number 1.
ಏನಿದು?
With regard to redaction of my complainant's name and the details, asking. Under 15A, my lord, clause 8.
ಅದ್ರಲ್ಲಿ ಯಾವ provision ಇದೆ?
CST Act, my lord.
Pass ಮಾಡ್ಬೇಕು. Pass ಮಾಡಿ register ಮಾಡಿ.
Here, yes, my lord.
ಅದೇ. Yes. ಅದೇನು judgments?
No, my lord, that, the places wherein actually his details are occurred.
ಆಯ್ತು ಕೊಡಿ. ಎಲ್ಲೆಲ್ಲಿದೆ?
Many places.
Many
Even in
places ಗೆಲ್ಲ
the-
ಇಲ್ಲಿ masking ಆಗುತ್ತಾ?
Yes, inside the judgment also, my lord, the entire, as it is, the statements are all
Obviously, ಹಂಗೆ
extracted.
ಇರ್ಬೇಕು ಮತ್ತೆ ಇನ್ನೇನು? ನೀವು ಮಾಡಿರೋ ಸ್ಟೇಟ್ಮೆಂಟ್ ನಿಮಗೆ
The
ಕರೆಕ್ಟ್
statement
ಆಗಿದೆ.
and all, my
ಲಾಸ್ಟ್
lord.
ಟೈಟಲ್ ಮಾಸ್ಕ್ ಮಾಡ್ತೀನಿ.
That is dismissed, my
ಓ
lord.
ಯಾವಾಗ?
That is dismissed.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೊಡಿ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಕೊಡಿ.
My lord, everything is mentioned.
ಒಂದ್ ನಿಮಿಷ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಕೊಡಿ.
That is mentioned, my lord.
ಹಾ.
Stating that, my lord, the delay is causing in the proceedings.
ವಿಚ್ ಡಿಲೇ?
ಈ ಕೇಸ್ಗಳಲ್ಲಿ. So number.
ಎಲ್ಲಿದೆ ಡಿಲೇ?
ಅಲ್ಲ, ಅವರೇ, my lord, on the date of the dictate, made the orders posted for, matters posted for dictating the orders, my lord. Kindly there is the order sheet. He has got a permission to engage an advocate.
ಕರೆಕ್ಟ್. ಹಾ.
Then, my lord, instead of engaging advocate, he went to Supreme Court.
ವೆರಿ ಗುಡ್. ಆಗಿದೆಯಲ್ಲ ಬಿಡಿ, ತೊಂದ್ರೆ.
That came out under the provisions of section 15 subclause A.
We'll pass orders only strict consonance with 15A. All right?
If he has been treated.
ಎಲ್ಲಿ ಇಲ್ವಾ ಅವರು? Where is he? ಸೋಮಶೇಖರ್ ಬಂದಿಲ್ವಾ?
ಬಂದಿದ್ದಾರೆ.
ಎಲ್ಲಿದ್ದಾರೆ? ಕಾಣ್ತಾನೆ ಇಲ್ಲ ಮತ್ತೆ?
Outside.
ಔಟ್ಸೈಡ್ ಇದ್ದಾರೆ. ಔಟ್ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಆಲ್ರೆಡಿ.
My lord, yes. No, he went to Supreme Court and it got dismissed without even hearing also.
Obviously, yes sir. ಮತ್ತೆ?
Much obliged.
15A ಪ್ರಕಾರ ಏನ್ ಆರ್ಡರ್ ಮಾಡ್ಬೇಕು ಅದ್ ಮಾತ್ರ ಮಾಡೋದ್ನ.
My lord,
ಇದು ವಿಕ್ಟಿಮ್ ಅಲ್ಲ ಇದು.
Lord, already a related judgment, your lordship has passed the same related judgment.
ಅದ್ರಲ್ಲಿ ವಿಕ್ಟಿಮ್ ಸರ್. SC/ST ನ ಅದು.
It's not SC/ST.
ಪೋಕ್ಸೋಗೂ ಇದಕ್ಕೂ ಒಂದೇನಾ? According to 15A, what is to be passed, I will pass, take it to Supreme Court. All right,
No,
we'll see.
Much obliged.
ಇಲ್ದರೆ ಪ್ರಾಬ್ಲಮ್ ಏನಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇನ್ನೊಂದು ಕ್ರೈಮ್ ಬರುತ್ತೆ.
PIL ಹಾಕಿದ್ದಾರೆ.
YPL ಏನಕ್ಕೆ?
PIL, my lord, mentioning so many cases. My lord, he has challenged, my lord. He has sought, my lord.
That is not.
That ex parte interim order should not be granted.
ಓ.
Copy could you?
ಆಯ್ತು.
PIL judgment.
ಅದು ಡಿಸ್ಮಿಸ್ ಆಯ್ತಾ? ಕೊಡಿ ಅವ್ರಿಗೆ. ಪ್ರಾಸಿಕ್ಯೂಷನ್ಗೆ ಗೊತ್ತಿರಲ್ಲ.
ಅವ್ರ ಮೇಲೆ ನಮ್ಮ ಮೇಲೆ ಗ್ರೀವೆನ್ಸ್.
ಹೌದೌದು.
We are responsible for the this court granting stay and we have not been objected.
ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಕ್ ಹೇಳಿ. He'll have a good practice. ಅಲ್ಲಿ ಇವ್ರಿಗೆ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಕ್ ಹೇಳಿ. He'll have a good practice. ಇದೆಲ್ಲ ಬೇಡ ಯಾಕೆ? It is better he practices and becomes a good advocate. That's enough. ಇದ್ರಲ್ಲಿ ಇಂಟೆಲ್ಜ್ ಆದ್ರೆ ಏನಾಗಲ್ಲ. ಪರ್ಸನಲ್ ಸ್ಕೋರ್ಸ್ ನ ಸೆಟಲ್ ಮಾಡಕ್ಕೆ ಇಫ್ ಯೂಸ್ ದಿ ಅಟ್ರಾಸಿಟೀಸ್ ಆಗ್ತಾ ಇದೆ. ಹೌದಾ ಇಲ್ವೋ ಹೇಳಿ ಮತ್ತೆ. ಆಯ್ತು, ಅದು ನೆನ್ನೆ ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ ಜಗದೀಶ್ ಸರ್. ಅದರಲ್ಲಿ ಅಲ್ಲ ನೆನ್ನೆ it has a chilling effect on the profession. Every advocate who is representing the accused are made accused in separate crimes. Tomorrow you may be caught, tomorrow you may be caught. So we should be very careful about complainants registering crimes. Police should inquire into it and advocate ಮೇಲೆ ಮಾಡಕ್ ಮುಂಚೆ whether it has happened really ಅಂತ ಮಾಡೋದು. ಎಲ್ಲ accused ಯಾರ್ಯಾರು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತಾರೆ complainants are registering separate crimes against them.
ನಮ್ಮಂದೆ ಇನ್ನೊಂದಿದೆ ಮ್ಯಾಮ್, ಫಾರೆಸ್ಟ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್
ಈ ಕೇಸಲ್ಲಿ
ಅಲ್ಲ, ಈ ಕೇಸಲ್ಲಿ ಇರಲಿ. ನಿನ್ನೆ ಒಂದು ಕೇಸಲ್ಲಿ ಇದೆ,
ಅದು ನಿನ್ನೆ ನೋಡಿದೆ ಸರ್.
ಅದಕ್ಕೆ
ತುಂಬಾ ವೈರಲ್ ಆಗಿದೆ.
ಚಿಲ್ಲಿಂಗ್ ಫಾರೆಸ್ಟ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ತಮ್ಮಂದೆ, ಫಾರೆಸ್ಟ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಒಂದು ತಮ್ಮಂದೆ,
ಅದು ಒಂದಿದೆ. ಅದೆಲ್ಲ ಬರೀತೀನಿ ಸರ್. These complainants, just because they lose the case, they go and register crimes against the advocates. Most dangerous trend. We'll see. Yes.
This case may be taken on that particular day.
ಯಾವ್ದಕ್ಕೆ
ನಿನ್ನೆ ಆರ್ಡರ್ ಮಾಡಿದ್ರಲ್ಲ ಸರ್,
ಅವತ್ತಿಗೂ ಹಾಕಿದ್ದೀನಿ ನಾನು.
ಆ ಡೇಟ್ ಹಾಕಿ
19th ಹಾಕಿರ್ಬೇಕು. ಲೆಟ್ ಮಿ ಸಿ. ಅವತ್ತಿಗೆ ಮೂವ್ ಮಾಡಿ ನಿಮ್ ಕೇಸ್ನ.
ಅಲ್ಲ, ಇದೇ ಕೇಸ್ ಅವತ್ತಿನ ಡೇಟ್.
ಈ ಕೇಸ್ ಯಾಕೆ ಬೇಕು ಅವತ್ತಿಗೆ? ಇದರಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ ನಾನು. 15A ಪ್ರಕಾರ ಏನಿದೆ ಅದು ಆರ್ಡರ್ ಮಾಡಿ. Yes, next.
In this matter, my lord, the amount deposited in court was directed to be released in favor of the respondent. The office, my lord, has said that the account details are furnished as a joint account. Unless there's a specific order directing the payment into this account, it will not be released.
This court had disposed the matter on a settlement arrived at between the parties.
Settlement
had disposed the matter disposing the matter on the order passed by the division bench. The learned counsel for the respondent has moved his memo on the score that the deposit that was made at the time when the petition was filed is not being returned to the respondent on the score that the account details rendered are now of a joint account.
Yes.
Therefore, the undertaking of the petitioner, undertaking of the respondent, undertaking of the respondent be obtained and the amount be released, notwithstanding the fact that it is a joint account.
Please, ma'am. Very nice.
Next matter, still number 3.
Madam,
it was heard for some time, my lord, and at my instance it was adjourned. I
Correct.
wanted to file
Predicate,
objection.
yes.
I have filed the objection, my lord.
Could I just?
You have filed the objection?
Yes, ma'am.
I didn't see the objections. Tell you the objection.
I have filed it yesterday, my lord. Sir, 28th Jan.
It's not, I read the file, I thought you have not filed your objections.
No, I have filed it.
That we are having, can I express it? My
Yes,
lord?
sir.
8th and 9th of this month is his marriage. On the
Whose marriage?
petitioner's marriage, my lords. He had got stay in the predicate offense on 15/10/2025, my lords. Now, in so far as the present proceedings is concerned, my lords, even if he had to surrender and seek bail, the kind of endorsement we get is the prosecutor says, let him be taken into custody, give me time to file my objection. All the others, out of 39 persons, my lords, except 3 of them, 36 have been granted bail.
Why he has not granted bail?
My lords, what happened is,
So what's the problem in granting bail to him?
my lords, now the prosecutor wants to take time, asking him to surrender for him to be taken to JC and only then consider. That seems too harsh, my lords. Remaining persons all on the same day, objections filed, bail granted.
Yes,
So let them not precipitate till my marriage takes place and if
ಮದುವೆ ಆಗ್ಲಿ ಬಿಡಿ ಶಾಂತವಾಗಿ.
ಅಲ್ಲ, ಮದುವೆ ಆಗ್ಲಿ ಅಂತಂದ್ರೆ the nature of allegation against him is so serious, my lord.
ಅಲ್ಲ, ಅದಕ್ಕೂ ಮ್ಯಾರೇಜ್
ನಾನು ಏನ್ ಹೇಳಿ ಇಂಥ ವಿಚಾರದಲ್ಲಿ ಯಾಕಂತಂದ್ರೆ
ಅಲ್ಲ, if he is getting married on
if
8th,
he had already filed anticipatory bail and that
if he
anticipatory.
is getting married on 8th and
Yes.
they are taking him into custody.
Yes, my lord.
Where will he marry?
My lord,
Custody?
Allah, he was in
And
judicial
predicate offense,
custody.
my
He
lord,
was in
October
judicial
we got the bail.
custody. He was in judicial custody insofar as.
Oh, idu
Ha.
land acquisition,
My lord,
double, triple.
Allala, my lord.
And this marriage also, I am now doubting. The marriage is another reason to get away from this particular.
Invitation.
My lord, this is not a case of double compensation so far as the petitioner is concerned. My lord, so far as the petitioner is concerned, the specific cases, one, my lords, Qasim, he was granted compensation for the first time. The compensation granted was about 2.9 crores. My lords, their contention is that compensation which is granted is on the higher side. It ought not to have been granted so much because the trees that were there.
ED is saying so?
Yes, my ED says that, and in that amount which was given to Qasim, Qasim has given as a loan 1.2 crores to the petitioner, which is being by way of RTGS, which is being returned. This is his role in the whole thing. Insofar as remaining are concerned, my lord's case of double compensation, but this is not a case of double compensation.
You come on merits.
Yes, my lord. This is a case, my lords, on merits. If the complaint is seen, my lords,
Yes.
the primary
Okay, you're ready,
contention.
Allah? Yes.
The primary contention which we pointed out is, my lords, in the complaint, initially there's a reference given to 5 FIRs as a reference. And then,
which page?
my lords. My
No,
lords,
Sandesh sir,
paragraph.
what is under challenge now?
My lords, the entire proceedings, stay of predicate offense has taken place. When there's stay of predicate offense, the complaint should not proceed further based on Umar Reddy's and other cases. That's the main challenge, my lords. If this complaint is noticed, my lords, page, I think on the last occasion, my lords was pleased to notice the FIRs which are mentioned. The FIRs are mentioned at page 98.
Okay, yes. No. What is
My lords,
page?
there's a table which my lords would get at page 97.
One moment.
97.
One moment. Yes.
My lords,
I
in the
made a note
table
here.
at page 97, 5 FIRs are mentioned, of which the most relevant FIRs are the first 2 FIRs, 251 of 2022 and 72 of 2023. Thereafter, if my lords would notice, they proceed on the basis of these 2 FIRs for the purpose of investigation of the proceeds of crime. My lords gets that at 3 point.
Now, those are stayed.
Those are stayed, my lords. And
issue that's to be thrashed out is once there is a stay.
Can
whether-
this proceed?
Whether ED can proceed with the
in the
ECIR.
complaint, my lords.
A
Now
complaint.
they're at the stage of the complaint, not even ECIR, at the stage
Oh,
of
it's
the
complaint.
complaint, my lords.
Can they proceed with the complaint?
Can they proceed? Because it's, according to us, my lords, it's pushing the cart in front of the horse, my lords. You are allowing the ECIR proceedings and complaint to proceed.
I think in one of the cases I had arrested this till the predicate offense would get over.
Yes, ma'am.
Once the predicate offense would, if it is dismissed.
Yes, ma'am.
Then it would straight away, ED would get the
So
jurisdiction.
normally, my lords, as my lords has seen, my lords, if
So
it's
which
going
are-
simultaneous,
One minute. Which are those crimes?
my lords,
Challenge
crime,
ಆಗಿರೋದು ಯಾವುದೆಲ್ಲ?
2 crime
ಧಾರವಾಡದ
numbers,
ಎಲ್ಲ?
250, Dharwad, 250.
ಇಲ್ಲಿದಲ್ವಾ?
My lords, crime number 251 of 2022 and 72 of 2023. These are the primary 2 crime numbers. If we see the complaint, my lords, the entire investigation takes place on the basis of these.
One moment, sir. Where are the orders, stay orders granted?
My lords, the first stay order is at page 232.
Justice Rachaya ಅವರದಲ್ಲ?
Yes, my lords, 3rd December 2025.
All right, next.
The second stay order, we have given it along with the memo, my lords, on the last occasion.
ಹೌದಾ?
That was on the previous date, my lords, it has been handed over separately. You got a copy? An order copy, my lords, stay of the other crime number. Can I pass it on? And my lords, we also expressed, my lords, the difficulty. What had happened is,
ಇದು ರಾಚಯ್ಯ ಅವರದ್ದು.
my lords, what had happened is, so far as the bails are concerned, my lords, I was under arrest.
482 stay ಮಾಡಿರೋದ ಬೇಲ್ ಆಯ್ತು?
482. My lords, the problem that took place in so far as this bails is concerned, I was arrested in the predicate offense, my lords. I was in custody for about 2.5 years. So in the ECIR, initially under body warrant, I was sent and they questioned. Then, my lords, in the ECIR, they take custody. But my lords, when I got bail in the predicate offense, without noticing that they've taken me in custody in the ECIR, they released me. So on 15th October, I come out, my lords. So now, even if I have to surrender, my lords, in this case, the endorsement that is given is, you await, you first endorsement given by the prosecutor, not by the court, my lords. You wait, you first go inside. I will take my time in filing objections.
Can we hear all this together
Yes, my lord.
on Tuesday?
It could be.
Predicate offense and this.
Yes.
Well,
But predicate offense is in Dharwad bench.
Dharwad bench, my lord.
so what? It requires the order of the Chief Justice, that's all.
We require. My
So
lords,
that it goes hand in hand.
my only request is this, my lords.
Your marriage.
How, my lords?
Before marriage, we'll take it.
Allah, my lords, what I'm requesting is, my lords, from 15th October, I've been enjoying the liberty. Now my marriage is on 8th and 9th. My
Allah,
lords.
you're in custody now.
No,
Then
I'm
what?
outside now. So protect me till then. My lords, let me at least have a peaceful marriage. After that, my lords may take it up, and if my lords feel there's no merit, then it is all right. At least for that, and enjoying the benefits since October, my lords.
I will pass an order to club all these and list it on 4th.
Please.
4th, we will protect you and your marriage both.
My lord, fourth, the one matter in Dharwad bench, my lord, I may have to.
ಅದು ಇಲ್ಲೇ ತರ್ಸು ಇಲ್ಲಿದೆ ಅಂತ ಅಲ್ಲಿ
It is a special order matter, my lord.
No problem, yes.
Could it be on 5th then, my lord's side?
All right.
Perfect.
Yes. Heard the learned senior counsel Sandesh Chowta appearing for the petitioner along with Avinash Angadi and Madhukar Deshpande representing the Enforcement Directorate. The learned senior counsel taking this court through the documents appended to the petition would demonstrate that the predicate offense upon which the ECIR by the Enforcement Directorate or the complaint so filed is foundation has been stayed by the hands of the coordinate bench. The learned senior counsel submits once there is a stay of the ECIR or stay of the predicate offense, the complaint, ECIR or the complaint cannot be permitted to be proceed further, and would submit that there is grave urgency in the matter as the petitioner, who's getting married?
Petitioner, my lords.
The petitioner is getting married
On 8th and 9th of February.
8th and 2 days.
2 days, my lord. She and his brother both are getting married.
Together.
Same message. That's quite common. My lords.
All right. The petitioner is getting married on the 8th, and therefore some order of protection be granted. In the light of predicate offense pending and stay being granted, and those being before the Dharwad bench, it is the opinion of the court that the predicate offenses and the present petition, the petitions challenging the predicate offense and the present petition be heard together. Therefore, the orders of the Honorable Chief Justice be obtained for tagging these matters together to be heard on the 5th. List the matter on the 5th in fresh matters list.
My lord, only request is that, my lord, with respect of predicate offense, my lord, the state has to argue the matter. If they
Don't
won't,
worry,
yes,
he will always be ready.
yes.
Yes. Don't worry about Jagdish, sir. He will be ready. Yes.
Obliged.
Yes, yes. Avattu will decide the issue itself.
Yes.
ಆಮೇಲೆ ಸಂದೇಶ್ ಸರ್, the allegation in the predicate offense or this, it's 406 and 409. The offenses are that. So you will have to demonstrate that you have not claimed dual compensation
Yes, my lords.
of the lands that had already been given compensation 20 years.
I will show it, my lord.
That's the allegation.
Because this, in so far as I am concerned, my lords, first compensation given to a person, 2.9 crores given to him. He in turn has lent me 1.2 by RTGS.
Correct. When is that first compensation?
I will point that out also.
Adanna-
Their grievance appears to be is excessive compensation given to him.
Excessive
That
compensation.
will not come within the ambit of the
TD would
criminal
not,
act. It can
bother.
always be set right.
But if there is dual compensation.
No, I will
then
point that out. If I'm able to demonstrate, my lords, it's not a case of dual
So,
compensation.
KDB dalva idu?
How?
KDB compensation.
KDB.
Is it?
My lords, about 39 accused, my
No.
lords.
2005 ಅಲ್ಲಿ ಆಗಿರೋ acquisition ಗೆ 2010 ಅಲ್ಲಿ ಆಗಿರೋ
2010.
acquisition compensation ಕೊಟ್ಟು ಮತ್ತೆ 2025 compensation ತಗೊಂಡಿದ್ದೀರಾ. That's the
That's
allegation.
dual compensation only, my lords. That's dual compensation only. But in this, we will be able to show it's the first compensation to a person who's entitled to it. Grievances exist.
Excessive ಅಂದ್ರೆ
We will point that out.
ಬೇಬಿ ಪಾಟೀಲ್ ರೇ, ಇದರಲ್ಲಿ your assistance also may be required because 2010 ಅಲ್ಲಿ compensation ತಗೊಂಡಿದ್ದಾರೆ. ತಗೊಂಡ್ಬಿಟ್ಟು 2025 ಮತ್ತೆ ಕಾಂಪನ್ಸೇಷನ್ ತಗೊಂಡಿದ್ದಾರೆ ಅದೇ ಲ್ಯಾಂಡ್ಸ್ಗೆ ಅಂತ ಅಲಿಗೇಷನ್. ಸ್ವಲ್ಪ ರೆಕಾರ್ಡ್ಸ್ ಮೇ ಬಿ ರಿಕ್ವೈರ್ಡ್. ವಿಲ್ ಸಿ. KDB ಅಲ್ವಾ ಅದು?
Yes, yes, my lord.
KDB.
KDB is the de facto complainant.
KDB is the complaint.
We know, my lords, this incident
But
where in
the
Dharwad.
subsequent special land acquisition officer finds that it was a case of dual compensation, gives a complaint, bare complaint saying this is what has happened, then the investigation that took place. And then the.
We'll hear it wholeheartedly.
Yes.
Please.
Bill number 4, your lordship may recall, this is the advocates fighting. There's another, no, your lordship, I think has to see this, madam, most disturbing trend. The lordship see the wound certificate obtained by the petitioner for his case.
1 minute.
At page 13, my lord. Wound certificate at page 13.
Idiyan Jagdish sir?
Alla, this wound certificate, nature of injury and the doctors, he obtains this, he says these two injuries are grievous in nature.
Oh, and are grievous in nature.
Now your lordship may see 116, what is the grievous injury?
Page 116.
Allala.
Idralli, section, BNS.
BNS.
I don't know how this can be brought within the purview of 116, my lord.
Grievous hurt.
Yes, ma'am.
My lord, it's about the size of the wound that has been
One moment,
inflicted.
sir, 1 moment. Lacerated wound on the right knee, incised lacerated wound on the right arm, small swelling on the scalp. Injuries 1 and 2 have been sustained in an assault and are grievous in nature. Inquiry 3 is simple in nature. So the lacerated wound on the right arm and the right leg is said to be grievous.
Yes.
Grievous.
My lordship, may I kindly see,
Who
look
has
at the
given
picture.
this,
This is the doctor, the issue, my lord. Your lordship may see this particular petitioner has more than 8 cases registered against him of largely with respect to insurance scams.
MVC cases, my
Motor
lord.
vehicles
But-
accident insurance scam. This is one such petition filed by him. In fact, my lord, 2, my lord, this your lordship may see in these 2 cases.
I totally agree, my lord. There are.
One moment, sir.
No,
One
it's not
moment.
about
I'll
this.
get back to you, sir. One moment.
He is the respondent in these 2 MVC cases. And the petitioner's counsel is his junior. And I have been told, my lord, the injury certificate is issued by the same doctors.
ಎಲ್ಲಿ ಇಶ್ಯೂ ಮಾಡಿರೋದು ಸರ್ ಇದು?
Private hospital in Kerpet, Kernagar.
ಎಲ್ಲಿ?
Kerpet.
KRPet.
Yes.
New Apurva Super Speciality Hospital, KRPet.
Who is the name of the doctor? MBBS MD.
These are the history of his cases.
The petitioner is before this court calling in question registration of a crime for offense punishable under section 109, 118, 351 of the IPC, BNS, which would be 307 and 324 of the earlier regime, the IPC. The issue is case and a counter case. Crime number 244 of 2025. Nimdi yavadu crime number?
244.
244 of 2025 is registered by the petitioner. On this score.
My lord, one submission. I was admitted to the hospital based on which an MLC came to be registered.
Correct, sir.
Based on MLC, the FIR has been registered.
ಈಗ ನಿಮಗೆ this is Boregowda was Nagegowda ತಾನೆ?
Yes, ma'am.
1 minute. Boregowda's FIR is 244. Let me dictate.
Yes.
244 of 2025. The crime is registered on 3/12/2025 at 5:30 PM. Prior to that, at about a little later to the registration of the crime by the petitioner, a counter case comes to be registered in crime number 243 of 2025. After that, correct, at 9:05 PM. The learned counsel for the petitioner submits that the petitioner has suffered severe blow. Then pictures ಎಲ್ಲ ಹಾಕಿದ್ದಾರೆ ಮತ್ತೆ?
ಏನೇನೋ ಹಾಕಿದ್ದಾರೆ ಇವ್ರಿಗೆ ಕಂಪ್ಲೇಂಟ್
severe blow and has produced certain pictures of lacerated wounds on the arm and the knee. This can't be simple at all. if photographs are what is said, it can't be simple, it is grievous.
Allala, but opinion.
Opinion is grievous, sir.
But it is, in fact, I've been told, my lord, there is no injury.
Lord,
ಮತ್ತೆ ಇದು ಎಲ್ಲಿ pictures ಇವೆಲ್ಲ?
And contrary, the
ಕೊಡಿ ಒಂದು ನಿಮಿಷ. The learned additional SPP on instructions and verification of the records would seek to submit that there is no injury of the kind that is produced as photographs in the appended to the petition. He would seek to produce certain
these are the complainant's photograph.
he would ಇದು against the complainant. ಅವ್ರಿಗೂ ಏನಾಗಿಲ್ಲ.
ಅಲ್ಲ, ಅವ್ರಿಗೂ ಎಲ್ಲ ಚುಚ್ಚಿದ್ದಾರೆ, ಬಟ್ ದೇರ್ ಆರ್ ಸಮ್ ಫೋಟೋಗ್ರಾಫ್. ಹೊಟ್ಟೆಗೆಲ್ಲ ಚುಚ್ಚಿದ್ದಾರೆ.
So ಏನ್ ಹೇಳ್ದೆ ಜೀವಯ್? Therefore, the learned additional SPP shall place on record the entire investigation papers and an affidavit from the hands of Dr. Nirup Raj MN, who is said to have examined the petitioner and rendered a certificate on 3/12/2025 that the wounds are grievous in nature and the examination so conducted by him. In that list the matter on 11th. List the matter on 10th February. 9th February in the fresh matters list.
My lords, in this matter, I may be permitted to file Wakala.
Senate counsel so and so undertakes to enter appearance for the complainant, registry to print the name of so and so as appearing for the complainant.
5.
Arrest.
ಇದರಲ್ಲಿ we have even grounds of arrest also.
ಅಲ್ಲ ಅದೊಂದು ಇಲ್ಲಿಗಲ್ ಅರೆಸ್ಟ್ ಅಂತ.
Illegal arrest ಏನಿಲ್ಲ, ಕರ್ಕೊಂಡ್ ಬಂದಿದ್ದಾರೆ, within time period they have been produced. There is no illegal arrest.
No, when do you transit period is not counted for.
No, it's not counted.
Then no, it is counted for illegal arrest. Transit period ಬಿಡಬೇಕು ಅಂತ
We
ಹೇಳಿದೆ.
have produced within that time.
Where if 24 hours ಅಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಬೇಕು.
24 hours.
When did you take him into custody?
We have taken him to custody on. We have taken him to custody on 17/1/2026. We have produced before the magistrate on 17/1/2026.
Where? ಇಲ್ಲೇನಾ? ಎಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರು?
Magistrate ಇಲ್ಲಿ ಬೆಂಗಳೂರಲ್ಲಿ.
17/1/2026.
Evening
At what time?
9:30 PM we have produced.
ಅರೆಸ್ಟ್ ಮಾಡಿದ್ದೆ ಯಾವಾಗ?
ಅರೆಸ್ಟ್ ಮಾಡಿದ ಬೆಳಗ್ಗೆ we have arrested it ಎಷ್ಟು ಗಂಟೆಗೆ ಅರೆಸ್ಟ್ ಮಾಡಿದ್ರು? 5:30 my lord.
ಬೆಳಗ್ಗೆ.
ಬೆಳಗ್ಗೆ.
Same day.
7:45 in the ಬೆಳಗ್ಗೆ.
Same day.
Same day.
And produced before the magistrate?
Magistrate at 9:30 PM.
My lord, the 7:40 they have arrested. And they have not served the notice under section 35(3). They went for the purpose of serving the notice, not for the arrest. And they have taken into custody, they have not produced, they have not given your lordship ground for arrest on same time. They have taken him to custody and produced before the court.
Magistrate ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಕ್ ಮುಂಚೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಗ್ರೌಂಡ್ಸ್ ಆಫ್ ಅರೆಸ್ಟ್?
ಇಲ್ಲ, ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ.
ಅಲ್ಲ, 7:40 AM ಗೆ ಕೊಡ್ಬೇಕು ಸ್ವಾಮಿ.
7:40 AM ಕೊಡ್ಬೇಕು ಅಂತ ಕಾನೂನಿಲ್ಲ. 2 hours before you are produced before the magistrate.
At 7:45 PM, 5:45 PM.
Grounds of arrest.
Grounds of arrest received by him at 5:45 PM on 17.
But they have arrested me, my lord, in the morning 7:40.
ಅರೆಸ್ಟ್ ಮಾಡಿದ್ರು, ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕಾಗಿರೋದು 24 hours ಅಲ್ಲಿ ಮಾಡ್ಬೇಕು.
ಮಾಡ್ಬೇಕು, ಬಟ್
ಈಗ 24 hours ಅಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. ಸೊ ಒಂದ್ ಗ್ರೌಂಡ್ ಹೋಯ್ತು.
ಹೋಗಿಲ್ಲ ಅವರು, ಅರೆಸ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಹೋಗಿಲ್ಲ, ನೋಟಿಸ್ ಕೊಡ್ಲಿಕ್ಕೆ ಹೋಗಿದ್ದಾರೆ. ನೋಟಿಸ್ ಕೊಟ್ಟು ಡೇಟು ಟೈಮು ಆ ಮಂತಿಗೆ ನೀವು ಹಾಜರಾಗ್ಬೇಕಂತ ಹೇಳಿ ಹೋಗಿದ್ದಾರೆ. ಇಫ್ he refused to come, then arrested. A 35 class C.
That is what is said here, that you did not cooperate with anything, so you are taken to custody.
Section 35 class C.
Yes sir, ಹೇಳಿ.
C ನಲ್ಲಿ ರೆಫ್ಯೂಸ್ ಮಾಡಿದ್ರು ಸಹ ಅರೆಸ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಪವರ್ ಇಲ್ಲ ಪೊಲೀಸ್ ಅವ್ರಿಗೆ.
ಈಗ where are the proceedings of the grounds of arrest on 22? You given this
The format al kottidare. Anyway, I've spoken to them a lot. The format will be removed, but it has been given and he signs it, his signature also been obtained
Why did you arrest him?
because he is not cooperated with investigation and
How
then
do you know
his
he's
ID
not, one
no,
minute, how do you know he's not cooperated with
no,
investigation?
he is evading arrest. We are searching for him for the past 20
ಈಗ
plus days.
35(3) ನೋಟಿಸ್ ಕೊಟ್ರಿ.
ಕೊಟ್ಟಿಲ್ಲ.
ಕೇಳ್ತಾ ಇದ್ದೆ. 35(3) ನೋಟಿಸ್ ಕೊಟ್ರಾ?
ಅಲ್ಲ ಅವ್ರು ಸಿಕ್ಲೇ ಇಲ್ಲ from past 20 days.
Where are those proceedings drawn? ಎಲ್ಲಿದೆ ಎಲ್ಲ?
I have to produce the CD, case diary.
Case diary ಕೊಡಿ. Most
Case-
important
I'll
is
place the
that.
case. I'll place
Get the
case.
case diary. We'll see whether he was, ಈಗ ಎಲ್ಲಿದ್ದೀರಾ?
ನಾನು ಜೈಲಲ್ಲಿ ಇದ್ದೀನಿ.
ಕಸ್ಟಡಿಯಲ್ಲಿ ಇದ್ದೀರಲ್ಲ?
ಹೌದು.
Yes.
ಅಲ್ಲ 14 days ಆಯ್ತು ಐ ಮೀನ್ ಜೈಲ್. ಸೆಕ್ಷನ್ 21.
ಬೇಲ್ ತಗೊಳ್ಳಿ.
My lord.
ಯಾಕೆ ಬೇಲ್ ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿಲ್ಲ.
ಯಾಕೆ? ಈ ಗ್ರೌಂಡ್ ಎಲ್ಲ ಹೇಳಿದ್ರೆ ಬೇಲೆ ಕೊಟ್ಬಿಡ್ತಾ ಇದ್ರಿ
I have filed memo before the trial court, my lord, saying that, my lord, the arrest itself is illegal. But the trial court passed the order in their favor, saying that legal, it is legal arrest.
ರಿಜೆಕ್ಟ್ ಮಾಡಿದಾರ?
Memo is filed.
We'll see. Tuesday, what is the offense?
318, 7 years ಒಳಗಡೆ ಇದೆ.
Fake website has been created.
Fake website.
Fake website.
ಅದೇ JBL ಅದೇನಾಯ್ತು?
same.
100% returns.
My lord, yes, your lordship, please kindly see, 100% legal document we have executed between the parties. Your lordship, please kindly see the page number 6. Partnership.
Let's see, but
Very
you
website
should-
is
ಅಲ್ಲ
illegal.
ಆಯ್ತು, you should follow the procedure ಅಷ್ಟೇನೆ.
ಅಲ್ಲ 1 month in they are searching. I'll place the
What is, when was the crime registered?
My lord, 25/12.
25/12. ಅರೆಸ್ಟ್ ಮಾಡಿದ್ದು ಯಾವತ್ತು?
17/1. 1 week ಆಯ್ತು.
ಅಲ್ಲಿವರೆಗೆ
ಅಲ್ಲಿವರೆಗೆ ಅವ್ರು ನೋಟಿಸೇ ಕೊಡ್ಲಿಲ್ಲ ನನಗೆ.
9/12 FIR ಆಗಿದೆ.
9/12 FIR ಆಗಿದೆ.
24/12. 24/12.
ಎಲ್ಲಿದೆ FIR?
My lord, 9/12 sir, page number 33. 9/12 ಗೆ
9/12/2025 ಸರ್ FIR.
9/12 ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ.
ಹಾ.
ಅವ್ರಿಗೆ ಅವತ್ತಿಂದ ಇವತ್ತುವರೆಗೆ
17/1 ವರೆಗೂ ನೀವು ಸಿಗ್ಲೇ ಇಲ್ಲ ಅವ್ರಿಗೆ.
ಅಲ್ಲ ನೋಟಿಸೇ ಕೊಟ್ಟಿಲ್ಲ. I was there in Kodlur itself. They have not made any effort. Your lordship, please kindly see. 7:40 ಬೆಳಿಗ್ಗೆ ನೋಟಿಸ್ ಕೊಡ್ಲಿಕ್ಕೆ ಯಾರಾದ್ರೂ ಹೋಗ್ತಾರೆ?
ಇದರಲ್ಲಿ ಫಸ್ಟ್ ನೋಟಿಸ್ ಯಾವತ್ತು?
I'll place the
ಕೇಸ್
CDR.
ಡೈರಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
I'll
ಮಾಡ್ಬಿಟ್ಟು ಯಾವತ್ತು ಫಸ್ಟ್ ಎಫರ್ಟ್ ಟು ಟ್ರ್ಯಾಕ್ ಹಿಮ್ ಡೌನ್.
ಅಲ್ಲ ಬೆಳಿಗ್ಗೆ 6 ಗಂಟೆಗೆ ಮನೆ ಒಳಗಡೆ ಹೋಗ್ಬಿಟ್ಟು ನೋಟಿಸ್ ಸರ್ವಿಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಹೋಗ್ತಾರೆ ಸ್ವಲ್ಪ ಯಾರಾದ್ರೂ? ಅರೆಸ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಹೋಗಿದ್ದಾರೆ ಅವರು.
ವಿಲ್ ಸಿ. ಮತ್ತೆ ನೀವು ಕ್ರೈಮ್ ಇಸ್ ರಿಜಿಸ್ಟರ್ಡ್, ನೀವು ಇಲ್ವೇ ಇಲ್ಲ.
ನೋಟಿಸ್ your lordship, please kindly see section 35C 3 4 5 6.
No, it is B is not available. There's no question of giving. I'll show you the entire case diaries, my lord, and
Case
also
diary
telephone diary,
Case
telephone
diary
TDR record, which indicates he has been roaming around in Andhra, Tamil Nadu, everywhere. It's not on one location.
ಕೊಡಿ
I'll
ಎಲ್ಲ
place
ಕೊಡಿ.
that.
We'll pass an order.
Yes.
List on Tuesday in fresh
My lord,
matters
your
list.
lordship, please kindly, since 1 week, my lord,
Forward, sir.
since-
Bail ತಗೊಳ್ಳಿ sir.
ಅಲ್ಲ 20 days I mean custody.
Your
Because
sir,
section
in a crime registered against you, you
Article
dodge the police.
21 and 22 guaranteed me, my lord, with regard to the personal liberty, my lord. My lord, without
We'll
any
order that, sir.
notice.
We'll order that, sir. No
Section 35
problem.
class
Your
C, my
personal
lord.
liberty ಏನ್ ತೊಂದರೆ
My
ಆಗಿದೆ
lord,
ನೋಡಿ.
if I fail to appear, I fail to comply the notice under section 35 class C, they have no right to arrest me.
We can issue a notice, ask him to come in spite of
They
which
came-
we can arrest
My
him.
lord,
Case
they-
diary
my
ನೋಡೋಣ,
lord,
wait,
since
sir.
four adjournment
Bail
they have taken, my
bail
lord.
reject ಆಗಿದೆ ತಾನೆ.
ಅಲ್ಲ, bail reject ಆಗಿಲ್ಲ. I have filed memo saying, my lord, that arrest itself is illegal.
Court has held it is legal.
Yes,
No problem. We will see.
my lord, section, if I fail
Again
to,
weekend ಬರ್ಬೇಕು ಆಚೆ ನೀವು. ಸೊ ಮಂಗಳವಾರದವರೆಗೂ ಸುಮ್ಮನೆ ಇರಿ.
ಅಲ್ಲ 20
Your
days.
constitutional rights we will answer. Yes.
ಅಲ್ಲ, my contention before your lordship is that
Yes, sir.
if I fail to comply the notice, my lord,
Yes, sir.
under section 35(6,
Let me look into the
but
case
the
diary.
police have absolutely no right,
One
power to arrest me.
One moment. 9/12 ರಿಜಿಸ್ಟರ್ ಆಗಿರೋ crime ಗೆ 17/1 ವರೆಗೂ you have dodged the police. If they have not, one minute, ಪೂರ್ತಿ ಹೇಳಕ್ ಬಿಡಿ. If they don't produce material that they have tried to track you or notice issue ಮಾಡಿ ಟ್ರೈ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಆಗಿಲ್ಲ ಅಂದ್ರೆ I will direct your release straight away.
My lord,
ಹೇಳಿದ್ನಲ್ಲ, I will direct your release straight away if they don't produce material.
fifth day,
But if they produce material,
fifth day, my lord, today.
ಪರವಾಗಿಲ್ಲ sir. If they produce material,
If they say, my lord, that they have made all efforts, my lord, first time they went to serve the notice to me.
that is why let them produce the case diary. Let
Like
them
our-
substantiate. Sir, it is not a crime that was registered yesterday and today you are not absconding. Allah 9/12 register ಆಗಿರೋ crime ಗೆ 17/1 ಗೆ arrest ಮಾಡಿದ್ದಾರೆ. So, wait, yes, let it come.
6 ಗಂಟೆಗೆ ಯಾರಾದ್ರೂ ಪೊಲೀಸರು ನೋಟಿಸ್ ಸರ್ವಿಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಹೋಗ್ತಾರೆ?
ಬೆಳಗ್ಗೆ 6 ಗಂಟೆಗೆ.
ಹೌದು. 35(3) ಬೆಳಿಗ್ಗೆ 6 ಗಂಟೆಗೆ ಅರೆಸ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೇನೆ ಹೋಗಿದ್ರು ಅವರು.
ಎಷ್ಟೊತ್ತು ನೋಟಿಸ್ ಸರ್ವ್ ಮಾಡಿರೋದು ನಿಮ್ಗೆ?
ಬೆಳಿಗ್ಗೆ 7 ಗಂಟೆ 40 ನಿಮಿಷ.
7:45 ಗೆ
7:45 ಬೆಳಿಗ್ಗೆ ಬರ್ತಾರೆ ಮನೆಯಲ್ಲಿ.
ಬೆಳಗ್ಗೆ ಬರ್ಬಾರ್ದಾ?
ಅಲ್ಲ ಬರ್ಬೇಕು, ಬೆಳಿಗ್ಗೆ ಅರೆಸ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬಂದಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಸ್ವಾಮಿ.
ನೋಡೋಣ.
ನೋಟಿಸ್ ಸರ್ವಿಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬಂದಿಲ್ಲ ಅವರು.
We'll see, sir. 40 days.
5th time, my lord, this
ಏನು?
time they have taken time.
So what, sir? So what?
I leave to this honorable.
Correct. We'll see the case there. If they substantiate that it is ಒಂದಂತೂ ಹೋಯ್ತಾ, ಇಲ್ಲಿಗ the 24 hours ಅಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. That's a different, that's over now. Now the only thing is 35(3) ಕೊಡಕ್ ಹೋದಾಗ has he not cooperated? When is the effort taken to serve the notice after registration of the crime?
My lord, 6:40 to 5:45 PM. They kept me illegal custody without any arrest.
We'll see, we'll answer, we'll check.
That's what it's record I have produced before your lordship.
Our record ಬರ್ಲಿ sir.
No, my record, their record itself I have produced, my lord.
Let them produce, sir. No problem. Yes.
To appear for the petitioner.
And that also, ಇದು ಅರೆಸ್ಟ್ ಮೆಮೊ ಡ್ರಾ ಮಾಡಿದ್ದೀರಾ? ಬೆಳಗ್ಗೆ ಅರೆಸ್ಟ್ ಮಾಡಿದಾಗ. And without arresting him, how did you bring him? All that you have to substantiate. Otherwise, result is liberty. Yes.
Petitioner. Subject matter is of a case and counter case, my lord. The petitioners here in my lord, as far back as on.
ಈಗ ಯಾಕೆ ಬೇಲ್ ಕೊಟ್ಟಿಲ್ವಾ?
Bail is in under consideration also,
Let
my
the
lord.
court consider bail.
Now what happens, only one submission, my lord, before this court. On 16/1/2026, my lord, 3 of these petitioners are brutally assaulted and they're all in the hospital as of this date, my lord. An FIR comes to be filed against this respondent number 2 before the jurisdictional Koramangala police. She's at large, my lord. What she does is on 22/1/2026, she walks into the Koramangala police station, my lord. The police do not arrest her.
How do you know she walks in?
She's she's the complainant against me, my lord. She's a complainant against me. Police do not arrest her. They entertain her complaint. Then this false FIR is now lodged against me. When I'm in my deathbed, my lord, the petitioner number 2 has lost his eyesight. How is that permissible, my lord?
Jagdish sir, in the counter case, in the case registered by them, why nothing has happened? You get the information. And instead of taking the person into custody, you permitted another crime to be registered. That is also illegal. The petitioner is before petitioners accused 1 to 7, 8 are before this court calling in question the registration of a crime against these petitioners in crime number 37 of 2026. A little history to the registration of the crime against these petitioners is a squabble that happens between the petitioners and the complainant, in which the second petitioner is brutally assaulted and injured and is admitted to the hospital as he has lost his eyesight. Immediately thereon, on 22/1/2026, a crime is registered in crime number 28 of 2026 against the complainant and others who had indulged in such assault. No investigation takes place or no arrest takes place of those persons, though the offense alleged was the ones punishable under section 115, 74, 75 and 79 of 79 of the BNS. However, on 4 days later, 7 days later, the complainant registers a complaint before the very same police station for identical offences. It is ununderstandable as to how the police did not take action against the complainant and others despite the offense under section 74 and 79 of the BNS and
109 also.
and 109
Attempt to murder. It was subsequently included in the remand.
109 attempt to murder, and have permitted to freely enter the police station and register the crime. In that light, there shall be an interim order of stay of all investigation in crime number 37 of 2026 till the learned additional SPP would secure instructions and make submissions as to why nothing has happened in crime number 37 of 2026, but the petitioners are now hounded in crime number 37 ಅಲ್ಲ ಅದ್ಯಾವುದು
28.
ನೀವು 28 in 2020, crime number 28 of 2026, but are hounded in crime number 37 of 2026. Yes, list the matter on for 12th February.
I may be permitted to seek hand delivery.
1 and 2 are in JC.
ಅವ್ರನ್ನ ಹಾಕ್ಬೇಕಾಗಿತ್ತು. 307 ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ರು ಏನ್ ಮಾಡಿಲ್ಲ, ಒಂದ್ ವಾರ ಆದ್ಮೇಲೆ ಆರಾಮಾಗಿ ಪೊಲೀಸ್
In fact, my lord,
ಸ್ಟೇಷನ್.
all the three petitioners, two petitioners have lost eyesight. One person is unable to walk.
Yes,
Great.
police are getting partisan. Instances are appearing every day now.
My lord, it's-
Externment, Jagdish.
Your lordship may remand it back to the officer, my lord. Since they have filed their objections,
Nothing is considered.
they need not, only the officer has to
ಅಲ್ಲಿ
consider.
ಕನ್ಸಿಡರ್ ಮಾಡಿ ಬರೀಬೇಕಷ್ಟೇನೆ. Limited purpose like how Justice Suraj Saab sent it.
Not only that, my lord.
Not only ilve ಇಲ್ಲ, because everything is considered by him.
No, I'll be able to, my lord. I'm not going to say anything, my lord, but.
ಬೇರೆ petitioner ಆಗಿ sir, this very petitioner.
What I'm saying, it is still covered by your lordship judgment.
No, no, sir.
It is.
He has considered
It is.
my judgment, distinguished it.
Give me 1 minute, my lord.
No, sir.
Give me a minute, my lord, it is covered. Your lordship, my lord, lordship felt about the proximity, show cause notice.
ಅಯ್ಯೋ ಎಲ್ಲ ಸೂರಜ್ ಸಾಹೇಬ್ರು ಎಲ್ಲ ಬರ್ದಿದ್ದಾರೆ.
ಇಲ್ಲ,
No,
ಅದೇ
no,
ನಾನು
I'm
ಹೇಳ್ತಾ
not going
ಇರೋದು.
to
My lord, take,
distinguish
your
it.
lordship, kindly take 1 minute, my lord. Kindly look at, my lord, page number 75, 117, that's all. Lord, I'm not saying your lord, on the remand, my lord, kindly look at, my lord, 75. Kindly look at 75.
Yes, sir.
10.3. Regard the, it has laid upon decision of Sachin case and the contents of
Oh,
documents.
those are my judgments.
Yes, my lord. Contents of documents are not furnished. And there is no acknowledgement. That's about the report being furnished along with the police. Then can you look at 117, my lord? Page 117. My lord, this is paragraph 10.4.
Yes,
Result
sir.
of the said judgment, Sachin case does not indicate that there is no, in as much as that decision was one relating service of notice. I am not on that, my lord, service of notice. I am on a show cause notice, objection being considered, and ultimately what
Taranath
lordship.
sir, period. I'm not going to distinguish this. It is not in consonance with what Justice Suraj has held. I will send it back.
True.
Because he has already
But what I'm
distinguished my
saying,
judgment. This is not a race
The
here.
lordship yesterday said Sachin judgment is overruled.
Overruled ಪ್ರಶ್ನೆ ಅಲ್ಲ. He
It
has
is
distinguished it.
Distinguished, my lord, it's still binding.
No,
It's still binding.
no, no. Sir. We are not running races here with the other judges.
No, we are not
Then,
saying, my
no,
lord,
what the coordinate bench has held, I am going to follow in letter and spirit. It is not in consonance with that, I will send it back. That's all. Ouring ಬರ್ದಿದ್ದಾರೆ, ಇವ್ರಿಂಗ್ ಬರ್ದಿದ್ದಾರೆ. No, nothing doing. It's a coordinate bench.
no, Kyle is your lordship judgment, my lord. I am saying your lordship judge is very clear about.
That is considered and distinguished. In fact, pursuant to my judgment, government has issued a circular also implementing that. That is not brought to the notice of the court while answering this. Circular issue ಮಾಡಿದಾರೆ ಇಲ್ಲ. Externment ಹೆಂಗ್ ಮಾಡ್ಬೇಕು, ಯಾವಾಗ ಮಾಡ್ಬೇಕು, ಏನ್ ಕೊಡ್ಬೇಕು, circular issue ಮಾಡಿದ್ದಾರೆ government. Government has not brought it to the notice of the coordinate bench. But I will not distinguish the judgment of the coordinate.
No, I am not saying, my lord. Kyle, one praise in your judgment, my lord, your lordship judgment.
Correct, sir.
Show cause not issued in the petitioners appears to be farce.
I know, sir.
And my lord, issued only for the purpose of making out a
ಅದು
case.
election, sir. Election time.
Then 45, my lord, your lordship leading with the proximity. What is the live link between the crime alleged, my lord? What is the object sought to be achieved?
See,
And also, my lord,
there are directions issued by Justice Suraj.
your
I will
lordship-
only follow what Suraj Govindaraj has done. It is not in consonance with that, we'll send it back.
Lord, just Suraj was Govindaraj was dealing with only certain issues.
Oh, no, sir.
These issues I am raising are different.
It is externment. You are also on externment orders. It is not in consonance with, because your objections are not considered, I will send it back.
That's true, my lord. That is true. But, my lord, right from 12/5 till today, 7 months, my lord, lapsed 8 months, nothing has happened.
ಏನ್ ಮಾಡೋದು?
Nothing has happened.
Yeah, you should have
Where is
moved.
where is the threat, my
I
lord?
will direct order to be passed in 15 days after considering your objections.
ಅಲ್ಲ ಹಾಗಲ್ಲ, ಇವತ್ತಿಂದ ಅಲ್ಲಿಂದ ಇವತ್ತಿನವರೆಗೆ ಏನೂ ಆಗಿಲ್ಲ. Nothing has happened, my lord. If there is harm and imminent danger, my lord, present danger, there should have been something.
ನೀವು ಎಲ್ಲಿದ್ದೀರಾ ಈಗ? ಎಕ್ಸ್ಟರ್ನ್ಡ್ ಪ್ಲೇಸ್ ಅಲ್ಲಿ ಇದ್ದೀರಾ ನಿಮ್ಮ ಒರಿಜಿನಲ್ ಪ್ಲೇಸ್ ಅಲ್ಲಿ ಇದ್ದೀರಾ?
Absconding.
ನಾನು ಎಬ್ಸ್ಕೊಂಡಿಲ್ಲ. ಎಕ್ಸ್ಟರ್ನ್
ಅಲ್ಲ ಎಲ್ಲಿದ್ದೀರಾ ಈಗ?
my lord,
ನೈಜೀರಿಯಲ್ಲಿ ಇದ್ದೀರಾ?
that is obviously, my lord, if such things are there, my lord, it's
Hello,
difficult for me to answer where he will be.
Correct, alva?
No, I do not know.
Yes. We'll send it back.
Yes.
The petitioner is before this court seeking the following prayer. Heard the learned senior counsel Tarnath Pujari appearing for the petitioner along with Balkrishna MR and the learned additional SPP for the state. The backdrop of the issue need not be reiterated all over again. It would suffice if the order passed in writ petition 30021 of 2025 disposed on 17th November 2025 is paraphrased as facts obtaining to the case at hand. The coordinate bench concerning this very petitioner challenging the very externment order had in extenso considered the law and directed the respondent to comply with and remitted the matter back to the respondent state only for the limited purpose of passing reasoned order indicating the provision under which the said order had been passed and complying with the requirements thereof. The order passed by the coordinate bench reads as follows. Madam, page 144, sir. Pursuant to the said order, a show cause notice comes to be issued to the petitioner, for which the petitioner submits an elaborate reply. Claiming to be considering the reply, the present order is passed. A perusal at the present order would, the perusal at the impugned order in the subject petition would clearly indicate that non-application of mind for the reason that all the crimes that are narrated, all the crimes that are found in the show cause notice are replicated in the impugned order without considering the objections filed by the petitioner. The objections were to this court that most of the crimes that are indicated in the order have all ended in acquittal or otherwise. Therefore, these factors ought to have been considered as directed by the coordinate bench. In the light of the order projecting non-application of mind, the inevitable conclusion that can be arrived at now at this juncture in this petition is the matter being remitted back to the hands of the concerned authority who has now passed the impugned order to pass orders in strict consonance with what the coordinate bench held, which should reflect application of mind and reasons rendered thereon. For the aforesaid reason, the order impugned shall stand obliterated again for the limited purpose of the competent of the area of the authority of the assistant commissioner of the assistant commissioner second respondent to pass necessary orders in accordance with law, bearing in mind the observations made in the course of the order which would reflect application of mind. The order shall be passed within 3 weeks from the date of receipt of the copy of this order. In the light of the matter being remitted, 1 week.
4 week ಕೊಟ್ಟರೆ ಒಳ್ಳೆದು, ಅರ್ಜೆಂಟ್ ಮಾಡ್ತಾರೆ.
4 ವಾರ ಯಾಕೆ? ನಿಮಗೇನು ತೊಂದರೆ ಇಲ್ಲ.
ನನ್ನ application is there, my lord, my application is pending.
No, pleadings have been completed.
1 minute. In the light of the matter being remitted to the hands of the assistant commissioner only to pass an order on the objections filed by the considering the objections filed by the petitioner, hearing the petitioner all over again would not be required. Therefore, the order shall be passed within 3 weeks from the date of receipt of the copy of the order, if not earlier, ordered accordingly. All other contentions would remain open to the petitioner.
My application on section 58 is pending.
What application, sir?
My lord, I have a right, my lord, to examine the witness in the sense, my lord, 58 is a procedural aspect to covering 55. It's a procedural aspect, my lord. It should be read with 55 to 58.
That is not accepted.
Hello.
In accordance with law andidine, yes. Ad judgment illa andidre, there are plethora of my judgments where I've held externment is a fundamental right. I mean, like rate of movement is a fundamental right. You have to curtail it. They should know why you are curtailing it. But that judgment now takes away that.
It doesn't take away, it doesn't take away, my lord. With great respect, I beg to differ with you, my lord. Your lordship is difficult to overcome. It is not so, my lord.
It is already, because I have subordinate bench.
No, consistently you are holding that, my lord.
I have held, I told you, see, LOC, externment. Externment orders are passed for the asking at the time of elections. You don't like his face, he's a force in the election, send him away. That is why externment orders were being passed during the elections.
Yes, ma'am. In this case, not
So
only.
what I held was, movement is a fundamental right. So you have to serve a copy, you have to give the reasons why you are doing it, and also hear the person who is to be externed in terms of section 58. That is what I had held. But all that is now watered down, I want.
This is an externment proceeding. My lord, repeatedly, my lord, is being demanded. My lord, we are at the hands of the police.
No, ಅದನ್ನ challenge
Mercy.
You should have division bench ಹೋಗಿ ಮಾಡ್ಕೊ. Division bench ಇದೇನು 482 ನಾ?
Please, my lord.
482 ನಾ?
It's
482.
226.
My lord,
226.
it is not, it's 226. Your lordship judgment is still holding the field, my lord. That's what I am submitting.
Sachin ಒಂದೇ ಅಲ್ಲ. I have written so many.
Yes, my lord, I have seen it.
Circular, have you seen the circular of the government? ನೀವೇ ಅಪಿಯರ್ ಆಗಿದ್ದಲ್ಲ.
But Supreme Court judgment, your lordship followed
All right, ನೀವೇ ಅಪಿಯರ್ ಆಗಿದ್ದಲ್ವಾ ಅಲ್ಲಿ?
Your lordship followed Deepak Donge.
Correct, sir. Deepak is considered by the coordinate bench. It's considered. In fact, all 1977 he has considered all the judgments. It's a lengthy order. It's a well-considered order.
I don't really think so.
It's all right.
Yes.
You may say so time.
I'm sorry.
Yes, sir.
Number 8.
Please.
Lordship, I pray for short of two petitions, my lord. The first being, my lord.
Okay, still number?
8. Sir,
DB Act.
DB Act ಬೇಡ, ಇನ್ನೊಂದಿದೆ ಸೆಕೆಂಡ್ ಪೆಟಿಷನ್. ಅದು ಇದು ಬೇರೆ 12,157 ಹೇರ್ ಮಾಡಿದ್ಮೇಲೆ DB Act.
Again problem in 498.
The petition before, the petitions are the daughter and the mother, my lord. MC petition came to be filed, criminal petition came to be filed before the Honorable Court, quashed the proceedings because the parties have entered into a compromise petition, my lord. Subsequently, my lord, the husband used this compromise petition as a device to overcome the criminal proceedings, and thereafter, my lord, he did not lead a life. He went away, and he abandoned.
Compromise was reunion.
Yes, reunion was there, and he has agreed to pay the maintenance. He has agreed to take care of.
If it is reunion, where is the question of maintenance, sir?
He has agreed. No, he was not paying the maintenance. That's what the agreement, my lord.
Reunion na maintenance.
Reunion.
Reunion al maintenance.
ಹೌದು ಬರ್ದಿದ್ದಾರೆ, ಕಾಂಪ್ರಮೈಸ್ ಅಲ್ಲಿ ಬರ್ತಿದ್ದಾರೆ ಅದು.
ಸರಿ, ಆಮೇಲೆ
maintenance means to pay the maintenance to children towards the education and etc. That has been mentioned, my lord.
ಸರಿ, ಈಗ reunion ಆಗ್ಲಿಲ್ವಾ?
Reunion ಆಗಲಿ, he has himself abandoned, and he has induced the petitioner to sell the property and taken the property, and he has swallowed the money, and he has gone now.
We'll revive the criminal proceedings.
Please.
ಅಷ್ಟೇ. 498 ಇದೆಯಾ?
498 ಇದೆ, ಮತ್ತೆ
ಎಲ್ಲ revive ಮಾಡ್ಬೇಡ.
ಎಲ್ಲ ರಿವೈವ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಅಷ್ಟೇ.
We'll revive everything, sir. And we'll direct the police to take you into custody.
Monday, take it on Monday or Tuesday, Lord.
Monday or Tuesday, I will take, not a problem, but that will be the order. If you have breached the compromise and hoodwinked the wife and children, you better be inside.
It is not breach. We filed the objection, but Monday ತೊಗೊಂಡೆ, Lord.
You reunion ಆಗ್ಲಿಲ್ವಾ?
Reunion ಆಗಿದ್ದಾರೆ, but there's some, we filed the objection also. They were together for some time. ಎಲ್ಲ ಚೆನ್ನಾಗಿತ್ತು, then later something has happened. So senior ಬರ್ತಾರೆ, Lord.
ಆಯ್ತು ಸರ್, ಅಂದ್ರೆ next Tuesday admission. Just the matter on Tuesday, the next for admission. It's made clear no further adjournment will be granted in the matter.
Great, please.
Yes, next.
9.
ನೋಡಿ ಇದರಲ್ಲಿ
10 ಲಕ್ಷ
10 ಲಕ್ಷ 5 ಲಕ್ಷ ಅಂತ ಹೇಳಿದ್ರೆ ಅದರಲ್ಲಿ ಏನಾಗಿದೆ?
Ready with 5 lakh, my lord.
Impugned order itself is passed in 21. Before the trial court, he was ready to pay 7 lakhs. At least ಒಂದು 750 ಕೊಟ್ಬಿಡ್ಲಿ, ಮುಗಿಸ್ಬಿಡೋಣ. I also convinced my client. 5 ವರ್ಷ ಆಗೋಗಿದೆ ಇಲ್ಲಿ.
ನೋಡಿ, that should be the thing.
My lord,
ಇವತ್ತೊಂದು
ready with, my lord, because he's also undergone heart surgery, and I'll have to take instruction.
ಅಲ್ಲ, ಈ 2.5 ಲಕ್ಷ ಜಾಸ್ತಿ ಮಾಡಿದ್ರೆ ಅಟ್ಯಾಕ್ ಏನಾಗಲ್ಲ.
ಇನ್ನು ಸ್ವಲ್ಪ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ. I will be caused. There was a compromise at the
ಇಲ್ಲ
first
ಇದಾರಾ?
instance and we have paid. Maga bandira, he was.
ಅಲ್ಲ ಅಟ್ ಲೀಸ್ಟ್ ಟ್ರಯಲ್ ಕೋರ್ಟಲ್ಲಿ ಏನ್ ಅಗ್ರಿ ಅದನ್ನಾದ್ರೂ ಕೊಡ್ಲಿ. ನಾನು ಐ ವಿಲ್ ಕನ್ವಿನ್ಸ್ ಹಿಮ್. ಅದು ಕೊಟ್ಟಿಲ್ಲ ಅಂತಂದ್ರೆ ಆಫ್ಟರ್ 5 years.
ಟ್ರಯಲ್ ಕೋರ್ಟಲ್ಲಿ 1.5 ಲಕ್ಷ ಡಿಡಿ ತಗೊಂಡೋಗಿ
1.5 ಲಕ್ಷ
1.5 ಲಕ್ಷಕ್ಕೆ
ಡಿಡಿ ರೆಫ್ಯೂಸ್ ಮಾಡಿ.
ಅಲ್ಲ ಈಗ ಏನ್ ಸೆಟಲ್ಮೆಂಟ್ ಆಗ್ಲಿಲ್ವಾ?
ಅಲ್ಲ
ಕ್ರೆಡಿಟ್ಸ್ ಮೇಲೆ ಬೇಕಾದ್ರೆ ಬರೆಯೋಣ ಅಷ್ಟೇ.
My lord, 5 lakh will, what, we'll.
ಚೆಕ್ ಅಮೌಂಟ್ ಎಷ್ಟು ಸರ್?
35 ಲಕ್ಷ ಚೆಕ್
Check
ಅಮೌಂಟ್.
amount 35
25 ಲಕ್ಷ
25
ಕೊಟ್ಟಿದ್ದಾರೆ.
25 we have
10
paid.
ಕೊಡ್ಬೇಕಾ?
ಇನ್ನು 10 ಕೊಡಬೇಕು.
ಐದಕ್ಕೆ last occasion, my lord had indicated.
ಅಲ್ಲಲ್ಲ,
we got the
your
money.
lordship suggested 5 ಲಕ್ಷ ಅಂತ ನಾನು ಕೇಳ್ತೀನಿ ಅಂತ ಹೇಳಿದೆ. Then when I asked my client, he said ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ 7 ಲಕ್ಷ ಕೊಡೋಕ್ ರೆಡಿ ಇದ್ರು ಅವರು, ನಾನು ಇಸ್ಕೊಂಡಿರ್ಲಿಲ್ಲ.
ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ದಾರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್?
ಇಲ್ಲ ಮಾಡಿರ್ಲಿಲ್ಲ.
ಮತ್ತೆ
I said ಆಯ್ತು ಈಗ ಅಷ್ಟಾದ್ರೂ ಕೊಟ್ರೆ ನಾನು ಇಲ್ಲ ಕನ್ವಿನ್ಸ್ ಮೈ ಕ್ಲೈಂಟ್.
Settlement.
5 ವರ್ಷಕ್ಕೆ ಇಂಟ್ರೆಸ್ಟ್ ಆಗಿದ್ರೆ ಇದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಆಗುತ್ತೆ.
2 weeks, because he is recovering. Just 2 days ago he came back.
ಆಗಲಿ.
List the matter on 17th February. ಅಷ್ಟಲ್ಲೇ ಮಾಡಿ
20 or 21.
ಆಯ್ತು, ನೋ ಪ್ರಾಬ್ಲಮ್. ಏನ್ ಸಿಟ್ಟಿಂಗ್ ಚೇಂಜ್ ಆಗಲ್ಲ.
Manjunath is not well, so he will come by the time.
List the matter on 20th.
ಆಗ್ಬೋದು.
Heard so and so, list on 20th. Friday ಅಲ್ಲ ಮೇಡಮ್?
Number 10.
Notes, this is the departmental
ಸೆವೆನೇನಾ
inquiry.
ಏನಿದು?
The departmental inquiry, exoneration in departmental.
2026 SSC online SC page 13.
ಅದು ಎರಡು ನೋಡಿದ್ದೀನಿ. I have gone through both. I have made a detailed synopsis, my lords.
ಅದು ಸಿನಾಪ್ಸಿಸ್ ಮಾಡೋದಕ್ಕಿಂತ ನಿಮ್ಮ ವಿಟ್ನೆಸಸ್ ಯಾರ್ಯಾರು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದಾರೆ ಚಾರ್ಟ್ ಮಾಡಿ. ಫಸ್ಟ್ ದಟ್ ಇಸ್ ಇಂಪಾರ್ಟೆಂಟ್.
All the 3 witnesses have been examined.
ಕ್ರಿಮಿನಲ್ ಟ್ರಯಲ್ ಅಲ್ಲಿ ಯಾರು ಇದ್ರಲ್ಲಿ ಯಾರು ಕೊಡಿ
I
ಸರ್.
brought a copy also.
ಗಿವ್ ಇಟ್.
Give them a copy. Good.
Where is the list?
Only 3, my lords.
List
List is
departmental
there in the departmental inquiry only.
ಕ್ರಿಮಿನಲ್ ಟ್ರಯಲ್.
ಕ್ರಿಮಿನಲ್ ಟ್ರಯಲ್ ಆಗ್ಲಿಲ್ಲ, HPC ಅಷ್ಟೇ. ಅದು ಆವಾಗ ಎಕ್ಸಾನರೇಷನ್ ಆಗಿರ್ಲಿಲ್ಲ. ಆಫ್ಟರ್ ಫ್ರೇಮಿಂಗ್, ಓನ್ಲಿ ಫ್ರೇಮಿಂಗ್ ದ ಚಾರ್ಜ್, HPC has been, I have been exonerated.
ಬಿಫೋರ್ ಚಾರ್ಜ್ ಅಲ್ಲಿ ಇದೆಯಾ?
ಇತ್ತು.
ಈಗ ಏನಾಗಿದೆ?
ಇಲ್ಲ, ಈಗ ಓನ್ಲಿ ಚಾರ್ಜ್ ವಾಸ್ ಫ್ರೇಮ್ಡ್ ಬಿಕಾಸ್ at that time exoneration was not there.
Right, now charge is framed and trial is on.
No charge, trial is on.
Charge frame ಆಗಿಲ್ವಾ ಇನ್ನು?
Only charge frame ಆಗಿದೆ.
Stay is there.
Entry ಮಾಡಿದೆ.
Please.
FDT ಅಷ್ಟೇ ಇದೆ. Only charge was framed, my lords, at that time.
One moment. ಅದೇ ಆಶು ಫಾಲೋ ಮಾಡಿ.
Please, Ashu follow. Now my lord.
Oh, entry mode is spread for up. Yes sir.
Your lordship may kindly see. I'm aware that charge at the time of framing charge, the departmental inquiry exoneration was not there. Not only departmental inquiry has been conducted, but even Lokayukta accepted the departmental inquiry findings conducted by the department. So now I have virtually 2 exonerations. One is by the department. Second is by the Lokayukta. Now government has also accepted it. In normal case, my lords, department conducts inquiry and government accepts it. In my case, not only department conducted the inquiry, whole inquiry report was given to Lokayukta. And Upalokayukta, after having seen that, concurred with the findings, and again they sent to government because government has referred them.
ಎಷ್ಟು ಅಮೌಂಟ್? Failed trap.
15,000 ರೂಪಾಯಿ.
Failed trap. Successful.
Successful trap.
Who took the money?
She only one accused.
Only one accused.
Only one accused.
So all tests were done?
Done. But everyone, not even one person has supported.
If a trap is laid against, you answer it. If a trap is laid against a government servant and trap only he is caught red-handed, like how the petitioner is caught red-handed. So money, there is acceptance.
Obliged.
No problem. Without demand, acceptance, section 20 kicks in, that presumption, that is demand is there, acceptance is there. In this case, how a departmental inquiry can be conducted and said that there was no demand and acceptance? How is?
No, your lordship may kindly.
How is it, you tell me? If cases where somebody else has taken in somebody else's name, ಯಾರ್ದೋ ಹೆಸರಲ್ಲಿ ತಗೊಂಡು ಇವ್ರ ಹೆಸರಲ್ಲಿ ತಗೊಂತಾ ಇದೀವಿ ಅಂತಂದ್ರೆ there is some meaning. You are caught red-handed.
Your lordship may kindly see, that is only an allegation.
Were you not caught red-handed?
No, no, that is an allegation. but-
Allegation Allah, your caught red-handed is not an allegation.
No, no,
It is a step beyond allegation.
no. Your
No,
lordship may
no.
kindly see the report, enquiry report as well as witnesses.
This is exactly the point. Where does criminal proceedings be interdicted in a departmental inquiry where demand and acceptance is again gone into when it has to be under the Prevention of Corruption Act?
No, your lordship may kindly see, no, that's what they have written. I mean, your lordship may kindly see. there
Trial
are-
ಆಗಿದ್ರೆ ಇಲ್ಲಿ same witnesses ಮಾಡಿದ್ರೆ ಆವಾಗ we can do something. We can't interdict the trial.
Your
unless
lordship may
happens.
oblige it. Now, what has happened in Ashu's case, my lords? Ashu's case is same, identity, department were different. CVC's finding was verbatim accepted in the criminal proceedings. And entities were different. Here, in Chandrasekhar's case, your lordship may kindly see, entire case, I have made a clear-cut distinction between both. Your lordship may kindly see, in that case, in Manjunath's case and Chandrasekhar's case are concerned, they have completely forgotten a fact that different.
Who has forgotten? Supreme Court.
Supreme Court.
Oh.
Because they have not mentioned. Your lordship
So
may
you
kind-
mean to say Supreme Court has forgotten
No,
and non-very
nobody has brought to their notice. That is what per incurem is all about. What is substantial, my lords? I have written, I mean,
Correct.
your lordship may kindly see.
I'll have to
that- I
repeat.
mean,
If I accept your statement, I'll have to repeat, Northeast is a beautiful place.
No, not. Your lordship may kindly see. What is, your lordship may kindly see, there is a different, there is a specific finding. I may be permitted to read the judgment of Chandrasekhar.
I have read, sir.
Different, what they have gone on, two aspects.
See, Ashu followed Radheshyam Kejriwal,
Obliged,
Ajay Kumar Tyagi,
obliged,
PS Raja.
obliged.
Chandrasekhar does not refer to Ashu, but follows Radheshyam Kejriwal, Ajay Kumar Tyagi, PS Raja.
Obliged,
Yes.
obliged,
All of them were three-judge bench decisions.
Obliged.
Ashu was also three-judge.
obliged.
So, not considering a subsequent three-judge bench.
Your lordship may kindly see, what is stated in that case? What is the opinion of Honorable Apex Court? Apex Court categorically says entities were different. In Radhesham case, entities are same. In this case, they say entities are different.
One more thing is, in all those cases, trial had progressed.
Obliged,
When did it go to the Supreme Court? When
obliged.
did it go? As a criminal appeal, not under 482.
No,
No,
under 482. Your lordship may kindly see. It is discharged. T. Manjunath was a revision petition.
D. Manjunath alla, Ashu na ಹೇಳ್ತಿರೋದು. Ashu,
Ashu.
Radhesham, all of them went after the orders of either acquittal or conviction.
No, Ashu's case, there was no conviction or acquittal. Ashu's case was at the stage of commencement of the trial like mine. Your lordship may kindly see the factual matrix. They have explained in detail. Then even specifically, it has been specifically stated in
See,
facts
in
itself.
Chandrasekhar, the apex court delineates, these are the witnesses in the departmental inquiry. These are the witnesses in the criminal trial. They are totally different. That's what Supreme
Yes,
Court has said.
I have gone through, my lords, as your lordship has gone through. There, only on two grounds they did not agree. The ground number one was entities are different. And in Radhesham Agarwal, the Supreme Court has said, the court has said, and when entities are same and in hierarchy, the specific word used is in hierarchy, when a superior officer overrules the order of a subordinate, in such cases, they said Radhesham's Agarwal's case is concerned, that has been taken into consideration. But they say, in this case, Jalamandal is a different entity, ACB is a different entity, therefore it cannot be accepted. So lordship may kindly.
If you had not been caught red-handed, I would have examined everything. But you're caught red-handed. Quantum is not the issue. But a public servant being caught
quantum
red-handed, receiving money, will not receive any refuge in this court.
Your lordship may kindly say, in the even now, we are on the simple point. Whether what is material, whether what is in the charge sheet is the material, or on oath, this is the case
I
where
fail to
examination.
understand. Disproportionate assets are there because
How?
records
That
are
I
there,
agree. That I-
income tax ಕೊಟ್ಟಿರ್ತಾರೆ, you can
Obliged.
departmental inquiry. 7A trapoli, when you are caught, how is a departmental inquiry conducted on demand and acceptance when you're caught red-handed and exonerated?
That's why I'm making a submission. It is only an allegation, my lords. What is evidence or what is material? After evidence.
ಯಾಕೆ ತಗೊಂಡ್ರಿ?
ತಗೊಳ್ಳೇ ಇಲ್ಲ.
ಮತ್ತೆ ನೀವು ತಾನೇ ತಗೊಂಡಿದ್ದು. red-handed, caught red-handed
Their
ಏನರ್ಥ?
allegation. That is their allegation. What has come out, your lordship may kindly see it. That's what even the.
Where is Predicate?
Ayo.
Panchnama?
Lord, FSL report is positive, my lord.
Your
Even
lordship may
voice
kindly
records are
see.
sent to FSL. Lord, opinion is there. They have not even produced the entire charge sheet. Lord, and my lord, even the phenolphthalein test was conducted. That is also, my lord,
Yes,
turned positive. My lord, this
I
is
am
not
not
matter of trial, my
Where
lord.
is the
Let them
question of
file
allegation?
No,
discharge.
your lordship may kindly see.
This is not the question of allegation with presumption in section 20.
No, your lordship may kindly see what has transferred in the evidence which is recorded on oath. On oath, when we have to chance when 482
It's
can
a
be.
matter of trial. I'm not saying you're guilty, but you should be tried.
No, your lordship may kindly see trial. I would have faced happily, my lords. But because even now, your lordship may because all these materials are not placed before the court earlier. Your lordship may kindly see under section 5 of the Karnataka Departmental Enquiries Act, all the proceedings before the enquiry officer is a judicial proceeding. In my proceeding also, oath has been administered. So it is a judicial proceeding. When in a judicial proceedings,
A
my lords,
departmental inquiry is a quasi-judicial proceeding, not a judicial proceeding. Anything else?
your lordship may kindly
It's a
see.
quasi-judicial proceeding, it's not a judicial proceeding.
Your lordship may, that is in the departmental enquiries where oath is not administered, it is quasi-judicial. When, my lords, oath is administered, what is judicial proceeding, my lords? Any proceeding, the definition is given. What is the meaning of judicial proceeding? The meaning of judicial proceeding is a proceeding wherein oath is administered is a judicial proceeding. That is the definition given to judicial proceeding. Even I have written in my synopsis that also, my lords.
Normally, my lord, government.
But normally I would have not argued. Lords.
We'll see, this requires an answer, we'll answer.
Section 80, and one more thing is there on section 80 also. My lords, there is a presumption about anything conducted in departmental inquiry. That is, if the certified copy of a judicial proceeding is produced in any other proceeding, my lords, prima facie any certified copy or a content of that copy has to be accepted at its face value. Your lordship may kindly see now the proceedings which I have faced is also departmental proceedings. Section 80. Your lordship may kindly see the proceedings which I have faced is departmental proceedings, wherein proceedings is conducted as a judicial proceeding. In criminal proceeding is also same thing. When both are same, my lords, in both, because perjury, I have got, your lordship may kindly say, I can, if and your lordship can ask some question if I am unable to answer, because
no problem.
no,
You answer,
then
you argue,
then
sir.
it's fine, my lords. I will
Why are you
accept
telling I
it.
should ask
But
questions?
your lordship, I will be happy if the court is asking me any questions. See, my humble submission. I'm aware, my lords. Your lordships are trying to say that once the apex court says something, that too on referring to a particular judgment, this court has to follow it. But my humble submission before this honorable court, 3 important points are not taken into consideration
By the apex court.
by the apex court.
All right.
Because number 1 is judicial proceeding, no distinct, because in Manjunath's case, the lordships have specifically said in other proceeding and as well as in Chandrasekhar's case, in criminal proceedings, there is a possibility of witness giving some other set of evidences because in criminal proceedings, they are exposed to perjury. Therefore, there is a possibility of these witnesses coming out with a different set of facts. Therefore, their lordships have said That is also one of the circumstances which has to be taken into consideration. But in this case, my lords, what inquiry I have faced is a judicial proceeding. Therefore, yes, oath is administered. Therefore, I have produced those copies also, wherein oath is administered. And second, it is conducted under Karnataka Departmental Inquiries Act specifically. And third, any proceedings, my lords, before Karnataka Lokayukta under section 11 of the act is a judicial proceeding. They are open to 193 IPC also. And as well in Karnataka Departmental Proceedings Act also, any witness gives a contradictory evidence, they are exposed to section 193 perjury.
Procedure is under 14A of KCS-CCA.
Only procedure, my lords. But proceedings conducted are under 11. Any proceedings, the word used is any proceedings conducted before Upalokayukta or Lokayukta is a judicial proceeding. In this case, my lords, Upalokayukta entrusts the investigation to them, and it is continuation of the same proceeding. It is not a different
Lokayukta
proceeding.
does not hold inquiry. It is DRE 5 idralli 4.
3.
DRE 3, yes.
Closure proceedings. And it has been accepted by Upalokayukta. They accept it. And then government also accepts it.
No, we'll
And
answer.
second is
This requires an answer because there's so many petitions pending. We'll
some
answer.
other day.
Third ಏನು ಹೇಳಿದ್ರಲ್ಲ ಹೇಳಿ. Some other day ಇಲ್ಲ ಅಷ್ಟೇ ಇವತ್ತು ಇಷ್ಟೊಂದು ಟೈಮ್ ಸ್ಪೆಂಡ್ ಮಾಡಿದ್ಮೇಲೆ ಮುಗೀತು. Third submission.
Your lordship may kindly see. In Chandrasekhar's case, what they say is, the IO had supported the case fully, and their lordships have gone to an extent of saying, on verifying the evidences of PW 1, 2, 3.
Where?
In Chandrasekhar's case.
Where? Criminal
In
trial?
departmental inquiry. In departmental inquiry. In departmental inquiry. The court says, though it has not been challenged before us specifically, but it will not detain us from going through their evidence only for the purpose of showing that even the order of exoneration is not on merit, because complainant has supported in toto. He has spoken about demand and acceptance in Chandrasekhar. And secondly, their lordships say that even punch witness is concerned, he has stated about entire trial proceedings, except the fact that he has not heard the conversation. And then their lordships, they say that even investigating officer has given the evidence. That is, in that case, IO was not examined. But in case of T. Manjunath, only IO was examined, and he has supported the entire case in toto. So in both the cases, my lords, their lordships have said, after going through the inquiry report, they could find manifestly the material which is sufficient to find the accused guilty, or say that the disciplinary authority could have proved the charges laid against them. They say there are sufficient materials to find that the charge alleged against them are proved. There is a specific finding in Chandrasekhar's case. That's why they say exoneration is not on merit. Even that wording is there. And their lordships have said, because
their exoneration was not on merit, but I'm aware.
So the distinction could be exoneration of merit includes hostile witnesses or not. For that also, my lords, in my synopsis I've written, what is evidence? Evidence is what is the chief and cross-examination read together is an evidence. It is not what the prosecution or disciplinary authority
in the
produces.
criminal trial, that stage is yet to come here. Evidence ಎಲ್ಲ ಆಗಿದೆ.
Departmental
Departmental
inquiry
inquiry ಆಗಿದೆ.
ಆಯ್ತು ಅಲ್ಲ ಅದು ಬೈಂಡಿಂಗ್ ಅಂತ. See, my humble submission.
Binding ಅಂತ.
Exoneration is binding. If even Chandrasekhar's case, the proposition has not been disputed. Then at the beginning only their lordships have said, the lordship may kindly say.
I've seen
only.
that judgment.
But still for my
All
satisfaction.
right, really.
Despite this court having consistently held that disciplinary proceedings and criminal prosecution, even on identical allegations, are parallel proceedings the relevancy of the conclusion is one is often contended to be binding on the other. Right is the principle that in a disciplinary proceeding, the proof is of preponderance of probability, while in a criminal proceeding, it has the highest standard of proof beyond reasonable doubt. Often it is argued that acquittal in the criminal proceedings should incur the benefit of accused delinquent employee in a disciplinary proceeding too. In the present case, we have a contrary contention of disciplinary proceedings, having exonerated the delinquent employee who seeks absolution from the criminal prosecution. The contention is that when the allegation could not be proved in a disciplinary proceedings, when allegation could not be proved in the disciplinary proceedings, where the requirement is only a preponderance probabilities, surely it cannot be proved beyond reasonable doubt. Your lordship may kindly see further, while distinguishing, their lordships have specifically quoted Rajesham Agarwal, and threadbare discussion is made on Rajesham Agarwal, wherein, my lords, because entire thrust was given on two issues, even marking is there at para 38, where they say the finding in the adjudicatory proceedings in favor of a person facing trial for identical violation will depend upon nature of finding. So I am on that point. It is on nature of finding that has not been disputed. If the exoneration in adjudicatory proceedings is on technical ground, not on merit, prosecution may continue. So question, my lord, says, in that case, in that particular case, their lordship has specifically stated it is not on merit because complainant had supported the case. In my case, absolutely nobody has supported, and even the amount found is 18,000 rupees and not the 15,000 rupees. So that itself shows that entire thing is different. And their lordships have specifically stated that entities are different. So in Rajesham Agarwal, they say that entities are same. Here they are different. And important aspect of judicial proceeding is not taken into consideration.
Right. We'll take it into consideration.
But in the event, my lords, in the event this honorable court feels that Chandrasekhar's case itself is applicable or T. Manjunath's case itself is applicable.
ಮಂಜುನಾಥ್ ಕೇಸ್ ಇದೆ ಕೊಡಿ.
Manjunath.
ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದೀನಿ, ಅದರೊಳಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ. Manjunath is there.
Supreme Court has remanded the matter, my lord, to the Honorable High Court.
So there's Natarajan or order.
Please.
ಕೊಡಿ. ಅದು exoneration ದೇನಾ?
Please, there are two issues, my lord. Sanction as well as exoneration. But matter is remanded, my lord, and argument is going on in that matter.
ಎಲ್ಲಿದೆ?
Krishna Kumar. ಇಲ್ಲಿ ನಡೀತಾ ಇದೆ.
ಬೇರೆ ಕೋರ್ಟ್ ನಡೀತಾ ಇದೆ.
This is Krishna Kumar.
All right. In T. Manjunath, your lordship may kindly see, it was on the point of discharge, wherein there are plethora of cases. At the time of discharge, court cannot look into exoneration in departmental inquiry. I am not on the point of discharge because there is under 482 there is a specific bar, but I am not on that. I am on the point that continuation will be abuse of process. I squarely fall upon Bhajan Lal. So your lordship may kindly see.
Let me see. We'll consider.
I may be permitted in the event. I mean, not now. I'm in the to take all these contentions in my trial because it is judicial.
ಈಗಲೇ ತಗೊಳ್ಳಿ. I will pass that order. You want me to pass a detailed order? I will pass on because this issue requires an answer. Wait, so that other cases it will be. In the event, definitely I will permit you.
Because it is a judicial proceeding, an observation, my lord, that judicial proceeding under section 80, therefore I may be permitted to take that contention in the trial.
No, you want to withdraw this now?
If court has made up my mind, I have to withdraw.
Because made up my mind. This requires an answer because all those things that you have submitted now does require an answer. We'll see judicial proceeding, all that we'll consider. Yes.
But here, but my learned friend argued, my lord, PW 1 to 3 has not supported the prosecution. Here, PW 2 and PW 2, my lord, partly supported the prosecution case, and PW 3, my lord, IO fully supported. the
IO will definitely support. Who else will support prosecution?
And my lord,
If
normal.
IO is turning hostile, then it is over. I would have straight away quashed entire proceedings
And my lord,
everywhere.
PW 3 regarding, my lord, conducting of inoculation test, my lord, trap mass, my lord, regarding that aspect, even PW 2, my lord, supported the case of prosecution.
IO's case,
No,
my lord.
let's raise some legal
Please,
questions.
legal
to answer.
regarding.
And free judge bench of Ashu is not considered in the later judgment.
But however, my lord, regarding judicial proceedings, my lord, Radhesham Kejriwal and my lord,
That
judgment, my lord, it is answered. My lord, it is completely
Department
different.
Inquiry Act.
Department inquiry.
And here is a case, my lord, there is specific demand and only one accused. And my lord, by following Neeraj Datta case, my lord, recently, my lord, Honorable Apex Court.
Neeraj Datta.
When there is a, Karunanidhi case, my lord, when there is specific
I'm
demand.
really-
And
When I was shocked, my lords, in Manjunath's case, the lordship, I mean, it is written specifically that IO's evidence itself is sufficient. Your lordship may kindly see where in Neeraj Datta's case it is
But in this
stated
case-
that IO's evidence is sufficient.
but in this case, A2 was, my lord, acquitted. However, A1, because there is a specific demand from the A1, the Honorable Apex Court will not answer the following Neeraj case when there is specific demand. Please,
That's the whole issue. We'll see.
please. Because my lord, FSL report is
No,
received,
no,
everything is there, my lord, to show that.
Heard the
matter of
learned
trial.
counsel A. Shankar,
Shankar Hegde.
Shankar Hegde, sorry.
Shankar
Shankar
is
Hegde
sufficient.
appearing for the petitioner and Prasanna Shetty representing the respondent Lokayukta reserved.
Please.
Much obliged.
Interim order subsisting will continue till the disposal of the petition.
Much obliged.
Entire charge sheet I have placed, my lord, before. the law.
Irli.
My lord, in serial number 11, I seek, my lord, a week's accommodation. The respondent counsel, my lord, has met with an accident. That is the reason, my lord,
List the
3
matter
days
on,
time.
list the matter on 10th for admission. Interim order subsisting will continue.
10.1, please, my lord. I've taken fresh steps to issue notice to respond number 2. There are two connected matters.
Two connected matters.
Please.
Respond number 2, yeah. First case yaru.
First case is a private complaint. There is my learned friend.
Second case ali?
Second case it is a private.
Different complainant.
Please, my lord.
Emergent notice to the second respondent, returnable by the 17th. We'll take it on 17th.
Much.
List on 17th for admission.
Interim order.
Interim order will continue.
The petition in this case, my lord.
498A.
498A, my lord. In-laws petition, my lord. My lord, on 11/10/2023, my lord, she lodged a complaint. I have produced at page number 56, my lord. On that day, NCR has been registered. On very next day, my lord.
Husband is not here?
Lord?
Husband is not the petitioner here?
Not the petition, my lord.
Yes. Really? Why?
Respondent, my lords,
Ah.
request for short accommodation.
No accommodation, yes. It is listed for closure.
Proxy council, my lord.
Proxy counsel, then don't worry, madam. Yes, come on. You should not take those responsibilities of appearing. Who is the counsel? VG Ravi Kumar.
Last date of occasion.
Heard the learned counsel appearing for the petitioner. The counsel for the respondent, the counsels representing the respondent would seek time. The interim order stands extended till the 10th of February 2026. List the matter for admission on 10th February 2026. In the event the respondent would not make submissions on the said date, orders would be passed on hearing the counsel for the petitioner. Interim order subsisting shall continue to the next date of hearing. 11th, 24 either. 11th, yes.
13.
7A.
My lords, may please see the order dated 7/1/2026. They have still not served a copy. My lords had observed that the interim order will be vacated if they have not served a copy on us even now.
ಒಂದು ಇಲ್ಲ ಇಲ್ಲಿ interim order ಯಾರು ಕೊಟ್ಟಿದ್ದಾರೆ?
Copy no ಕೊಟ್ಟಿಲ್ಲ. Petition copy also is not served to this day on us.
This court had on 19/7/2024 passed the following order. The Lokayukta was refrained from filing the charge sheet before the concerned court if the charge sheet had not already been filed. On 7/1/2026, again, this court passed the following order. In the event there would be no representation for the petitioner nor the copy would be served on the counsel, the interim order would get automatically vacated. Even today, today, there is no representation on behalf of the petitioner. Learned counsel B.B. Patil submits that the copy of the petition is not served despite passage of 2 years. In the light of the order dated 7/1/2026, the interim order stands vacated. The Lokayukta is, the respondent is at liberty to file the final report if it is ready before the concerned court.
Please, deeply obliged.
14.
ಇದು 7A.
7A charges are already framed.
ಯಾವಾಗ ಹಾಕಕ್ ಮುಂಚೆ ಹಾಕಿದ್ರ?
ಇಲ್ಲ, ಹಾಕಕ್ ಮುಂಚೆನೆ ಹಾಕಿ.
Charge frame ಆಗಿದ್ರೆ will not entertain. Yes.
My lords, my lords, the page on which the demand is there, acceptance is there. The charge copy also I'm producing.
ಈ charge frame ಆಗಿದ್ರೆ ಅಲ್ಲೇ ಮಾಡ್ಕೊಳ್ಳಿ.
My lords, the charge copy.
ಕೊಡಿ.
Soon after the.
Date ಏನು charge frame ಆಗಿರೋದು?
Soon after the rejection of discharge application. Soon after the rejection of discharge application, we have approached this honorable court.
But ಯಾವತ್ charge frame ಆಗಿರೋದು? ಯಾವತ್ತು ಪಾಟೀಲ್ ಸರ್?
This is the online copy, my lords, but incidentally the date is not there.
Anyway, charge frame ಆಗಿದ್ರೆ ಅಲ್ಲೇ, but petition ಹಾಕಕ್ ಮುಂಚೆ ಆಗಿದ್ರೆ definitely we will not entertain. ಆದ್ಮೇಲೆ ಆಗಿದ್ರೆ will entertain.
On the same day, when he rejected the discharge application, the same day they have framed the charge.
Of course, that is the
without any
procedure.
opportunity to approach the higher court in this case.
ಅವ್ರ opportunity ಕೊಡ್ಬೇಕಾ? charge frame ಮಾಡಿ 15 ದಿನ ಬಿಟ್ಟು ಮಾಡ್ತೀನಿ, ನೀವು ಹೋಗಿ ಮೇಲೆ ಆರ್ಡರ್ ತಗೊಂಡ್ಬನ್ನಿ.
Same day they have framed the charge.
Lords, even on merits, he himself has demanded and accepted it.
ಎಲ್ಲ turned.
Very clear. We can point out the pages also on which.
Got redundant.
Please.
No, we have filed the amended petition in this matter as per the permission of this honorable court. Today it's for objection for that.
Yeah, today it's for argument.
Next day I will argue the matter.
ಎಲ್ಲಿ ಸ್ವಾಮಿ ಅಲ್ಲಿ?
Swami out of session.
ಇದು ಅದೇ ಆಶು.
Please.
But here is
ಅದಕ್ಕೆ ಶಂಕರ್ ಹೇಳಿದ್ರು.
all the witnesses
ತುಂಬಾ
are
ಕೇಸ್ಗಳು
examined.
ಬೇಕಾಗುತ್ತೆ ಇರಿ.
All the witnesses are examined. Milord, may kindly be see the page number 18. There are 20 witnesses are examined in the
Departmental inquiry.
Departmental inquiry. And here the case at the time of trap, Milord, the shadow witness are
10th
not.
ತಗೊಂಡ, let him come. List the matter on 10th for admission, 11th for admission as a last chance. In the event no submissions are made, the petition would be answered, hearing the counsel, appearing for the respondent.
Interim order.
Interim order subject to the aforesaid stands continued till the next date.
Much
obliged.
Next.
16.
On the basis of the PCR, they register.
PCR?
What PCR? They have come, filed the PCR before the batch set, my lord.
Interim order ಇದೆಯಲ್ಲ?
PCR, there is no criminal.
Interim order ಇದೆ?
Interim order there.
ಯಾವಾಗ serve ಆಗಿದೆ madam?
We have filed the civil suit before the filing the PCR.
Interim order, 26/25. Lest the matter on 11th for admission, interim order subsisting will continue to the next date of hearing. This should go, Jagdish sir. This should go. Yes. Within 7A na? 16.
Counter is ready.
Okay.
I'll file it in the
Counsel to B.B. Patil seeks 3 days time to file the statement of objections. Objections, if any, by the next date, list on, madam, it's 7A, 12th ಹಾಕೋಣ. ಇಲ್ಲ 11th ಯಾಕಂತ dates ಹಾಕೋಣ. 11th.
Please.
Interim order.
Interim order subsisting will continue to the next date of hearing.
17.
17.
ಇದು ಏನು? 7A?
7A. My lords.
D&A?
No, not 7A.
ಅಲ್ಲ, D&A ಇದೆಯಾ?
Please, my lords. It's a dereliction of duty, my lords.
Dereliction of duty? D&A ಅಂದ್ರೆ demand and acceptance ಇದೆಯಾ?
No, it's not demand and acceptance.
ಏನಿದು? 13
It is not attracted.
It's not 7A, my lords.
ಮತ್ತೆ?
Dereliction of duties, my lord, for exercising their official duties for Podi and Durst, my lord.
There is some dereliction of duty, I make an allegation and made the complaint.
13-1,
After lapse of 6 years,
13-1E.
it's not at.
6 ವರ್ಷ ಆದ್ಮೇಲೆ ಕೌಂಟರ್ ಹಾಕಿದ್ದೀರಾ?
Counter ಹಾಕಿದ್ದೇನೆ. It is ready, I'll file it in the.
ಫೈಲ್ ಮಾಡಿ. Same previous order, 11th interim order continues.
Both.
Both.
18.
ಇದೇನು?
Trap failure.
Failed trap.
Huh?
Failed trap.
Failed trap, and moreover, even conversation, there is nothing. The work is completed.
Work ಬಿಡಿ ಸೀತಾ ಸೋರೆನ್ ಇಂದ
ಅಲ್ಲ, Supreme Court, ಇದು sanction is refused.
Sanction is refused.
This is also Tippeswamy. Incidentally, this is also failed trap because another Tippeswamy, my lords were pleased to write, went up to Supreme Court, came back. It is now heard in part before another bench. This is also a failed trap. We'll file our regular compendium of judgments, my lords, relying on 25 judgment.
Interim order ಇದೆಯಲ್ಲ. Heard the learned counsel Shankar Hegde appearing for the petitioner and counsel Baby Patil. Counter ಹಾಕಿಲ್ಲಲ್ಲ ಇನ್ನು?
Counter
ಹಾಕಿದ್ದೀರಾ? The learned counter ಹಾಕಿಲ್ಲ.
We'll file with our
Learned
judgments.
counsel Shri Baby Patil seeks 10 days time to file statement of objections. List the matter on 17th, 18th. Objections, if any, by the next date, interim order subsisting will continue.
Oblige.
19.
ಇದೇನಾ?
7A.
7A.
Have it on my lord.
Failed successful?
No, successful.
ಇವರೇ ತಗೊಂಡಿದ್ದಾರಾ? Same 17th. Objections, if any, by the said date.
20.
What's this?
Husband petition. It's for
498,
file.
there's an interim order?
Interim order is there. The respondent wife is served. She is remain
Oh, no.
unrepresented last.
Manjula PR, somebody is here.
Last year,
Manjula PR is the wife, is it?
husband. Right? I'm ready on marriage.
One moment. My interim order. Yes, I have stayed it only on 7/1/26. Wait.
Wife is served.
ಯಾವತ್ತು ಸರ್ವ್ ಆಗಿದೆ ನೋಡಿ?
Council.
ಕೌನ್ಸಿಲ್ ಅದು? ವಕಾಲತ್ ಹಾಕಿದಾರ? Council. Heard the learned counsel Amrita Manchanda appearing for the petitioner. There is no representation on behalf of the respondent, second respondent complainant. As a last chance, list the matter on 18th. In the event the respondent's counsel would not be present, the petition would be answered, hearing the counsel appearing for the petitioner. Interim order subsisting will continue to the next date of hearing.
21.
ಇದೇನು?
Failed trap.
Failed.
Failed trap.
Objection
I'll have to
not
file
carried.
counter.
ಮಾಡಿ. Same interim order subsisting will continue. This Baby Patil sir will file statement of objections. ಅವ್ರು ಮಾಡಿದ್ನಲ್ಲ madam, same order, yes.
Please, oblige.
18th.
Please.
22.
Lords, I need a short accommodation to file.
22 is 25. It will come on
I
19th.
need objections, I have to file.
Lots.
19th.
Interim order may kindly.
Interim will continue.
Great.
ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ, yes.
Oblige.
In this case, my lordship,
23 party in person.
Party in person ಇದಾರೆ. I filed the ವಕಾಲತ್.
Oh.
Please.
So a partly in person.
Partly in person, exact.
ಏನ್ matter?
The lordship is intentioner of the case is Article 341, 342 of Constitution of India. Back behind.
ಏನ?
Caste certificate. Fake caste certificate. So my case is concerned with only 342 article. The Nayaka community obtained, some of the peoples are obtaining the fake
Petitioner
certificates.
ಯಾರು sir?
Petitioner is the
ಅವ್ರಿಗೆ ಏನ್ ತೊಂದ್ರೆ ಆಗಿದೆ?
petitioner is the accused number 1 in crime number 4112.
ಅಷ್ಟೇ ತಾನೆ? ಈಗ ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದೀರಾ?
ಇದರಲ್ಲಿ they file application under section 91 CRPC. Some of the documents.
What documents?
I have marked in the documents at page number. I will show them.
What documents, sir?
The documents are station.
Page 45 one is.
At page number 19, my lordship.
Page 45 ಯಾರ್ಯಾರ್ದೋ ಓನ್ ಸರ್ಟಿಫಿಕೇಟ್, ಯಾರ್ಯಾರ್ದೋ ಇದು ಯಾಕೆ ಬೇಕು? ಎಲ್ಲ ನಿಮ್ದೇನಾ?
ಅಲ್ಲ ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀನಿ.
ಆಯ್ತು ಸರ್. learned HCGP shall secure instructions and make his submissions further proceedings before the concerned court till the
One
next
small
date.
request, my lordship, in this case. Criminal petition number 29, 15 of 25, connected matter.
I tag this petition along with number barcode.
29, 15 of 25.
List on 19th, there shall be an interim order of stay of further proceedings before the concerned court till the next date.
Public. In the both petitions.
ಇದು registry to print the name of so and so as appearing for the petitioner and delete the name of Dr. J.S. Madhukar as appearing
Stay in
party
the both
person.
petitions. my lordship.
Both-
Four criminal petitions.
ಎಲ್ಲಿದೆ ಎಲ್ಲ?
ಒಂದು 408 and
Number
408.
ಕೊಡಿ.
ಕೊಟ್ಟಿದ್ದೀನಿ.
Number
I will see.
tag ಎಲ್ಲ.
I will give it.
Yes, yes.
Both petitions.
24.
ಈಗ 20% ರೆಡಿ ಇದೆ ಎಲ್ಲಿ ಇವರು ಜ್ಯೋತಿ? 24 ಬೇರೆನಾ? Yes,
For
sir.
the petitioners, kindly grant a week's time.
List on 25th, 26th. Yes. At the request of the council appearing for the petitioner.
25.
20%.
Please, my lord.
ಯಾವಾಗ ಕೊಡ್ತೀರಾ?
My lord, covered by judge.
ಯಾವ ಕವರ್ಡ್ ಇಲ್ಲ.
My lord, non-speaking order. The
ಎಲ್ಲಿದೆ
reasons
ನಾನ್
are not-
ಸ್ಪೀಕಿಂಗ್? Which is non speaking
Page
order?
59, my lord.
What is check amount?
Lord, check amount, there are three checks, my lord, which one?
Correct, three petitions.
The first one, the first petition, my lord, the check amount is 60 lakhs. Second petition, check amount is 38 lakh 35,000. Third petition, 38 lakh 35,000.
I'll give you
That's
time.
a- that's a fine amount, my
I'll
lord.
give you time for 8 weeks to deposit the amount.
My lord,
No, covered ಎಲ್ಲ ಇಲ್ಲ.
my lord, similar, same order, my lord, same
ಇಲ್ಲ.
circumstances and they have also like some amount.
ಏನ್ ಜಂಬು ಭಂಡಾರಿ?
Please,
Oh, no. Yes.
my lord.
ಎಲ್ಲಿದೆ?
One-
Where is the order? Where is the order here?
Order at page 59, my lord. Impugned order that I'm referring.
Oh, ಇದ್ರಲ್ಲಿ reason ಇದೆ ಎಲ್ಲ.
My lord,
ಜಂಬು ಭಂಡಾರಿ is considered.
they have just mentioned it, my lord. She doesn't make the
He,
reason.
who is she?
The learned,
Yes.
session. They say IA number pending for consideration, impugned judgment and order so and so dated hereby suspended on condition that the appellant shall deposit 20%
We'll
fine
send it-
amount
send
and
it back.
also execute.
We'll send it back for, to redo the exercise. The petitioner, all three cases, madam, same, ಒಂದ್ರಲ್ಲಿ ಹೇಳ್ತೀನಿ ಮಿಕ್ಕಿದ್ ಮಾಡಿ. The petitioner is before this court calling in question an order of the concerned court, concerned appellate court, which suspends the sentence subject to condition of deposit of 20% as is obtaining under section 148 of the Negotiable Instruments Act. The learned counsel, the petition, heard so and so. The petitioner is the accused, the respondent, the respondent, the complainant. The petitioner gets convicted of the offense under section, for section 138 of the Negotiable Instruments Act. The issue is not with regard to the merit of the matter. The concerned court suspends the sentence by the following order, page 55 to 59. Though the judgment of the apex court in the case of Jambu Bhandari is referred, there is no application of mind for directing deposit of 20% as is directed by the apex court. In identical circumstances, this court has passed the following order. Same order. ಅದರಲ್ಲಿದೆ ಕೊಡಿ.
That this order should not come in the way of, well, they should not take advantage of this order not to.
For what?
Deposit of.
15 days I have given for the court to pass necessary
Very good.
orders, that's all.
Very good.
ಇದೇನ್ ಕ್ವಾಶ್ ಕಂಪ್ಲೀಟ್ ಅಲ್ಲ, ವಾಪಸ್ ಕಳಿಸಿದ್ರೆ 15 ದಿವಸದಲ್ಲಿ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿ ಅಂತ. Next. Yes,
28.
all three, yes.
Lord, sir.
Here for the respondent number 2. Pay for a short accommodation to file my objections.
Interim order ಇದೆಯಾ ರವಿಶಂಕರ್?
Its interim is in operation.
Will grant him 10 days time.
Very well.
They heard the learned senior counsel D.R. Ravishankar appearing for the petitioner. The learned counsel J.R. Jagdish seeks 10 days time to file statement of objections. In both these cases?
Yes, ma'am.
The second one, the registry to print the name of J.R. Jagdish is appearing for the second respondent of the first ಮಾಡಿ. ಆಮೇಲೆ time granted 10 days to file statement of objections ಅಂತ ಮಾಡಿ. List the matter on 19th February.
There is
Objections.
one application, my lords, if your lords is.
ಏನದು?
That is second petition is not against him. We have not made him as a party. This is basically against the police. Notwithstanding the interim order passed, they have issued police notice.
ಅದು ಸ್ಟೇ ಮಾಡಿಲ್ವಾ?
That is not, even, ಇದರಲ್ಲಿ stay ಇದೆ ಅಲ್ವಾ? Even in that stay is operating.
ಹಂಗಾರೆ ಅದು ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅವರು ಅಂತ ಬರಬೇಡಿ. List the matter on 19th.
Lordships.
Objections if any by then, interim orders of listing will continue till the next date of hearing. Yes. ಇಲ್ಲಾಂದ್ರೆ
Let
ಅವತ್ತು
it be in the fresh matters list itself.
Same admission.
So,
Admission is.
admission. Very good.
Admission say first.
Very-
29.
Petition in this case. My application, my lord, to release passport and
ಅದೇ SVP.
No, my lord, this is a case, my lord, where an application is filed to release of the passport by the magistrate, because it is
application.
the passport
How
is
can it be kept with the magistrate?
Plus respondent police seized my, they arrested me and seized my
PF
passport.
ಮಾಡಿದಾರ ಅಲ್ಲಿ?
House.
Passport ನ PF ಹೆಂಗ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
It should not have been done, my lord. Your lordship would get that at page 69, annexure K. PF number is 24 of 25. The passport bearing so and so, and Samsung.
That's the exclusive property of the passport authorities to impound or otherwise.
Please.
Court or police has no jurisdiction there.
Your lordship has held in
ನಾನೇ
the.
ಬರ್ತಿದ್ದೀನಿ ಯಾವ್ದ್ರಲ್ಲಿ?
Please.
ಯಾವ್ದು
In
some
DRT case.
DRT case.
Please,
Yes. Just check that. Disposed.
please.
Right.
Great.
In accordance with law, you can take action if you want to.
Blood that.
ಇದೆಯಾ judgment ಅದು ಕೊಡಿ.
Judgment.
DRT ದಲ್ಲಿ.
Sorry, I'm not bad. So one more application, my lord, interim relief from this honorable court.
For what?
Well, they issued, my lord, inventory. The authority, my lords, to, requested to Deputy Commissioner of Crime, my lords, issued, circular, my lords, lookout circular. First.
LOC ಯಾವ್ದಕ್ಕೆ ಸರ್? LOC ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ? ಪಾಸ್ಪೋರ್ಟ್ ಕೇಳ್ತಾ
The
ಇದ್ದೀರಾ?
passport ಮಾಡಿದೀವಿ. One more application, filing to
ಪೆಟಿಷನ್ ಡಿಸ್ಪೋಸ್ ಆದ್ಮೇಲೆ ಅಪ್ಲಿಕೇಶನ್ ಏನು?
interim direction may be issued to Captain.
ಚಾಲೆಂಜ್ ಮಾಡಿ ಸೆಪರೇಟ್ ಆಗಿ. Will answer.
Please. Great.
Heard ಎಲ್ಲ ನಂದು DRT ಜಡ್ಮೆಂಟ್ ಇದೆ ಅಂತ ಕೊಡ್ತಾರೆ.
30.
Split up.
Please. A2 and 7 was acquitted. Petitioner is A6. Allegations are common blood against all the accused.
ಏನ್ 399 402 ನಾ?
ಇಲ್ಲ, the offense 143, 144. The major is 324, my lord, the offense. Even the no test identification
ಇದು
period.
page 49 ಅಲ್ಲಿ co-accused ಅದು?
ಹೌದು,
Co-accused.
ಹೌದು.
ಹಾಗಾದ್ರೆ ಅದನ್ನ ಫಾಲೋ ಮಾಡಿ ಮುಗಿಸಿ.
Paragraph number 22 and 23 is the findings.
That's all right. Annexure F, page 49, is it co-accused?
Yes, please. They are the accused number 2 and 7 is concerned, they acquitted. The trial court.
120B and 302.
Please.
Oh, this is accused number 8.
No. Annexure E is this so far as co-accused is comes.
What is this I am asking? Annexure F.
But the principle followed by this court, my lord.
The petitioner is before this court seeking the following prayer. The petition heard so and so. The petitioner gets embroiled in a crime for offences punishable under so and so. Nodkodi. The petitioner is accused number
6.
The petitioner is accused number 6 at the relevant point in time was not available for trial. Owing to the fact that the petitioner was not available for trial, a split charge was drawn against the petitioner, which is now sought to be tried before the concerned court. The other accused who were available for trial faced the trial and an order of acquittal is passed in their favor on the score that the prosecution has failed miserably to prove the guilt beyond all reasonable doubt. The order of the concerned court is as follows. Page.
Finding at page number para 30, 22 and 23 at page number 41.
22, 23, ಆಮೇಲೆ 28 to 30 paragraphs. In the light of the acquittal of the co-accused and the offense being the one that can be committed only the allegation being common, permitting further trial against this petitioner, though he has escaped trial in the earlier point in time, would be wastage of precious judicial time. In that light, adon Oxford. Annexure F nande order.
Good.
Next.
31.
Lord, a similar contention, my lord, covered by judgment ಇದೆ ನಿಮ್ದೆ.
ಏನದು?
307, 1 and 2 acquit ಆಗಿದ್ದಾರೆ, split up ಆಗಿತ್ತು. This is for accused number 3.
ಕೊಡಿ. The petitioner is before this court seeking the following prayer. ಇದು ಯಾರ್ದು?
Lord,
Accused number?
ಇದು accused number 3, my lord.
ಇದು?
ಇಲ್ಲ ಇಲ್ಲ, ಅದು ಬೇರೆ.
ಬೇರೆ.
Judgment ಹಾಕಿದೀನಿ.
The petitioner gets embroiled in a crime heard so and so, same drill ಗೊತ್ತಲ್ಲ? Then, yes. The judgment ಎಲ್ಲಿದೆ? Acquittal.
Annexure E, my lord, 74, page number.
70. Offense ಏನು?
307, 323, 324, 504, 506, red with 149, my lord.
Madam, ಇಲ್ಲಿ page 80, reasons 81 ಇಂದ 89. Same principle. Yes.
Grateful.
Next.
Order. Appearing for petitions, my lordship. My lordship, the charge sheet has been the.
Charge sheet ಆಗಿದೆ.
Charge sheet ಆಗಿದೆ. Filing ಮಾಡಿದ್ದು sir.
ಏನ್ ಫೈಲ್ ಮಾಡಿದೀರಾ?
Charge sheet, my lordship. There is an objection with regard to charge sheet, my lordship. The same copy they have produced, my lordship, before the trial
Counsel for
court.
the petitioner submits office objections have been complied with, office to verify. Yes,
My
next.
lordship, interim order is there, my lordship.
ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. Yes, next.
Gate may be given, my lordship, so that I can argue.
Yes,
Immediate
list on 19th,
Much obliged.
18th.
Much obliged.
Parmeshwar,
33.
7 ಏನ? Objections ಯಾರಿದೆ? Respond. B ಆಗ್ಬಿಟ್ಟಿದೆ. Registry to appropriately print the name of B.B. Patil in place of B.B. Patil. B.B. Patil.
ಅಲ್ಲಿ ಬಿ ಪಾಟೀಲ್ ಅವ್ರ ಕೊಲ್ಲಿಗ್ ಇದ್ದಾರೆ.
ಅಲ್ಲ ಬಟ್ ಇಲ್ಲಿ B.B. Patil ಅಂತ ಹಾಕಿದ್ರೆ ಏನ ಅವ್ರಿಗೆ ಹೆಂಗ್ ಗೊತ್ತಾಗತ್ತೆ?
ಇಲ್ಲ ಇಲ್ಲ.
B.B. Patil. ಇದು ನೋಟಿಸ್ ತಗೊಂಡಿದ್ದೀರಾ ಮುಂಚೆ?
ಆಗಿದೆ.
Name registry to print the name of so and so, non-compliance of office objection. Or statement of objections ಹಾಕಿದ್ದೀರಾ? A week's time is granted to rectify the statement of objections, rectify the objections, square the statement of objections by Madhu R.
Lords, it appears, my lords, the complainant has filed a statement of objection, but it is not accompanied with the verifying affidavit.
That we'll see, yes. 10 days time is granted to comply with the office objections, square the statement of objections of the second respondent. The registry to print the name of B.B. Patil as appearing for the first respondent in place of B.V. Patil. Objections, if any, by the respondent by the next date of hearing. List the matter on 25th.
My lord, in 33, my lord, in 33, my lord, I had filed the objection along with the verifying affidavit in the registry, my lord. Same may be overruled, my lord.
List the matter on 26th. Interim order, if any, shall continue to the next date of hearing. 25th.
34, 13%.
Statement of
7A charge sheet challenge.
7E. And he already filed a discharge application before the trial.
Rejected,
It's pending.
No, pending.
Interim order ಯಾಕೆ ಕೊಟ್ಟಿರೋದು?
Lordship has
Shall not file charge sheet.
Deferment of
charge sheet is already filed.
Charge sheet challenge ಮಾಡಿದ್ರು.
After charge sheet, my lord, he filed an application for discharge.
ಮತ್ತೇನು interim order ಇಲ್ಲಿ? Interim order ಕೊಟ್ಟಿರೋದೇನು?
Deferment of proceedings. ಅದು ಎರರ್ ಆಗಿತ್ತು ಸರ್.
Deferment of proceedings.
Please.
I will take it on 18th.
Lord, I'll filing this.
On registry lucky. Counsel B. Latif seeks 10 days time to file statement of objections. List the matter on 18th. 18th or 19th, no, madam.
18.
Yes.
35.
Appearing for the petitioner, my lords. 7A.
7A?
7A, my lords.
7A.
ಏನು ಸಕ್ಸಸ್ ಫೇಲ್
Success received 25 lakhs.
Lakhs.
Very objection, 40 pages is only the note numbers. This much is only the numbers of the notes that have been seized. TDR for, it's the Mangalore Urban Development Authority Commissioner.
Muda.
For TDR, my lords, an initial demand of 45 lakhs and then 25 lakhs received through one Mr. Salim, who gives
ಅದನ್ನೇ ಕೇಳ್ತಿರೋದು ಸಕ್ಸಸ್ಫುಲ್ ಟ್ರ್ಯಾಪ್ ಇಲ್ವಾ?
Please, my lords,
ಇವ್ರು
because
ರಿಸೀವ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರಾ?
ಅವ್ರು
Petitioner has not received the amount.
ಮತ್ತೆ
ಅವ್ರು ಹೇಳಿದ್ದಾರೆ ಸಲೀಮನ್ ಅವ್ರು ರಿಸೀವ್ ಮಾಡ್ಕೊಂಡು ಒಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. Saying that I have received it on his behalf.
ನೋಟ್ ಸೀಸ್ ಮಾಡಿರೋದು ಯಾರಿಂದ?
Of course, my lords, during the TAP proceedings, it has been.
Accused number 2 in the, my lords, Salim Anton.
Seized from Mr. Salim, because he was asked to give it to Mr. Salim. Of course, this gentleman wouldn't be receiving it by himself.
ಸರಿ, ಇದು ಕಾನ್ವರ್ಸೇಷನ್ ಇದೆಯಾ?
Conversation ಇದೆ, 45 ಕೇಳಿರೋದಿದೆ, 45 ಆಗಲ್ಲ, ಸ್ಕ್ವೇರ್ ಫೀಟ್ ಮೇಲೆ ಕೊಡಿ ಅಂತಿದೆ.
ಎಲ್ಲಿದೆ ಎಲ್ಲ?
I have a statement of objection, my lords, in that.
My lords,
Running page number
ತೀರ್ಮಾನ ಮಾಡಲ್ಲ,
22.
wait sir.
please, my
Running page number 22. Statement of objection. At para 8, the trap mahazar starts, at page number 18, it starts, my lords. At 22, that is internal page number 5.
So it's not a successful trap, like how money receiving you caught red-handed ಅದಲ್ಲ ಇಲ್ಲ.
That's the latest Supreme Court judgment. It says even if you're receiving it through someone else,
That I have seen,
he
ಕೇಳಿದ್ದೆ
is
ಅಷ್ಟೇ.
receiving it through
ಕೊಡಿ.
someone else.
I want to know whether he has accepted it or not.
That's that big an amount,
ಅಲ್ಲ,
no one would
ಗೊತ್ತಿಲ್ಲ.
receive it themselves.
ಕರುಣಾನಿಧಿ ಗೊತ್ತೆ. Yes.
My lords will have seen it. ಈಗ page number
Well, let's take
25.
it on 17th,
Please.
18th.
Please.
Before the law. List the matter on 18th. 19th, sorry. 19th, madam? 18th, yes.
Please.
For admission.
Please, oblige.
Entry ಮಾಡಿದ್ಯಾ?
ಇದೆ, my lords, not to file.
Entry ಮಾಡಿ subsisting, not to file charge sheet.
My lords, they filed against accused number 2, but not against me.
All right. You are accused number 1, na?
1, my lords.
Who is the one who has received it?
Accused number 1?
Accused number 1, you wrote, 2 has received it.
ಅದೇ 2 has received it, ಅವ್ರ ಮೇಲೆ charge sheet ಹಾಕಿದ್ದೀರಲ್ಲ. List the matter on 18th.
Oblige.
Entry ಮಾಡಿ subsist, if any, shall continue to the next date. Next.
Deeply obliged.
36 withdrawal.
In terms of
37.
Lordship, sees my lordship, 2023 bail granted. He is
30?
unable, 23 ಅಲ್ಲಿ
ಅಲ್ಲ ಯಾವ serial number?
37.
37, ಏನಾಯ್ತು?
Lordship, he is unable to furnish 2 sureties. Lordship, relaxation of condition we have filed, session court rejected. Session court himself, my lordship itself granted bail to
ಎಲ್ಲಿಯವ್ರು ನೀವು?
A2.
Where are you?
Lordship, native of Uttar Pradesh.
ಅದೇ ಪ್ರಾಬ್ಲಮ್.
It's very difficult to secure his presence. A1 ಗೆ relax ಮಾಡಿದ್ದಾರೆ, ಒಂದು surety ಮಾಡಿದ್ದಾರೆ. Lordship, since from 2 years, my lordship, he is unable. Very poor person, my lordship.
ಶ್ಯೂರಿಟಿನೇ ಕೇಳಂಗಿಲ್ವ? ಕೊಡಿ.
This is one surety relax ಮಾಡಿದ್ದಾರೆ. One surety will manage, my lordship.
ಇದು A1 ದಾ?
A1.
Same order. The petitioner is accused number 2 is before the court calling in question rejection of an application seeking relaxation of the bail condition of production of 2 sureties. The learned counsel submits query the accused query the other accused. This court has passed the coordinate bench of this court has passed the following order. In that light, same order. Yes, next.
38.
Wait for time to file.
498A.
First is
Minutes.
DV, 38
Wait
is
for time to file.
38 is DV, 38.1 is 498A of family members, 38.2 is
right.
498 of husband. All the 3 are state.
Your entered appearance now, is it? Sandesh, ಇದಿರಲ್ಲ already.
The petitioner is accused number 1.
ಯಾವುದೋ ಒಂದರಲ್ಲಿ ಸ್ಟೇ ಮಾಡಿದ್ದೀನಿ. List the matter at the learned counsel appearing for the second respondent seeks 2 weeks time to file statement of objections. Objections, if any, by the next date. List the matter on 19th for admission. Interim order subsisting in any of these cases shall continue till the next date of hearing.
Steps has been taken, madam. Already taken, madam.
Learned counsel submits office, needful has been done, office to verify.
Vignesh Shetty maybe take notice for R2,
Yaru?
madam. Vignesh Shetty for R2 bank.
Learned counsel Vignesh Shetty is directed to accept notice for the second respondent bank. Registry to print the name of so and so as appearing for the second respondent bank.
Interim order maybe.
Interim order subsisting will continue to the next date. Next.
40. Move for withdrawal.
Moved for withdrawal. Kodi. Memo, in terms of memo, next.
Lord, with liberty, my lord.
But charge sheet, yes. 41,
41.
on compliance. 10
I
days time
appeal
is
for
granted.
I appeal
10
for the
days time
petition.
to file the office objections, finally. Yes, next.
42.
Withdrawal in terms of
Liberty maybe.
same. Memo ಏನ್ ಕೇಳಿರ್ತೀರಾ?
43.
Appear to the petitioner, please, Lords.
What is this 43?
My lord.
Batch matters.
My lord, this is a Mailarappa matter, my lord. where-
ಇಷ್ಟೊಂದಿದ್ಯಾ?
No, my lord. Serial number 43.5, my lord. WP number 16185 is not connected, my lord. It's not
16185
related to
not connected,
But by mistake, my lord, instead of we mentioning it as 16815, my lord, it was mentioned as in
Correct number ಕೊಡಿ sir.
correct number 161.
ಬರ್ಕೊಡಿ correct ಆಗಿ.
Yes, my lord, I'll write and.
Connected list ಅಲ್ಲಿ.
ಇನ್ಯಾವ್ದೋ ಬಂದಿಲ್ಲ ಅಂತ
Maybe
ಹೇಳಿದ್ರಲ್ಲ.
dealing-
ಏನಾಯ್ತು ಸೆಟಲ್ಮೆಂಟ್ ಟಾಕ್ಸ್? ಆಗ್ತಾ ಇದೆಯಾ?
ನಾನು ಹೇಳ್ತಾರ ಇದು ಡ್ರಿಲ್ಲಿಂಗ್
Council for the parties would submit talks of settlement between the parties are on. List the matter on 20th.
This may be dealing and one.
Dealing ಮಾಡಿ correct number ಒಂದು ಹಾಕಿ madam. Next. Interim order subsisting will continue to the next date of hearing.
Interim order may be extended in.
ಮಾಡಾಯ್ತಲ್ಲ. Yes. 44, 45 Axis Bank disposed. Next.
46.
Lots for the petition.
Office objections.
Apply the office objections. Lots say complaint has been registered against me for the under section 108 of BNS, my lords. Kindly come to the complaint.
So
my
what?
lords. Allah.
No, this is a fresh complaint. I asked the investigating officer to investigation report. Yes.
Atrocities Act invoke ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಪರವಾಗಿಲ್ಲ.
108
List the
natural
matter.
death ಸ್ವಾಮಿ.
Office objections, accepting the submission of the council overruled. List the matter on Tuesday, fresh matters list. Yes.
Lords, interim order, my lords, let them not take any coercive
Don't
steps
worry,
against-
we'll grant on that.
47.
Great.
My lord, 47, my lord, I appear for the petitioners, my lord. My lord, 2 days time for
RP.
compliance, my lord. Yes, my lord.
What?
My lord, GNWC, my lord, GMCPC matter, my lord. My directions has been issued, my lord.
Put up the matter immediately after compliance with the office objections. Next.
Please, my lord.
48. Petitioners, my lord. Short accommodation.
A week's time is granted to do the officer, do the needful. In the event needful is not done, the second respondent, interim order would stand automatically interim order, if any, would stand automatically vacated.
49.
ಏನಿದು ಅಲ್ಲಿದು ಬಾಂಬೆದ?
ಅಲ್ಲ ಇಲ್ಲ ಸರ್ ಮೈಸೂರು ಬೇಲಬಲ್ ಅಫೆನ್ಸ್ ಗೆ ರಿಜೆಕ್ಟ್ ಮಾಡುದು ಬೇಲಬಲ್ ಅಫೆನ್ಸ್ ಇನ್ ಆಫೀಸರ್ ರಿಗಾರ್ಡಿಂಗ್ ಮೇಂಟೈನಬಲ್
5 grams ಗಾಂಜಾನ?
53 ಗ್ರಾಮ್ ಗಾಂಜಾ ಬೇಲಬಲ್ ಅಫೆನ್ಸ್ ಬೇಲಬಲ್ ಅಫೆನ್ಸ್.
ಆಯ್ತು ಸರಿ ಒಂದು ನಿಮಿಷ. ಅಲ್ಲಿ ಬೇಲ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಬೇಲೆಬಲ್ ಅಫೆನ್ಸ್ ಅಲ್ಲಿ ಅಂತ. ಈಸ್ ಹಿಯರ್. ಪಾಸ್ ಓವರ್ ಮಾಡ್ಲಾ? 2:30 ತಗೊಂತೇನೆ. 2:30 ಕೊಡ. Yes, next.
Hearing on IA 50.
Vacating stay ನೀವ್ ಹಾಕಿದ್ದೀರಾ?
7A.
ನೀವ್ ಹಾಕಿದ್ದೀರಾ vacating stay?
Please.
List on 12th, 11th.
Oblige.
For list on 11th for admission. Objections vacating stay application stands overruled. List on 11th for admission. MH Prakash.
Please, oblige.
51. 51.
11ನೇ ತಾರೀಕು ಹಾಕ್ತೀನಿ. ಚಿನ್ನಪ್ಪ ಅವ್ರು ಇದಾರ? ಮತ್ತೇನ್ ಪ್ರಾಬ್ಲಮ್? ಏನಾದ್ರು ಮುಗಿಸ್ಕೊಳ್ಳಿ, ಇದು ಮತ್ ಬರ್ತಾನೆ ಇದೆಯಲ್ಲ.
Malats, what prayer they are asking in review, I am unable to apprehend, Malats.
I will highlight.
What is that?
Somewhere something is being
Sir,
struck.
no, what this honorable court is the.
ಅಲ್ಲಿ ನಾನು ಬರ್ದಿರೋ ತಪ್ಪು ಅಂತ ಇದಾರೆ ಅದಕ್ಕೆ.
I don't know what it is, ಎಲ್ಲಿ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ.
Point out, my lord. My lords will also agree with me.
Eh?
The error that has been.
He is asking for a substituted view. That is virtually.
Yes, please. My lords, if my lords may kindly take page 33. My lords, a common order was passed by this court in respect of 2 petitions.
Correct.
One was challenge, the other side had filed a modification application that Tahsildar should not be appointed and ADLR should be appointed.
ಹೌದು.
So far as that one petition was filed. The other petition was against the allowing of my application for appointment of court commission to evaluate the warehouse that has been put up by the plaintiff. Now, in that order, my lords, trial court has not appointed anybody as court commissioner. It was just allowing my application. Now, page 33 extract of the order is placed, my lord. It says.
No, my order is at page 21. What is wrong with the order, you tell?
The order appointed Tahsildar as court commissioner to conduct commission work. But trial court never appointed Tahsildar as the court commission. Now, because of this observation, it led to the passing of the final order, whereby my lords have held that Tahsildar will be is also appointed to assess the revenue.
Correct, that is my order.
Please, but trial court never appointed
I
Tahsildar.
have done it, sir, you leave it.
Because of this observation. my lords.
No, you forget about the trial court's order, it is my order.
Now, that is also contrary to this court's order, a clarificatory order. That is at page.
No,
30.
all that merges with this order.
My lords, page 30. For a moment, my lords would kindly see.
How long will you litigate on this very
Just on
correction? No, ಅದು ಇದು.
This one point, my lords. Page 30.
ನಿಮ್ ಪ್ರಕಾರ ತಪ್ಪಿದೆಯಾ ಇದು?
ಇಲ್ಲ.
ಇಲ್ಲ, ಯಾಕಂದ್ರೆ ಅವರೇ objections ತಗೊಂಡಿರೋದು in the very
ಅಲ್ಲ,
beginning.
ಏನಾಗುತ್ತೆ?
ಒಂದ್ ನಿಮಿಷ, ಒಬ್ರು ತಹಸೀಲ್ದಾರ್ ಅಂದ್ರಿ, ಒಬ್ರು
ADLR ಅಂದ್ವಿ.
ADLR. ಇಬ್ರು ಮಾಡಿ ಅಂತ
So far as that is concerned, I'm okay. But the second part regarding the valuation, initially it was their objection that single commission cannot carry out both the commission work, which is at page 30.
He has accepted this order now.
Yes, my lords.
Our objection all ಮಾಡಿದ್ರು, this is my order.
But it will be contradicting this court's earlier order is my submission.
That gets merged with this, sir, it is over. See, my order was on a particular premise, clarification ಕೊಟ್ಟಿದ್ದೆ. ಅದ್ರ ಮೇಲೆ court had passed certain orders. Again, you were before this court. On that, coming before this court, again, I have passed this order. Now, this is final.
That clarificatory order, why that is important is because there they had pointed that if at all commission work has to be executed for ascertaining where the Kaludar is, ADLR has to be appointed, and ADLR cannot carry out the commission work for valuating the property.
So,
Now,
the
that
other,
is
one
technically,
ನಿಮಿಷ,
I also
one
agree
minute,
with
sir.
that objection.
One is revenue, one is ADLR.
Survey.
One is who?
Tahsildar.
He will take assistance of people who want for
Yes, my lords.
Somebody from PWD department, because the valuation is for the cost of construction of the warehouse that has been.
He will take assistance from that.
But it
Cannot go on tinkering this order.
only difficulty is one objection or Tawambutre that he is not technically qualified. My entire commission report will be gone.
That objection he will not take, that's all.
My lords, yes, my lords, in terms of this order, if he executes the commission, I don't have any objection. That I may be permitted to cross examine, that's a different
This is
aspect.
different, cross examination I'm not saying. You
Technical ground ನಾನು
qualified-
ತಗೊಳಲ್ಲ.
ಆಯ್ತಲ್ಲ?
Technical ground
The
ನಾನು ತಗೊಳಲ್ಲ.
petitioner is before this court for the third time again, for on the score that the order passed by the concerned court has some error in it, which is apparent on the face of the record. After hearing both the parties, this court was of the opinion that to give a quietus to the dispute with regard to who should valuate the property or who should measure the property, the Tahsildar and the Assistant Director of Land Records were jointly appointed as court commissioners. The concerned court on the said order has now allowed the application, directing both of them to do the commission work and report to the concerned court. The apprehension of the learned counsel for the petitioner for which the review petition is sprung is that the respondent should not take the objection that Tahsildar is not technically qualified to evaluate the property. The learned counsel submits that objection based on this order will not be taken, but in the cross-examination, it is open for him to put questions. The cross-examination cannot be stalled by this court. The submission of counsel Sri Sinappa is recorded that is placed on record that he will not take objection based upon the order passed by this court.
Yes.
Takalva? Yes, passed by. With the aforesaid observations, the petition stands disposed, failing which the entertainment of a review petition will be hearing the matter all over again, which is not a permissible course that is available to this court in terms of the judgment of the apex court in the case of Kamlesh Verma versus Mayavati, 2013, 8 SCC, page 220. Yes.
That's one submission. Permission to take assistance from.
So that accordance with law, I said. Let me not be explicit. He will do it. Yes.
ಆಗೋದು.
ಈ ಆರ್ಡರ್ ಮೇಲೆ ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ತೆಗೆಯಲ್ಲ ಅಷ್ಟೇ.
Permission.
That will again be.
ಮತ್ತೆ ಇನ್ನೊಂದು ಲಿಟಿಗೇಷನ್ ಆಗುತ್ತೆ. That is in accordance with law, he is entitled to do it, sir.
52, 13%.
Humble submission, my lord. Party person, my lord. I am seeking to set aside the maintenance which is not been allowed by the lower court, my lord.
Right, we'll see. You come on Tuesday or Wednesday?
My lord, then 5th, my lord, 2:30 PM, kindly give time, my lord.
All right, 5th, 2:30 PM.
Fifth.
ನೀವು ಬನ್ನಿ ಮೇಡಮ್,
Sixth or any
ಪರವಾಗಿಲ್ಲ
other day.
ಬನ್ನಿ, ನೀವು ಆನ್ಲೈನ್ ಬನ್ನಿ. ಎಸ್
ಅಲ್ಲ ಅವತ್ತೊಂದು
Deeply obliged, my lord.
ಎಸ್ ನೆಕ್ಸ್ಟ್.
This is offense under 306 last time not said not should dictate. There is no proximity. I am a temple not trustee.
ಸ್ಟೇ ಇದೆಯಲ್ಲ,
Stay there.
ಡಿಕ್ಟೇಟ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದೆ, ಕರೆಕ್ಟ್, ಐ ರಿಮೆಂಬರ್. ಇದನ್ನ 4th ಹಾಕಿ, ವಿಲ್ ಡಿಕ್ಟೇಟ್ ಆನ್ 4th ಫಾರ್ ಅಡ್ಮಿಷನ್, ಪೋಸ್ಟ್ ಲೆಸ್ ದ ಮ್ಯಾಟರ್ ಅಂಡ್ 4th ಫಾರ್ WP ನ ಇದು
ಹೌದು
4th ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್.
Great. Tomorrow would be extended.
ಇದು ಪಾಸ್ ಓವರ್ ಮಾಡಿರಿ, 54 ಕರಿಬೇಡಿ.
Automatic extension.
54,
ಕರಿಬೇಡಿ ಅಂತ ಪಾಸ್ ಓವರ್ ಮಾಡಿ.
final hearing 55.
Petitioner is accused number 33, my lords, and all 40 accused persons.
ಇದೇನು ಇದು ಮೈಲಾರಪ್ಪ ಅಂತಿದೆ?
Yes, my lord.
ಅದು ಇದು ಬೇರೆನಾ ಇದನ್ನ?
Different. He's a PDO, Panchayat Development Officer, my lords. Lords, I received the information that, my lords, final charge sheet has been filed, my lords. I'll secure instructions and I'll make my.
2019 ಯಾಕೆ ಇಲ್ಲಿದೆ?
19 petition, my lords, there was an interim order was operating, my lords. Then, my lords, the honorable coordinate bench of the honorable court has modified the interim order to the extent that.
ಆಯ್ತು. We'll list it on ಯಾವತ್ ಮೇಡಮ್? 23. 7th. 17th.
My lords, it may be posted for admission, my lords, so that.
List the matter for admission on 17th.
Much.
Interim order subsisting will continue.
56.
This is a matter which is posted for dictating of orders.
Yes, Amala.
Third, detailed written arguments have been already put forth, Manoj, may be reserved.
Seriously?
1 year before, Manoj, have put arguments.
Third reserve, yes.
Grateful, Manoj.
57.
ಇದು list on 17th.
Not appearing.
ಏನಿದೆ ಇಷ್ಟೊಂದು?
Lords, a series of complaints relating to the same transaction, Lords. Lords, one apartment I purchased from one Veena Narayan. This Veena Narayan happens to have some relationship with one of the retired officials of the police department, Omkaraya. So that is where the entire problem starts. Lords, the first of the complaint was registered by me after the purchase of the apartment. Lords, I was.
ರವಿಶಂಕರ್ ಸರ್, ಒಂದು ನಿಮಿಷ. ಇದು ಎಲ್ಲ ಕ್ರಿಮಿನಲ್ petitions ಅಲ್ವಾ?
All criminal petitions.
We'll post this for admission, release it from further hearing, post it for admission so that it comes at the top and finish it off.
Very well, my lords.
On a particular day. ಯಾವ ವರ್ಷದಿದು? ಎಲ್ಲ 23, 24 ಅಲ್ವಾ?
23, my lords, all 20.
All 23.
Yes.
List them all on 10th for admission.
Lords.
We'll close it on that.
Lords.
Release the matter from the status of being part heard. List the matter. ಹೆಂಗು ನನ್ನ ಮುಂದೆನೆ ಬರುತ್ತೆ. So list the matter on 10th for admission.
Lords.
So that we can close. Yes.
Obliged.
Rajat, where are you?
Please, my lords.
Yes.
I'm well.
All right.
My lords, I appear for the petitioners. I pray for 2 weeks of time, my lords.
ಇದು ಹಿಯರಿಂಗ್ ಹಾಕಿದ್ದು ಮೇಡಮ್ ಇವತ್ತು. ನೋ 2 weeks time. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆರ್ಡರ್ ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದೀರಾ, ಮತ್ತೆ I can't.
Senior counsel KG Raghavan sir has been handling this matter.
He's not back, is it?
Not yet.
When?
So anytime after February 11th.
Oh, seriously? We'll talk to Raghavan sir then. ಬಂದಾಗ ಕೇಳ್ತೀನಿ ಏನ್ ಇಷ್ಟು ಹಿಂಗೆಲ್ಲ ಅಂತ. Yes. List the matter on 11th, 13th February.
Please, great, my lords. See.
It's made clear no further adjournment would be granted in the matter.
59.
To the appellant,
Ah,
being
for the
led by Mr. Raghavan, there is a small medical emergency.
Raghavan sir.
Mr. Srinivas Raghavan.
Srinivas Raghavan, all right.
Some medical emergency in his family this morning. Any convenient date, my lords,
Then
we are ready
we'll
to.
take it on 13th. No further adjournment.
We are ready to go on, my lords.
ಮತ್ತೆ?
As Mr. Given the circumstances.
List on 13th.
I'm obliged, my lords. Great.
This matter actually, my lord, had already heard
and
ಹೌದು.
directed us to file written submissions.
ಹಾ.
Written submissions ನಾವು file ಮಾಡಿದೀವಿ ಇದರಲ್ಲಿ. After the written submissions were filed, my lord, the petitioner counsel has changed.
ನೀವು ಮೂವ್ ಮಾಡಿದ್ದ ಆಮೇಲೆ?
ನಾನ್ move ಮಾಡಿದ್ ಸ್ವಾಮಿ. Because this matter, my lord, pertains to the declaration of Islam.
All right.
Week's time, my lord, I'll file my written submissions.
ಇವತ್ತು ನನಗೂ ಟೈಮ್ ಇಲ್ಲ. We'll do it. Yes.
My lord may also see the written submissions are already on
No
record.
problem.
We were directed to file that.
We'll just hear him and then pass.
Please,
Yes. We'll take it on 24th ಅಲ್ಲ?
please, my lord.
GM?
GM.
And this pertains to a slum, my lord. There's
Slum
an
area.
interim order operating against the slum.
Oh, yes. List the matter on Tuesday ಆಗ್ಬೋದಾ?
Please, my
1
lord.
week.
10th ಅದೇ.
ಆಗ್ಬೋದು.
10th February.
Great.
10th February at 2:30 PM.
Great.
Yes.
2:30. Grateful, my lords.
So,
My lord,
Atrocities.
there are two cases, my lord, in this. The first one, there's a charge sheet that has been filed, which has been challenged. Second, my lord, is an FIR. In the first, my lord, I've gone through the entire charge sheet. I've also placed my objection. The first one, in fact, my lord, my very humble submission would be this. Firstly, the respondent number 2, the kind of injuries that he has suffered. He has suffered.
482 ನಾ ಇದು? 482 ನಾ?
482.
First stay ಆಯ್ತು ಅಂತ second one immediately refer.
And the second.
List the matter on 11th, madam ಇದು? 24 ಆದ್ರೆ? List the matter on 11th for preliminary hearing. Release the matter from status of being part heard.
Please, my
482 ನಂಗೆ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿ. 482.
ಹೌದು 2
ನೋಡಿ ಮೇಡಮ್, 482 ಇದ್ರೆ ಮಾತ್ರ.
482.
On so that it will come in the top.
Please, my lord. On 11th, my lord.
11th.
Grateful.
Interim order make.
Interim order will continue. Next.
62.
This matter may be had on 13.
Indranagar.
Petitioner.
Yes.
13 respondents.
Both Indranagar and Kormangla.
Indranagar and
ಉದಾಸ್ ಕಣ್ಣೂರ್ ಸರ್ ಯಾರಿಗೆ?
ಬಿಡಿ.
ತಮ್ಮದೇ ಒಂದು ಜಜ್ಮೆಂಟ್
ಗೊತ್ತು, ಇದರಲ್ಲಿ ಸದಾಶಿವನಗರ.
ಸದಾಶಿವನಗರ ಕವರ್ ಇಟ್.
ಆಯ್ತು, ವಿಲ್ ಸಿ. ಎಸ್. ಸೀನಿಯರ್ ಎಲ್ಲಿ?
Senior seats to VC.
ಅನ್ಮ್ಯೂಟ್ ಸರ್.
I appear for the petitioners, Miller. Sorry, Miller.
Yes, sir. ಇದು 13th ತಗೊಳ್ಳೋಣ. Raghavan sir is not in complaint. Yes.
Very well.
List on 13th.
Very.
Interim order, if any subsisting, will continue to the next date of hearing. Yes. Okay.
63.
Sorry, delayed by 27 minutes.
Please, my lords, justice flows from this honorable court.
Yes, sir.
Any
From
minute.
this institution itself is
One
from that.
minute, my lords.
Yes.
Justice flows. It is not only to the councils, to the parties, to the cases.
Yes, sir. Advocate General Sahib ಯಾರಿಗೆ? State.
Oh.
Yes, sir.
Please, my lords.
I have heard you in extenso.
No, my lords, what I shall do is like this, my lords.
Yes, sir.
In limit, whatever the time my lord allots, that will be the final time for me. And just 2 or 3 minutes, in one sentence, whatever I have stated earlier.
Recap.
In 1 or 2 sentences, not beyond that.
Yes, sir.
Only a point, sir.
ನೀವು ಇದೆಲ್ಲ ಹಾಕಿದ್ದೀರಾ?
We have filed the objection as well as the judgment compilation, Manoj.
Perfect.
I also filed the judgment compilations in this case, and notifications issued by the government also by separate compilations. I have given it.
Yes, yes.
The copies to my learner friends also.
Yes, yes. Yes, sir.
The first point which I pointed out is regarding the notifications which have been issued on only single day. My lords, one question I will pose myself to the effect that what will be the prejudice that is going to cause to the petitioners as such. My lord may kindly see that it is not a case of one person. 15,000 to 20,000 people will be displaced. I'll explaining the word displaced a little later. Are being displaced in this case as such. Under such circumstances, with due respects to the authorities, without application of mind, they have issued the 3 notifications on a single day. The words which have been used under 1(3) is application of chapter number 7. That word is not available. Then under section 3(1), application of the area. This area is required for the purpose of industrial area. Under section 28(1), this particular land is required for the acquisition. If all these three words, consciously the statute has made a distinction at the different levels, and without making any distinction between these words, by copy paste orders.
ಇಲ್ಲ ಇಲ್ಲ ಅದಲ್ಲ ನನ್ಗೆ
No, Manish, I thought if I'm causing.
no 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 ಅದಕ್ಕಲ್ಲ
By copy paste.
no no you can to use that
by copy
I
paste.
have this problem vertigo yes.
By copy paste orders, if such an order is being passed, I call it as a non-application of mind is number 1. Number 2, my lords, it suffers from legal malice in the sense that a huge extent of a land, you have got a power. I don't say that government has no power as such, but the citizens are also required to be safeguarded under the constitution. If you wanted to take away the rights of a citizen in such a way, that is impermissible. Therefore, my lords, I have used the word legal malice. The word legal malice has been used for a different purpose also here. My lords, approximately about 1.5 crore rupees per acre is the land which these people are going to give us, approximately.
ಓ ಫಿಕ್ಸ್ ಮಾಡಿದ್ದೀರಾ
My lords,
ಆಯ್ತಾಯ್ತು
in respect of some other lands, I mean, it's a huge extent.
ಆಯ್ತಾಯ್ತು
Total, my lords, since that question has arose, totally about, according to them, only 5,000 acres they are acquiring it. Out of that 5,000 acres, these notifications, these 10 notifications is about 3,700 acres of the land. And so far as the petitions before your lordships are concerned, only 3 villages in this batch, my lords.
3 petitioners
No, 3 villagers, 3 villages. No, about 6 or 7 petitioners are there. Totally 10 petitioners or 11 petitioners are there, my lord. So, I'll answer that point, particular point. So, these 3 villages are included in this writ petition as such. But
Only one village, I think.
3 villages. Sir, totally 3 villages are there, sir.
Extent is that.
No, sir, 3. Advocate General, connected matters are there, sir.
ಅಲ್ಲ
Connected matters.
5 ಮ್ಯಾಟ್ರ್ ಇದೆ ಇದು ವಿಲೇಜ್ ಬೈ ವಿಲೇಜ್ ಎಸ್
Give it to understand.
No. All the 3 are connected.
ಆಯ್ತಾಯ್ತು
So legal malice, that's what one. In respect of certain negotiation, in respect of other lands, that's 1.5 crores or something like that. 4 crores, 5 crores like that. And my lords, it is on record, which is not known to me, but it is on record. They are offering these lands at the rate of almost 6.5 crores.
Who is offering?
To the beneficiaries. To the beneficiaries, my lord. They are not here before this honorable court. The proposed persons who wanted to, who are getting these lands for the purpose of industrial areas, they are offering at the rate of 6.5 crores. I call it as they are doing a business better than a legal real estate agents as such.
KIDB.
Government. I'm using the word KIDB and more particularly the government because they are under the control of the government ministers as such.
Yes.
And I should not, no, I don't want, I will not touch that aspect. I'll not touch that aspect. Yes. Because unnecessarily. Let's restrict to my pleadings as such. So, this is also, according to me, this is also a legal malice. These are the page number, para number 45, I have taken up this particular ground as such is concerned. Then, my lords, coming to one more, the next point which I wanted to place for my lord's kind consideration would be non-consideration of the objections. My lords, at annexure V. A detailed objection statement has been filed.
Correct.
And-
Page 132.
And continuous annexure W series is another one. The various owners also had given it. And I'm not reading what are all the important, just I'll draw my lord's attention to page number 132 only. How many annexures I have attached along with that?
Yes, sir.
I have attached so many annexures. Here, my lords, I have questioned regarding the land falls within the TG Halli catchment area. So Arkavati river is there, Kumudvati river is there. And for this purpose, my lord, the MPRI has already given a report. That MPRI report, the consolidated statement of the MPRI, it is in 4 volumes. Consolidated statement I have submitted to the authorities. Apart from all these things. And how that objections have been considered.
ಏನ್ ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ ಮಾಡಿದ್ದಾರೆ ಒಂದೊಂದು ತೋರಿಸ್ಬಿಡ್ತೇನೆ.
Page.
Please. Page 307.
307.
One, please. And then send a note system.
Objections ಹಾಕಿದ್ದೀರಾ? Readings are complete. This is that Queen City, na?
Send a note.
Queen City.
AL, page number 307, 330. Volume 2.
ಇಲ್ಲಿದೆ. 307. Yes, sir. AL.
The same 310 also, my lord may kindly see.
Yes.
This order was used, copy paste, which is available on page number 314 and 315 once again.
ಇದು ನಿಮ್ಮ objections, petitioner's objection.
Allah, objections Allah. This is the order that has been passed.
Allah, order on the objection.
On the objections. Cut and paste order. And not even one grounds are touched. Not even one grounds are touched. And they said that these lands are the dry lands. I have produced before this honorable court, and even in their note it has been there. The coconut, arecanut, banana and other things are there. These people have not visited, otherwise, even if they don't want to look these things at all, sitting in an office, they could pass such type of an order. This is now, my lord. This takes away the right of a citizen to hold the property.
Article 300A.
Then, my lord, the right to life is also being taken away by these people.
Article 21.
21. And my lord, in this context, without explaining too much about it, one particular paragraph which judgments, that particular judgment. I have relied upon the 3 judgments.
Yes, sir.
I have relied upon the 3 judgments, my lords. In this case, citations I had passed on to my.
Yes, it's here, sir. It's here. Yes, sir.
By PH Raj, if I'm right.
Ide. Yes.
3 judgments are.
Yes, sir.
Surinder Singh's judgment.
Correct.
It is available at serial number 1, my lord.
Yes, sir.
my lords, without reading, because I have to, meant,
No, I will go through it. Don't-
and that's what, my lords, I don't want to read because this honorable court, I know how much pain it takes it. Paragraph number 68, 70 and the 71. It speaks about they have to independently and objectively with due application of mind consider the objections. These are the words which have been borrowed from the same judgment as such. And personal hearing has to be given.
Yes, sir.
And here, my lords, there is a one more judgment which is at Vinod Kumar's case, 2014, 3 SCC page number 203. Relevant paragraphs would be 10, 11, 12 and 13.
Government should independently apply it.
Apply.
Yes.
My lords, there's a one more word which is, I feel it, I should bring it to the notice of what the Supreme Court has said. The only umbilical cord that is available between a citizen and the government is Section 5A of the Original Land Acquisition Act, otherwise the 28(3). Otherwise, my lords, it is an illusory right. And right to life itself would become an illusory in the hands of the authorities. So this umbilical cord is the only thing. It is not that mere formality. Just now, I have used the one more word, my lords. It's a right to life. Article 21. I have used it. They may say, otherwise, I have not touched the dwelling houses. I mean, a proper village and the surrounding areas. If you can take away all the lands, what is that the right to life you are going to give it to those people? This is not that one generation. Generations to generation, this particular people, the citizens are enjoying these lands. You are taking away. My lords, here, there is one more principle I intended to bring it to the court's notice. Intergenerational equity and the protection of the environment has to be maintained by the court. Intergenerational. On this particular principles, my lords, the three judgments, I am placing it.
Ninety-five six SCC 3.
My lords, 95(6).
Para 40, 42.
Please, my lords. And 2009, 6 SCC page number 142.
MC Mehta.
Please.
Para 45, 46.
Please, ma'am. And then, my lords, there is one more judgment of Vanashakti. That is available. Vanashakti is available. It is at serial number 11. Well, lords, here, actually, that particular paragraph in my notes, actually, I have not mentioned on the intergenerational, but I can bring it to my kind notice. It is available on page number 300.
Paragraphs?
30, 31. Please, madam. 31 and 33. Having, I need not. Para number 31, my lords, just one word, one sentence, just I'll read it. My lord may not open it, my lords, I'm confident.
Yes, sir.
Courts have consistently insisted upon the protecting the environment and consistently and held that natural resources are held in trust by the present generation for the future generations. Therefore, my lords,
natural resource nimden bantu.
The land itself is the land itself is the natural resource.
Sir, if that is taken note of, no acquisition can take place.
No acquisition, natural resources in the sense, my lords, we have to take note of it, from where they can acquire it, what for they can acquire it.
Unnatural,
lords, can you
acquisition of
imagine?
unnatural resources, only natural resources.
My lords, this is the whole land, my lords, according to me,
It's a natural resource.
These particular lands are the natural resources. If you people take away, what else the people can grow and what else the people can, what is that intergenerational? In this context, my lords, the observations of Sham Diwan
Yes, sir.
in that particular book, two lines I shall read it from. Oh. Page number actually, I shall state that page number 184 to 188. Page number 184 may kindly be.
Environment law and policy making.
That's page number 185, paragraph number 3, my lord. The litigation concerns the environment. A great American judge, emphasizing the imperative issue of environment, said that he placed the government above big business. Kindly see. Government above big business. Individual liberty above government. Environment above all.
Yes.
Well, based upon these particular points as such is concerned, and I have produced the photographs.
Photographs I saw. Lot of photographs I saw. Coconut and areca.
I think, well, it is the aerial views, not only my land, otherwise, even the aerial views also I was able to produce it. And there's one more notification, my lords, that I'll draw the attention of the court. Annexure Z1, page number 195, last page in volume number 1.
Yes, sir. Yes, sir.
Well, last page in volume number 1.
Yes, I'm
map
there,
it.
Yes, sir.
It gives the two rivers, two streams.
That is one TG Halli.
TG Halli. And these lands are very near, within that catchment areas.
Yes. Yes, sir.
Now, the Emperor report and the other writ petitions and the government is also being directed to maintain and to improve the TG Halli. Earlier, my lords, the whole Bangalore was being under the...
Correct.
And even in 1978, 80s and up to 1990, 1/3 of the Bangalore is being fed by the TG Halli. Being a resident of Rajajinagar, we are supposed to use the TG Halli till almost 95, 96 as such.
Yes, sir.
So this TG Halli has to be preserved. And by taking 5,000 acres of the land, how are you going to maintain?
That is their headaches.
It is not their headache, my lords. It is a headache about the citizens as such. I am here on behalf of a citizen. My lords, they are interested in 6.5 crores. They are not interested in anything beyond this.
6.5 crores.
They are interested in 6.5 crores. I am underlining these words.
The board is interested only in that.
Oh, government is interested only in that. Under the guise of this type of notifications, otherwise acquisitions, and how they are fighting each other within the ministry. I am using that within the ministries. Two different departments of the government are claiming it belongs to me. It belongs to me. That is not my concern, but it is how the records speaks. So it falls within the
You filed your written submissions also.
Please, man, my mind. That's one more important point. My lords, only I am touching the points as such.
Correct.
One more important point. I had submitted to my lords this zonal regulations.
Yes.
By
It's here.
separate.
Yes, sir.
My lord got that.
Page 48, yes. Of this. Zone regulations, page 48, notifications.
No, my lord, the first one I'm depending upon.
Environment.
EIA notice.
EIA. all right.
EIA.
Copy ilva?
But
ಆಯ್ತು ಕೊಟ್ಟಿದ್ದಾರೆ ಎಸ್ ಎಸ್
I must have served the copies also.
Yes, ಈಗ
If not, one more copy I'll.
Yes, sir, you continue.
Where's paragraph 2? It is their contentions that EC, environmental clearance, is not required for the purpose of this township development. That is their contention. In their objection statement also they have taken to that contention. And which I will demonstrate it according to me would be, it is inaccurate stand taken. Let's read paragraph 2 and then I can read to paragraph number 6 and 7.
Yes, sir.
Application 6, I shall read it, madam. Application for prior environmental clearance. An application seeking prior environmental clearance in all cases shall be made in the prescribed form number 1, annexed herewith, and supplemental form number 1A, if applicable, as given in appendix number 2. After these words is important, my lord. After identification of the purpose of the site for the project and or activities to which the application relates before commencement of the area. So, after identification, therefore, my lords, in Krishnamurthy's case, the Kenchappa case and the Krishnamurthy's case, which I have quoted it, I shall read that, bring the court's attention to that
Yes.
particular paragraphs also.
Yes, sir. Paragraphs I'll see.
Only, just I shall refer, I need not read it, my lords.
Kenchappa at serial number 9. Krishnamurthy at serial number 10.
10.
Para 75 to 100, they are 36 to 39.
Please,
Yes,
please.
yes.
See, in these cases, they have identification, especially the other side is relying upon the Krishnamurthy's case, which is at serial number 10. The paragraph number 100 is more important. What the Krishnamurthy's case says is, what is required is the identification of the land for the purpose of environmental assessment and environmental clearance. What is required is only that much. For this purpose, you need not go for the final notification. If at all, I mean, I'll explain that case. If at all you require, you just identify the land. Preliminary notification is sufficient for you. Then you go for the environmental clearance or the environmental assessment. Assessment report.
Environment impact assessment.
Impact assessment. Environment. Even as on today, we are in the January or the February 2026. The final notification has come in the month of May 2025. Even as on today, they don't have the impact assessment. Even as on today, let them produce it. They have called for the tender. Tender for what purpose? To comply with the requirements. Only to comply with the requirement. Requirement is to fill up the form because it requires expertizations. Probably they may require. So, identification, only for the purpose of identification it is required. And while I'm commenting upon the Krishnamurthy's case, one more thing I should bring it to the court's notice. Without reading it, I'm making the submission. A Krishnamurthy case is regarding acquisition of a land for the national highway purpose. So, in the national highway purposes, it falls within the category A. So, they are required to do so. You cannot avoid. The national highway is the one. It just passes through. It is not that the whole land will be taken away. A strip of a land is being taken away.
Here the whole land is taken.
Here the whole land is. And even in the strip of a land while they are being taken away, the Supreme Court has said that
Environment impact assessment should be there.
not impact assessment and environmental clearance. So I was reading this para number 6. Furnish along with the application a copy of the pre-feasibility project report, except that in case so and so. This one, then I can bring to my lords para 7, stage 1, paragraph 1. Well, after 4 lines in that, I'll reduce the reading also. In stage 1 screening, after 4 lines, in the 6th line, the projects requiring an environment, kindly see these words are 6th line, the project requiring an environmental impact assessment report shall be termed category B1. I am underlining these words. Why this shall be termed into category B1? Now, there the B is there, the B1 is there. We'll skip all those things. I can straight away bring to page number 18.
Yes, sir.
8B. 8B. Township and the area development projects, according to me. If it falls, actually I wanted to drive them to the para number 7, the column number 7.
Even there it is required.
My lords, if it is there, it has to be from the central government. If it is from here, at least from the state government authority, they require it, and pollution control board, they require it. And they require a B1. Now, this notification has been amended. That amendment I have produced on page number 45. Then it comes to page number 46. It has been called out. The amendment, that amendment has taken place on the 29th January 2025. And here they have made it more abundantly clear on page number 47. A project of a township, area development projects covered under the item shall require an environment impact assessment report and be apprised as category B1 project, page number 47.
Yes, sir.
My lord. So, now, if I'll not read their objections, but I'm stating it, I underlined those words also, my lord. What they claim is, whenever we construct building, whenever we go for the construction, that time we will take the environmental assessment. But exactly this question was posed in Krishnamurthy's case in para number 100. And they said that either in the KIDB Act, there is no such provision. This is important from my point. There is no such provision wherein you can withdraw the notification. You can drop the acquisition. So, if you don't get, let us assume a condition. You don't get an environmental clearance. Then what would happen? You are taking away the right of a citizen, the land, and you are getting the land. Therefore, my lords, under the Krishnamurthy's case in para number 100 and 103, the court has said that you maintain the preliminary notification and not for that, and it has said so. And in Krishnamurthy's case, incidentally, the preliminary notification was challenged, and in Kenchappa's case, the final notification was challenged, and the notifications have been set at not in Kenchappa's case, and preliminary notification alone is ordered to be maintained, and they should go for environmental clearance. One more point so far as the national highway case is concerned. There is a provision under section 3D of the National Highway Act, wherein if the acquisition is not completed within a period of 1 year, the acquisition lapses. 3D is there. Therefore, my lords, by exercising the power under Article 142 of the Constitution,
That is 21(7), National Highways Act.
my lords, what the Supreme Court said is that even your application is pending for consideration for environmental clearance and assessment report, it could be treated as stay. It was because, my lords, because the court intervention is being protected under the act, but this environmental assessment pendency was not protected. Under article, the court said under we are exercising a power under 142. To that extent, only to that extent, we protect it. But you should obtain it before you go for the final notification. That's the.
All right. We'll hear the Advocate General.
Another one or two points. I'm concluding it, my lords.
Oh, yes, sir.
One more. So far as the same notifications are concerned, my lord, may kindly turn to page number 3 notifications. I have produced it regarding page number 48. I'll not take the only just drawing the attention.
Correct. Zone regulations.
Zonal regulations are there.
I've seen that.
Then, my lords, this notification, they are depending upon this notifications. Then, my lords, by the next notification dated page number 54,
yes,
it has been withdrawn.
Yes.
It has been withdrawn. So, zonal, these protection is required, and there is one more writ petitions are pending in that another division bench matter. I'm not taking a shelter, but it is all those matters are still pending. Then one more notification, they have issued it in 2021. We wanted to implement.
Yes.
But one effect, what happened? What happened? This is how sometimes the litigation is being used, otherwise the government orders are being used in a different way. Lot of writ petitions were pending in respect of about 142 writ petitions. In respect of buildings, they have been constructed in the area of that TG Halli and Arkavati. And some of the authorities at that stage, they have issued a notice to demolition it. Because of the intervention of the government, I'm using that word, intervention of the government, they have withdrawn that 2003 notification. Once that the 2003 notification has been withdrawn, what happens is the notices for demolition becomes infructuous. All those writ petitions came to be closed. Only the one writ petition is still remaining it, but all those writ petitions to be closed. And the injustice that has been caused to the Mother Earth has remained intact. The construction of the high-rise buildings, few of the high-rise buildings, which they wanted to, the authorities wanted to demolish it, because, it's the effect of it. How the litigations have been used or the government notifications are causing damage to the Mother Earth as such is concerned. Therefore, this. Then there's one more thing, my lords, which I can just use another 1 or 2 sentences here. The difference between environmental impact assessment report and the environmental clearance is required. It is a impact assessment is detailed study and analysis of the project's potential environmental effect is concerned. What is that the detailed study they have made it? I have produced that, they have produced that annexure R1. AI generated photo. My lord has just seen it. AI generated. Something like a New York, something like a New London, this and that. So I don't want London here. I want my villages. Well, this is all the things. And one more, well, we cannot close my eyes. MSPL case they have wanted to defend. See, MSPL case is the one which refers to the couple land acquisition is concerned. My lord knows that the learned single judge has dismissed the writ petitions. Incidentally, the division bench of this honorable court has allowed the writ petitions.
Incidentally, actually,
it has allowed the writ petitions. The matter went to the Supreme Court. It has reversed it. Almost 25 plus years have been lapsed now. Even they cannot start the business there. The life of lakhs of people is being affected. There about 120 acres are less than about 500 acres of the land is there.
5,000 acres.
Only 5,000 acres is there.
Nimdu ಎಷ್ಟು ಎಕರೆ ಇದೆ ಟೋಟಲ್ ಎಲ್ಲ
well, my lord, for the present it may come some
out of the 5,000 acres.
No, I'm giving it.
These petitioners ಎಷ್ಟು ಎಕರೆ ಇದೆ?
ಅದನ್ನೇ ಟೋಟಲ್ ಆಗಿ ಹೇಳ್ತಾ ಇದ್ದೇನೆ. 60 acres. 45 plus 10, 55, 56 acres or 58.4 acres, my lord. My lord, the petitioners, hundreds of the petitioners would have come before this honorable court. I'm making official statement. This honorable court has observed. This honorable court has observed and put me on a guard.
ಎಲ್ಲರೂ ಬರೋದು ಬೇಕಾಗಿಲ್ಲ.
ತುಂಬಾ ಎಲ್ಲ ಲಿಟಿಗೇಷನ್ಸ್ ಆಗೋದು ಬೇಡ, ತುಂಬ ಬೇಗ ಮುಗಿಸ್ಬಿಡೋಣ ಇದನ್ನು ಅಂತ.
ಈಗ ಮುಗಿಸ್ಬಿಡೋಣ.
ಇಲ್ಲತ್ತು ಅಂತಂದ್ರೆ 100 ಕೇಸುಗಳನ್ನು ಬಂದಿದ್ರು. Financially, the office could have been benefited it. But I have taken the words of this honorable court and said and advised the parties, no, the court wanted to hear the matter. Let us not bulge with the records. So under such circumstances, my lords,
Advocate General,
oblige.
Yes.
And some time for the purpose of Monday or Tuesday, not beyond that Tuesday, I'll file my written submission. Monday or Tuesday.
I'll hear him and reserve it. You can file your written submission, not a problem.
That permission, only 2 days time I require.
No problem.
Oblige.
Your written submission.
I'll just file his written submission by Monday, Manoj. Few questions which my learned friend. Manoj, in every land acquisition case, Manoj, understand, Manoj, the grievance of the landowner, Manoj, is nothing but natural, Manoj. What your lordships will consider is, Manoj, whether acquisition is for industrial purpose or the purpose under and whether the procedure under the act has been followed, Manoj. As pointed out, Manoj, out of 4,500 acres, Manoj, what the subject matter before your lordships is only around 60 acres. First principle, Manoj, when large extent of land, if minuscule court has said 1/10 of judgment, I mean, your lordships are aware, Manoj, court should be slow. Ultimately, Manoj, the whole purpose of this is, Manoj, for development of knowledge. This is the knowledge and something like smart city in Gujarat, Manoj. We have gift city in Gujarat, Manoj, where we sought to acquire all education institutions, all this, give them land for the purpose of development, Manoj. So object is in keeping in mind of the act, Manoj. Then, Manoj, insofar as what may learn in other issues, environment clearance as well as environment impact assessment, Manoj. The lordship may kindly say annexure R2 to R8, Manoj. What we have sought to produce is, we have it's not a precondition is what is required, Manoj. It is subsequent to Kenchappa's judgment as subsequently diluted in Krishnamurthy's case, Manoj. That's my first submission. Your lordship may kindly take the citation, Manoj. I'll just, the first principle, what I want to say is, Manoj, the environment clearance in terms of 2006 notification is required to be obtained before commencement on the building, work is done. So therefore, my lords, the question is, once it's still premature, my lords, possession has to be taken, award has to be passed, allotment only after that. By then, my lords, we will get all the clearances. Only after that, your lordship may make it clear, my lords, no development unless without this clearances, my lords. That is a condition precedent as laid down by the Supreme Court, my lords. And again, development and environment has to go together as the next principle, my lords. Then, my lords, the question with regard to 28(3), my lords, your lordship may kindly see the grounds in all these applications. Ultimately, my lords, your lordship, the grounds urged in while filing objection on 28(2) is there are trees which are growing fruits bearing tree. That those are and they're required for their family maintenance. These are general objections which are filed by every landowner. Keeping view that in mind, and the object of the acquisition, your lordship will consider whether it's a case with no special circumstances which requires the land to be denotified, my lord. So therefore, they have not made out a case for denotifying the or dropping the land in question, because this comes in the middle of the whole project, my lord. We have produced a sketch also to show. Therefore, my lord, to say either and last coming to Tipukunalli, what they say is we are doing in terms of zone 4, industrial permissible activity under the zone 4, we are carrying on that activity. So therefore, it is not violation of this notification also. Then once a land is declared as an industrial area, in view of section 47, that ceases to be industrial, that continues to be industrial area, the activity permitted within that industrial area can be regulated. These are my submission for your lordship's kind consideration.
Written submissions ಹಾಕ್ಬಿಡಿ.
I'll file that.
ನೀವು ಹಾಕ್ಬಿಡಿ sir. Heard the learned senior counsel Nargund appearing for the petitioner and the learned advocate general appearing for the response. State of board I have sir.
Board minutes.
But to the board, judgment reserved. The parties are permitted to file the written submissions in the next 4 days.
This, in fact, your lordships have dealt with most of this issue in the other connected matter, including section 28(3), my lord. I think that will
get out. ಹೇಳಿ sir.
Because there are other interpretations wherein the, what you can say, advanced technology of seed growing, agricultural industries are also available in some of the
28(1)
connected interpretations. I have produced the material for that.
Yes, yes.
Well, just one other aspect which is not part of the compilation is one of the arguments, section 13, 28(1) and has been issued together, 1331 and 28(1).
ಹೌದಾ ಅವರೇ ಕೊಟ್ಟಿದ್ದಾರೆ.
So there.
Sir has referred everything and answered everything.
So that's why my argument was brief.
Yes, exactly.
Only one line that
Yes.
Well, in fact, all acquisition, the purpose of each notification is different. Identifying the industrial area, then 28(1) is only preliminary notification. 28(1) cannot be issued without 13 or 31.
Okay, we'll see. Yes. Madam.
Court officer? Court officer?
ಹೇಳಿ ಸರ್.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 64 ಇತ್ತು.
ಮಧ್ಯಾಹ್ನ.
ಫಾರ್ ಸೆಟಲ್ಮೆಂಟ್ ಇತ್ತು ಮೇಡಮ್ ಅದು. ಮಧ್ಯಾಹ್ನ. ಓಕೆ.
Court officer least 2.
Post lunch.
Okay, thank you.
ಇನ್ನೊಂದು ಕೊಟ್ಟಲ್ಲಿ ಅಂತ.
crores. 11 crores gold was from where? From here? From your premises, sir. Huh. Sixth richest person. ಈ ಪ್ರಾಬ್ಲಮ್ ಏನಾಗಿದೆ ಹೇಳಿ ಸರ್? ಅಷ್ಟಕ್ಕೆ 11 crores ಗೋಲ್ಡ್ ಎಲ್ಲ ಹೇಳ್ಬೇಕಾಗಿತ್ತ? ಡೇಟ್ ಕೊಟ್ಟಿದ್ದು ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳಿ.
Third memo, my lords, maybe taken up on Tuesday.
Monday
71 years old, my lords.
ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರಾ?
Fresh man. Tuesday, my lords.
ಗೊತ್ತಿಲ್ಲ. ಕಮ್. ನಿಮ್ಗಿಂತ ಮುಂಚೆ ಮೆಮೊ ಕೊಟ್ಟಿದ್ದಾರೆ.
Third memo.
ಬರ್ ಆಯ್ತು.
Not come on.
10th ಮೆಮೋಸ್ ಆರ್ ದೇರ್. Yes.
2020.
ಮಂಡೇ ತಗೊಳ್ಳಿ. ಮಂಡೇ ತಗೊಳ್ಳಿ.
ಮಂಡೇ ಆಗಲ್ಲ. ಮಂಡೇ ಲಿಸ್ಟ್ ಬಂದ್ಬಿಟ್ಟಿದೆ ಆಗ್ಲೇ.
ಟ್ಯೂಸ್ಡೇ ಹಾಕೊಳ್ಳಿ ಸ್ವಲ್ಪ ಅರ್ಜೆನ್ಸಿ.
ಏನ್ ಬೇಕು ನಿಮ್ ಗೋಲ್ಡ್ ವಾಪಸ್ ಬೇಕಾ?
ಸ್ಟೇ ತಗೊಳ್ಳಿದ್ರಿಂದ ನಾಟ್ ಇನ್ವೆಸ್ಟಿಗೇಟಿಂಗ್ ಮೆಲರ್ಸ್, ರಿಕವರಿ ಆಗಿಲ್ಲ ಗೋಲ್ಡ್ ಅಂಡ್ ದ ಬೇಲ್ ಲೋವರ್ ಕೋರ್ಟ್ ಹಸ್ ರಿಜೆಕ್ಟೆಡ್ ದ ಬೇಲ್ ಮೆಲರ್ಸ್. ಇಲ್ಲಿ ಸ್ಟೇ ತಗೊಂಡಿದ್ದಾರೆ ಮೆಲರ್ಸ್. ಆ ಸ್ಟೇ ಇರೋದ್ರಿಂದ
ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ?
I have to file melots.
You have to file.
If it is posted, I'll
Enter
file.
ಮಾಡ್ರಿ ಯಾವಾಗ ಕೊಟ್ಟಿರೋದು?
On 8th or 10th ಕೊಟ್ಟಿದ್ದೀರಾ melots? ತಾವೇ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಮೈ ಎಂಟ್ರಿ ಮಾಡ್ರಾ?
Yes, melots. ಅದು ಅವರು just they have misguided the honorable court stating that it's a civil dispute. It's not a civil dispute. It's a theft melots. They have ED ಅಂತ impersonate ಹಾಕಿಬಿಟ್ಟು they have entered the 4th floor. There was 200 crore rupees gold stored in the in my gold.
ಅಲ್ಲಿಂದ 200 ಹೋಗ್ತಾ ಇದೀರಲ್ಲ.
ಅಲ್ಲ ಮೇಡಮ್, ಅದನ್ನ ಮುಟ್ಟಿಲ್ಲ my lords. 11 crore ನ ಎತ್ಕೊಂಡು ಹೋಗ್ಬಿಟ್ಟವ್ರು my lords. That has to be
11 crore ಎತ್ಕೊಂಡು ಹೋಗ್ಬಿಟ್ಟವ್ರ?
ಗೋಲ್ಡ್ ಎತ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ ಮೇಡಮ್.
ಸರಿ ಆಯ್ತು ನೋಡಿ. ಟ್ಯೂಸ್ಡೇಗೆ ಹಾಕಿ ಮೇಡಮ್.
Please my lords. Have mercy on me my lords, because
have mercy on you. Why?
30th ಗೆ ಪೋಸ್ಟ್ ಆಗಬೇಕು.
ಎಲ್ಲರ ಮೇಲೂ ಮರ್ಸಿ ಇದೆ ಸರ್. ಡೋಂಟ್ ವರಿ.
Please mercy.
One request, morning I had requested for 2:30, my lord. Number, FR number ಒಂದ್ ಸ್ವಲ್ಪ ಮಿಸ್ಟೇಕ್ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ my lord.
FR ಅಲ್ಲೂ ಮಿಸ್ಟೇಕ್ ಆಯ್ತಾ?
ಅಲ್ಲ ಅದು my clerk called me from there. I couldn't hear.
ಬೇರೆ ಹೈಕೋರ್ಟ್ FR ನಂಬರ್ ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ, ಇದರದೇನು ಸ್ವಲ್ಪ
ಇದೇನಾ? ವೈಸ್ ಲಕ್ಷ್ಮಿ ಮೇಡಮ್ ಮೀಟಿಂಗ್ ಇದು FR ನಂಬರ್ ಆಯ್ತು. 3:30 ಒಳಗೆ ಬಂದ್ರೆ ವಿಲ್ ಟೇಕ್.
Second complaint, my lords. My lords, I have succeeded in the divorce petition.
What?
I have succeeded in the divorce.
Succeeded.
Please, my lords. This is a second complaint. In the first complaint, no allegations has been made. No guidelines has been
Why
followed.
did you succeed in that?
Divorce petition, my lords.
ಅದಕ್ಕೆ ಈಗ ಬಂದಿರೋದು allegation. ಏನ್
Pursuant to
ಕೊಡಿ
the-
ಈಗ?
Please, wait.
Yes.
Monday,
next Monday, yes, 8th.
lords, and this is a pending matter. My lords. Great.
Yes.
Well, serial number 92.
92 ಎಲ್ಲಿದೆ?
92. ಅಲ್ಲ, petitioner is a senior citizen.
ಸೀಲ್ ನಂಬರ್ 92.
92. ಈಗ ಅರೆಸ್ಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ 1 ಗಂಟೆ.
ಎಲ್ಲಿದೆ 92? ಯಾವ ಕೋರ್ಟ್ ಹಾಲ್ದು?
ಸಂದೇಶ್ವರಿ.
92 ಇದೆ ಮೇಡಮ್. ಯಾವತ್ತಿನ ಲಿಸ್ಟ್ ಸರ್? ಮಂಡೇದ? ಇವತ್ತಿರೋದೇ 75 ಮ್ಯಾಟ್ರಸ್. ಬೇರೆ ಕೋರ್ಟ್ ಇರ್ಬೇಕು ನೋಡಿ.
ಅಲ್ಲ ಇಲ್ಲ ಸಂದೇಶ್ವರಿ.
Seal number 64.
Yes, in this case, I appear for the petitioners in this case, my lord.
ತಾವು ಯಾವ್ದಕ್ಕೆ?
64, my lord, serial number. Lord, serial number 64, my lords.
No adjournment, wait sir. Yes.
Recording settlement 64.
I appear for petitioner in this case, my lords.
ಅಯ್ಯೋ ನೀವೇನಾ ಸರಿ ಹೇಳಿ. ಹಾ
Lords, ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ mediation is scheduled on 5th February, my lords.
list the matter on 9th at 2:30 PM. Yes, next.
65.
The petitioner in this case, my lord, the parties are compromised.
Offense.
My lords, 498 AM.
ಎಲ್ಲಿದ್ದಾರೆ?
ಇಲ್ಲೇ.
ಆಯ್ತು ಸರಿ. ಸೆಟಲ್ಮೆಂಟ್ ಅಲ್ಲಿ
Please, I have filed an application.
Respondent
File an
ಯಾರು?
application for
Respondent ಯಾರು?
Respondent number R2 is the complainant, my lord. That is the wife
Who
of
is
the
appearing for the respondent?
respondent, my lord. I called him, but he is not
ಅಲ್ಲ,
out of town.
ಇದಾರ ಯಾರು?
ಇದಾರೆ,
Yes, all right.
Yes.
Done. Sign ಮಾಡಿ.
Yes. That's, I filed an application for impleading of
Husband.
Yes.
ಅದು ಎಜೆಕೆ ನಿನ್ನೆ ಮಾಡಿದಲ್ಲ impeding husband.
I'll amend the cost.
ಕೊಡಿ amendment
ಅಲ್ಲ,
ಹಾಕಿ
ಅದು
first.
ಕೊಟ್ಟಿನಿ, amendment ಕೊಟ್ಟಿನಿ.
ಎಜೆಕೆ amended cost rate ಹಾಕಿ ಅದಕ್ಕೆ.
There was a compromise between the parties before the mediation, my lord. That report has been done.
Yes. 66. Offense.
498, 498.
Will parties?
Parties, final talks are.
ಆಯ್ತು 9th. Yes. 9th at 2:30.
Kindly have it on Tuesday, my lord. Monday.
9th at Tuesday. Yes. Offense.
Yes.
ಎಷ್ಟು?
3 cases.
506 and CST.
ಸೆಟ್ಲ್ ಆಗಿದೆಯಾ?
No, my lord.
No. When do you want? 13th.
Yes, my lord.
13th.
No, my lord. In one case, it could not be settled. But in other 2 cases, it is settled.
No problem. You settle everything and come. 13th. Yes.
68.
Next.
ಕ್ರಿಮಿನಲ್ ಮಿಸ್ಲೇನಿಯಸ್ 270.
ಇನ್ನೊಂದು ಇದೆಯಾ ಜೊತೆಗೆ?
ಲೋಕ ಅದಾಲತಲ್ಲಿ ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ.
ಯಾವುದು? 68 ಅಲ್ಲ? 68 ಆ?
68.
Bill number 68.
ಎಲ್ಲಾಗಿದೆ?
ತುಮಕೂರು ಕೋರ್ಟಲ್ಲಿ ಆಗಿದೆ.
ಹಾ, ಮತ್ತೆ?
ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ.
ಹಾ.
4 lakhs ಕೊಟ್ಟಿದ್ದಾರೆ ಮತ್ತು ಹೊರಗಡೆ
ಆಯ್ತು, ಈಗ ಏನ್ ಮಾಡ್ಬೇಕು?
ಬರ್ತಿಲ್ಲ ಪಾರ್ಟಿ ಬರ್ತಿಲ್ಲ ಕಾಂಪ್ರಮೈಸ್ ಇಲ್ಲ.
ಪಾರ್ಟಿ ಯಾವಾಗ ಬರ್ತಾರೆ? 13ಕ್ಕೆ ತಗೊಳ್ಳ? ಬರೋ ಚಾನ್ಸ್ ಇಲ್ವಾ? ಆದ್ರೆ ಮತ್ತೆ ನೋಟಿಸ್ ಮಾಡೋಣ ತಳಿ. 1 additional SPP 2 emergent notice, there shall be an interim order of stay of stay application ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರಾ? ಹಾಕಿದ್ರೆ ಸ್ಟೇ ಕೊಟ್ಟಿರಿ. List on 20th. Yes, next.
69.
13th. ಇಲ್ಲಾಂದ್ರೆ 13th ಹಾಕ್ಬಿಡಿ ಮೇಡಮ್.
70.
ಆಗಿದೆಯಾ? Now cooperating. ಎಲ್ಲಾಗಿದೆ ಸೆಟಲ್ಮೆಂಟ್? ಆಯ್ತು. List the matter on 20th. Emergent notice. 1 additional SPP 2 emergent notice. Further proceedings before the concerned court where the petitioner shall remain stayed. Next. Stay application ilva?
71.
Requesting for a passover, my lords. The party is on their way.
On the way. All right, we'll see. 3:30.
72.
That was compromised.
ಅದೇ offense ಏನು?
506.
Offense.
506.
506. ಹೌದಾ? ಇದು ಬಿಡಲ್ಲ. ಇದು ಮ್ಯಾಟರ್ ಆಫ್ ಟ್ರಯಲ್. I will not permit settlement in this case.
Issue is
ಹಾ.
ಏನೋ ಒಂದು ಪಾರ್ಕಿಂಗ್ ಅಲ್ಲಿ
ಗೊತ್ತು ಸರ್. 506 ಯಾರು ಮಾಡಿ ಅಫೆನ್ಸ್ ಮಾಡಿದಾರಲ್ಲ, ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇರೋದು.
Correspondent number 2.
both
Case file ಆಗಿದೆ.
Submits as his entered appearance. ಅದು name so and so. Yes.
Order sheet signatures.
All sheet and sign ಮಾಡೋಗಿ.
Right.
73.
498 ಎಲ್ಲಿದ್ದಾರೆ?
ಕೋಆಪರೇಟ್ ಮಾಡ್ತಿಲ್ಲ ಮೇಡಮ್.
ಮಾಡ್ತಿಲ್ವಾ? ಸೇಮ್ ಎಂಟ್ರಿ ಮಾಡ್ರಿ. 20th ಹಾಕಿ ಇದ್ರಲ್ಲಿ ಮಾಡಿದ್ವಲ್ಲ. 70 ಏನ್ ಮಾಡಿದೆ ಅದೇ.
74.
Yes.
My lord, I appear for the petitioner. Criminal trespass and my lord, the criminal
Settle ಆಗಿದೆಯಾ?
intimidation. Settle ಆಗಿದೆ. Other side also. Settle ಆಗಿದೆ.
ಎಲ್ಲಿದೆ?
Compromise.
My lord, they are-
Already filed. Already filed. At the land council, Vipin Hegde appearing for the petitioner. Petitioner respondent.
Petitioner, my lord.
Petitioner and so settlement closed. Parties ಅಲ್ಲಿ?
Parties ಬಂದಿಲ್ಲ. But they have already filed a memo, my lord. Memo is produced at Annexure D. Before the suit ಇತ್ತು, suit ಅಲ್ಲೇ ಹಾಕಿದ್ದಾರೆ.
ಸೂಟ್ ಅಲ್ಲಿ ಆಗಿದೆಯಾ? ಹಾಗಾದ್ರೆ ಅದನ್ನ ಕೊಟ್ಟು ಸಾಕು.
Annexure D, my lord.
Suit ಅಲ್ಲಿ Annexure D is okay. Just check.
List number 2. Fresh matter, bill number 1.
I'm appear for the petitioner. Offenses are 498A, my lords. Petitioner is the accused number 2.
In the meantime, 26th, returnable by, yes.
Bill number 2.
ಇದು ಜೈಲು.
ಇದರಲ್ಲೂ based on a requisition.
ಅಲ್ಲ ಕೊಟ್ಟಿಲ್ಲಲ್ಲ? ನೀವು ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀರಾ?
ಹೌದು, ಹಳೇದು.
ಮತ್ತೆ ಬರೀ ನೋಟಿಸ್ ಈಗ ಕೊಡ್ತಾ ಇದ್ರೆ
No, now we stopped it because during the search we found a mobile phone is in his cell.
Inside the food?
Inside, no, in his cell. Therefore, we stopped it now. So we don't want unnecessary trial court.
Emergent notice to the, how do you serve?
We will serve, my lord.
The notice be served through the jail superintendent. There shall be an interim order of stay as prayed for on the score that though food was given to the respondent, what was found at the time of search in the cell is a cell phone.
Cell phone and the FIR has been registered for that.
Cell phone and an FIR is registered to that effect. In that light, there shall be an interim order of stay as spread for till the next date of hearing. Next.
Order seal number 3.
Learned additionally speaking.
My lords, appearing for the petitioner in serial number 3, my lords.
Post immediately after service of notice upon the respondent number 2. ಇದೆಲ್ಲ 7A matters, huh?
My lords, kindly have it on 12th, my lords.
ಎಲ್ಲ all will list them all on ಒಂದೇ ದಿನ ಹಾಕ್ತೀನಿ. Objection ಯಾವ್ದ್ರಲ್ಲಿ ಹಾಕಿಲ್ಲ ಹಾಕ್ಬಿಡಿ.
Yes, please, your lordship.
19th.
Yes, please.
All
Please,
on 19th up to 16th. Up to serial number 16, 19th.
Yes, please, your lordship.
Grateful.
Further hearing 17.
ಅದು ಅದೇ ಅಲ್ವಾ?
Further hearing 17.
Further hearing. Dilip Kumar, yes. 13th, madam. 13 entry order continues.
18.
Appear for the
Same 19th.
DA case, your lordship.
ಪರವಾಗಿಲ್ಲ ಅಲ್ಲೇ ಬರಲಿ.
Yes, please, your lordship.
Release the matter from the status of being part heard, post the matter in preliminary hearing. ಇದು ಅಷ್ಟೇ 193 same order 17. Release the matter from the status of being part heard, post the matter for preliminary hearing on 13th.
Reporting settlement 19.
Interim order may be kindly.
Okay.
For the petition, washing of domestic violence proceedings matters, not 198 in cooperating. I have a judgment declared a settlement.
ಎಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗಿದೆ?
Family court divorce settle ಆಗಿದೆ.
ಕೊಡಿ. ಆಮೇಲೆ ಅಲ್ಲಿಂದ they don't come forward at all.
That's page 32.
ಬಟ್ ಆಮೇಲೆ ನಾನು ಇಲ್ಲದೆ ಸೆಟಲ್ ಮಾಡಿದ್ರು ಅಂತಾರೆ.
ಇಲ್ಲ ಅವರೇ mediation agreement ಅಲ್ಲಿ action take your lordship to enforce. Page 32 and 33, my lords. 32, wherein she says that para number 7.
ಇಲ್ಲಿ ಡೊಮೆಸ್ಟಿಕ್ ವೈಲೆನ್ಸ್ ಇದೆಯಾ?
Domestic violence.
ಅಲ್ಲ ಅದರದ್ದು ಇದೆಯಾ ಇಲ್ಲಿ ಇಂಡಿಕೇಶನ್ ಇಲ್ಲಿ ಇದೆಯಲ್ಲ?
ಹೌದು. Criminal certificate of 25. para
ಪೇಜ್ 31 ಅಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀನಿ. ಆ ಪ್ಯಾರಾ ಮಾತ್ರ ಹಾಕಿ ಸಾಕು. Close ಮಾಡಿ.
Petition number is also.
Yes, close.
Petitioners are present.
Sign ಮಾಡಿ. Yes.
30 mood matter.
Please, great.
Order seal number 1, Shri Bhargav Ji.
My lords, one submission, my lords. In serial number 3, there is an interim order.
It will not continue, madam. Yes.
My lords, kindly interim order may be extended.
No, it will not continue, madam. Yes.
Your lordship, the has been filed for the offense of attempt to murder.
Attempt to murder. ಅದಕ್ಕೆ ಮತ್ತೆ ಮೂವ್ ಯಾಕೆ ಮಾಡಿದ್ರಿ ಈಗ?
ಇಲ್ಲ, ಯಾಕಂದ್ರೆ we had filed the petitioner, first petitioner had filed he had filed a FIR at an earlier point of time at 1:30.
So, case and counter case.
ಇಲ್ಲ, ಒಂದು ನಿಮಿಷ ಹೇಳ್ಬಿಡ್ತೀನಿ.
2 ನಿಮಿಷನೇ ತಗೊಳ್ಳಿ.
At 1:30, petitioner number 1 filed an FIR against the respondent and others, your lordship. And the entire facts of the matter revolves around the fact that petitioner number 3 rounded up everyone and he took a rod and hit the respondent here in your honor. Rod on tale hodru anta heltare. And petitioner number 3 is an advocate. On the said date, he was
advocate rod ತಗೊಂಡು ಹೊಡಿಬಾರದು ಅಂತ.
He was in Bangalore.
ಆಗಿದ್ದು ಎಲ್ಲಿ?
He was in Bangalore and his presence was marked before one of the courts here.
ಅಲ್ಲ ಆಗಿದ್ದು ಎಲ್ಲಿ ಇನ್ಸಿಡೆಂಟ್?
Incident Chitradurga. And he was present here.
Chartered flight line ಹೋದ್ರ?
ಗೊತ್ತಿಲ್ಲ. The allegation that
get the investigation paper.
Get the investigation.
2:30 ಗೆ ಯಾಕೆ ಮೂವ್ ಮಾಡಿದ್ರಿ? 2:30 ಗೆ ಯಾಕೆ ಮೂವ್ ಮಾಡಿದ್ರಿ?
ಅರೆಸ್ಟ್ ಮಾಡ್ತೀವಿ ಅಂತ ಅವರು
307 ಅಲ್ಲಿ ಮಾಡೇ ಮಾಡ್ತಾರೆ.
Your complaint ಅಲ್ಲಿ ಅವರು ಇದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ.
No, in our complaint, we don't say that the advocate was present. He was present in Bangalore at the relevant point of time.
We'll see. We'll post it on Tuesday.
Yes.
Tuesday.
Until then,
FH, FM, yes.
Seal number 2.
Until then, bail.
Even 6 and 318.
406, 420.
420. I am not the accused at all.
But why challenge?
ಅದಕ್ಕೇನು ಹೇಳಿ. My lord, may I just request your lordship to kindly turn to page 15. That is a complaint. ಇದು running account to transaction between two parties from the year 2024 and onwards. Have a look at the subject column itself. Probably I need not disturb your lordship by taking you. Page 15 subject.
ನನ್ನನ್ನು ನಂಬಿಸಿ ಚಿನ್ನದ ಒಡವೆಗಳನ್ನು
ಪಡೆದುಕೊಂಡು ಮಾರಾಟ ಮಾಡಿ ಚಿನ್ನದ ಗಟ್ಟಿ ಕೊಡುವುದಾಗಿ ನಂಬಿಸಿ ಹಣ ನೀಡಿದ ನಂಬಿಕೆ ದ್ರೋಹ ಮತ್ತು ಮೋಸವನ್ನು ನಿತೇಶ್ ಜೈನ್ ಬೋಹ ಮತ್ತು ಶ್ವೇತಾ ಬ್ರೋಹರ್ ಅವಳ ವಿರುದ್ಧ ಕಾನೂನು ಕ್ರಮ.
ನೀವು ಯಾವ ಜೈನ್?
ನಾನು ಅಲ್ವೇ ಇಲ್ಲ.
ಆಶೀಶ್ ಜೈನ್.
ನಾನು ಬೇರೆ ನಾನು. Then what happens is this, this crime came to be registered at Halsurgate Police Station, Bangalore. But one assistant commissioner of police of Yashwantpur economic offences, he would keep harassing us. Come settle the issue with him. Then, my lord, we would issue several notices and the final notice being.
To whom?
To the assistant commissioner.
Yes.
May I just request your lordship to kindly have a look, cursory look at page 78 for a second now. This notice was issued to him. Look here, you are harassing us like anything. You are troubling us. Why are you indulging in such kind of activities? Then, my lord, this notice was sent to him yesterday. Have a look at the date itself.
30th.
Yesterday. Well, what happens this morning is another police people would issue a notice to me. Please come and appear before us for investigation in connection with this case.
Which police station?
Well, now Malleshwaram police. Probably he became jittery. The assistant commissioner became a little bit jittery after the service of this notice. ಈಗ Malleshwaram police now. And FIR is not registered against me. The issue relates to the period 2024. A transaction interest.
Right, but
and ಜೊತೆಗೆ if it is a notice.
ಅಲ್ಲ ಯಾರು ಅಂಗಡಿ ಏನು?
I'm sorry, madam.
ಅಲ್ಲ you own a shop, is it?
ನನಗೋದಕ್ಕೂ ಸಂಬಂಧನೇ ಇಲ್ಲ. ನಮಗೇನ್ ಮಾಡ್ಬೇಕಾಯ್ತು ಕೊನೆ ಪಕ್ಷ 170 notice ಅಲ್ಲಿ ಕೊಡ್ಲಿ if my presence is needed as a witness. Or if my presence is needed as an accused under section 35 my lord of the BNSS, let him issue a notice.
ಇದ್ಯಾವ ತರ ನೋಟಿಸ್?
ಇದ್ಯಾವ ತರ ನೋಟಿಸ್ ಅಂತ ನನಗೆ ಅರ್ಥವಾಗ್ತಾ ಇಲ್ಲ. ಅದು ಏನ್ ಗೊತ್ತಾ? Forthwith right now you have to come ಅಂತ.
ಅಲ್ಲ what is this extra BNSS notice? And what provision is?
My lord, if I am a witness, 179.
No problem.
If I am an accused, my lord,
33(5).
Yes, 35. ಇದ್ಯಾವ ತರ ನೋಟಿಸ್?
Sorry.
ಅದು ಏನ್ ಗೊತ್ತಾ? ಟೈಮು ಇಲ್ಲ ಏನು ಇಲ್ಲ. Forthwith you should come ಅಂತ. That is number one. Well, the legal issue, apart from the facts of the case, the legal issue that is involved is whether they have the jurisdiction to investigate this case at all.
Heard the learned senior counsel C.V. Nagesh appearing for the petitioner. The petitioners are not accused. They are not proposed to be brought as accused also in the crime so registered in crime number 253 of 2025, but are repeatedly being called by the police to appear before them under what authority of law is not divulged. Owing to constant harassment, it transpires that a mail is communicated to the jurisdictional police before whom crime number 253 of 2025 had been registered, that the harassment is not stopping. The harassment from that police station appears to have been transferred to another police station, which admittedly is not inquiring into crime number, investigating into crime number 235.
Case has been transferred.
235 of 2025.
There is only one crime.
Transfer ಅಲ್ಲ ಟ್ರಾನ್ಸ್ಫರ್ ಯಾವಾಗ ಆಗಿದೆ?
ಆಮೇಲೆ ಈಗ ಮಲ್ಲೇಶ್ವರಂ.
ಟ್ರಾನ್ಸ್ಫರ್ ಎಲ್ಲಾಗಿದೆ?
ಅಲ್ಲ ಹಂಗಂತ ಸೆಕೆಂಡ್ ಪೇಜ್ ಇರುತ್ತೆ.
ಅಲ್ಲ ಇರ್ಲಿ. So and so. The learned additional SPP submits that the case has been transferred to another station, which has now issued a notice. The notice is produced. The notice notice does not indicate under what provision of law it is issued to the petitioner to summon. If he is an accused, it is open to the police to issue a notice under 35 of the BNSS. If he is wanting as a witness under 170. So 179 ಅಲ್ಲ ಅದು?
Oh, the 179,
Ah,
which is
170.
equivalent to 160, madam.
179
PNSS.
of the BNSS. Neither of the two has happened. It is this action of the policeman which is now become rampant, that has generated lot of litigation before this court. The action is not without any rhyme or reason calling people to the police station without indicating under what provision of law they are called. The notice now is termed as police notice 1. Under what provision, again as observed here and above, is not indicated. Therefore, the person who has issued the notice to these petitioners on 31/1/2026.
Today morning, madam.
Today,
This morning.
31/1/2026 shall be present before the court at 2:30 PM on Tuesday. All further action pursuant to the notice shall remain stayed. ಇದನ್ನ ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿದ್ದು ಇನ್ನೊಂದು ಸ್ಟೇಷನ್ ಇಂದ ಕೊಟ್ಟಿದ್ದಾರೆ.
Settlement cases.
ಅದು ಗೊತ್ತಾಯ್ತು.
Looks to me like that. I
Police
may be wrong. I may be wrong.
No, police. See.
Station to station. Also get registered ಮಾಡೋದು. ಯಶವಂತಪುರ ಬರೋದು.
Police sir.
ಯಶವಂತಪುರದಿಂದ
police
ಕೊಟ್ಟ ತಕ್ಷಣ ಮಲ್ಲೇಶ್ವರಕ್ಕೆ ಬರೋದು.
Police station to station, settlement to settlement.
And
crime solve ಮಾಡಿ ಅಂದ್ರೆ ಮಾಡಲ್ಲ, settlement ಮಾಡಿ ಅಂದ್ರೆ ಮಾಡ್ತಾರೆ.
ಅದು ಚಿನ್ನ ಬೇರೆ.
ಅದ
ಗೋಲ್ಡ್.
ಅದು ಮೊದಲು ಸೆಟಲ್ ಮಾಡ್ತಾರೆ.
And I don't know whether I am justified in making Marwadis ಸ್ವಲ್ಪ timid.
ಅದೇ ಭಯ, ಅದೇ ಆ ಕಮ್ಯುನಿಕೇಶನ್ ನೋಡೇ ಗೊತ್ತಾಯ್ತು.
Timid people.
This has led to an emotional breakdown. Yes. Office objection. Elli counsel, advocate on record. Office objections. When?
By tomorrow, by Monday.
We'll release the copy only after compliance.
By hand, not today, it may be sure.
Yes. The office objections be complied with by the evening of tomorrow. By the evening of Monday. Failing which interim order would get vacated.
3.
In the next time ಬರೋವರೆಗೂ ಅದು ಕಂಪ್ಲೈ ಆಗಿರಲ್ಲ. ಆ ಇಂಟ್ರಿ ಆರ್ಡರ್ ಸಿಕ್ಕ ಮೇಲೆ ಆಯ್ತು, ಆಮೇಲೆ ಮತ್ತೆ ಕೋರ್ಟ್ ಬಂದಾಗಲೇ ಗೊತ್ತಾಗುತ್ತೆ.
I come before your lordship with a similar
ಏನು ಎರಡಿದೆ?
Yes, both are connected. I come before your lordship with a similar grievance, except instead of harassing me through another unit of the state police, he has gone on to state of Gujarat, lodged a complaint in Gujarat, and the crime branch of Ahmedabad city is harassing me with notices. That your lordships will find at
Crime
page
branch
31.
of Ahmedabad is now true.
Yes, ma'am. Page 31, your lordship will find the notice. State of Karnataka is really not a substantive party to this petition.
But ಅವ್ರು ಇರ್ಬೇಕು.
Formally, I have made them a party. Actually, your lordship, page 31, your lordship will see,
Yes,
this is
I'm
what I have
there.
called into question.
I'm there,
Now,
yes.
I have to show your lordship what the background to this entire notice is. But if your lordship will come to page 32. Page 32, my lord, your lordships are there?
I am there.
Yes, ma'am. This is the complaint that the directors on behalf of the company lodge against Ashay Harlalka, who happens to be the complainant before the Gujarat police. This complaint comes to be filed on 28th March 2025. Your lordship will see the date on top. Lord, that results in an FIR that your lordship will find at page 37 on the very next day for offences under the IT Act, Lord, source code deletion, having caused loss to the company of over 25 crores. Similarly, my lord, that accused approaches this honorable court in August, moves this honorable court, not obtains a stay by filing a criminal petition that your lordship will find at page 40.
40.
Page 40, your lordship will see at page 41.
My order?
No, just below that. In that petition, he comes before this court and says this is a purely civil dispute between the shareholders, and comes and obtains a stay, my lord, against which we filed a vacating stay before your lordships. And after having filed that vacating stay before your lordships on 14/1, your lordship passes that order at page 40. After having filed that vacating stay, now see how, my lord, the counterblast triggers. Now, my lord, please see, this notice comes to be issued to me. This notice is dated 9/1/2026. 9/1/2026, he goes before the Gujarat police. All this while, not there are complaints filed against 3 separate employees before the Whitefield police. He has obtained an anticipatory bail before the Bangalore Sessions Court. He comes, obtains a stay before this honorable court, and there's another employee who was working directly under him against whom there's a complaint and FIR that is lodged. He also files a 482 petition before this court. After I filed a vacating stay before your lordship and your lordship have listed for 5th, he goes before the Gujarat police, my lord, and there gives a complaint that I have caused cheating and irregularities 9 months later. Now, please see, my lord, I did not say to the Gujarat police that I'm not going to comply with that order. Please see my reply at page 52. I issue a formal reply to that notice. In that notice, my lord, at para 3, your lordship will see, I'll say it is respectfully submitted that the complainant is not an unrelated informant approaching your office in the ordinary course. He is already an accused. Your lordships have it not?
Yeah,
Page
I'm
52.
seeing it, yes.
He is already an accused in a prior and subsequent criminal case arising from the same so and so. Lord, I set out all the details, my lord, when this 482 filed, when he obtained an interim order, and my prayer, your lordship will see at page 54, before that police station. Your lordship will see at page 54. I requested for a copy of the complaint. I requested for a clarification whether FIR number 176 and 502 were disclosed. And I requested for another date during which I will come.
What comes about?
That not results in a refusal to even give me a copy of the complaint, a refusal to give me a copy of the FIR. I cite your lordship's judgment in 15125, Lord, in which your lordship said if a 41A notice has to be given, it has to be accompanied with a complaint or an FIR. So I give a supplementary representation that your lordship will find at 57. In 57, I cite Supreme Court judgments. I cite Satyendra until, Lord.
So what happens?
Now, Lord, they have refused to give me a copy of the copy of the FIR or the complaint. They've refused to even acknowledge my replies. Therefore, Lord, I'm before your lordships. Now, your lordship may ask on maintainability. Office has not raised an objection on maintainability. I've narrated it in para 15.
It is maintainable.
Under 226 subclause 2, if even a part of the cause of action has arisen in the state, yes, I have judgments of Justice Nagaratna as well in Priya Indoria, that your lordship will protect me and I will go before the jurisdictional court and obtain.
First, we will tag it with that, the other petition that is pending.
Yes, your lordship may tag it,
That's
but
why.
in the meantime, Lord, your lordship may
That I
protect
will
me.
do. That I heard the learned counsel Angat Kamath appearing for the petitioner. The petitioner is the complainant against the present complainant, which in crime number
176 of 2025.
in crime number 176 of 2024. 2025. That is challenged before this court in writ petition, in criminal petition 12927 of 2025. On 10/9/2025, the coordinate bench, owing to the submission that it was a dispute which is purely civil in nature, grants an interim order of stay. Vacating stay application comes up on 14/1/2026. This court passes an order that no further adjournment would be granted and lists the matter on 5/2/2026. In the interregnum, the petitioner, the complainant in the case at hand, goes before the jurisdictional police at Gujarat, Ahmedabad, and registers a crime. The Ahmedabad jurisdictional police is now sending repeated notice to the petitioner under 35, ostensibly to be under 35(3) of the BNSS, seeking his appearance for the purpose of investigation. The petitioner, in terms of law, has sought copy of the crime and all other incidental details which are not divulged. The details are still not divulged, but notices are being sent to the petitioner. This, on the face of it, is an abuse of the jurisdiction and abuse of the process of the law. Therefore, there shall be an interim order as prayed for.
Lord, I've just asked no coercive action.
There shall be an interim order that no action shall be taken on the complaint registered by the sixth respondent before the jurisdictional police at Ahmedabad.
Lord, your lordship may say no coercive action.
So all stay, stay of the so-and-so,
Stay of the
and no coercive action shall be taken on the strength of the said complaint so registered against the petitioner. Tag the petition with page 41.
I'm so grateful.
Yes.
Trying to read whether Gujarat police are better in issuing 35 notice.
That's what. Same way. No, nothing. Nobody
They're
follows
issuing
the
notice
law.
even preliminary inquiry.
Preliminary inquiry.
I'm grateful.
Both matters. Same order. We'll tag the two arising out of same crime.
Same, Lord, it's not the same crime number. I don't even know what is the crime that is lodged.
Correct,
I don't have a
correct,
copy.
yes. Both same order.
1
in
year
both.
later, he goes before the Gujarat police and lodges saying, Lord, this
Same order. Same complainant alva.
he accused in my complaint.
No,
1
ಈ
year.
ಎರಡರಲ್ಲೂ
Yes,
same
yes,
complaint.
same
ಅಷ್ಟೇ sir. Yes.
Matter pertaining to Dharwad bench, still number 1, Sirajuddin Ahmad, extension of parole.
Yeah.
For extension.
What penalty?
Extension of parole.
Offense.
Read not to letter.
ಎಷ್ಟು ವರ್ಷ? Saturday ಆದ್ರೆ ಹಿಂಗೆ ಕೇಳೋದು. ಪೂರ್ತಿ ಕೇಳಕ್ಕೂ ಇರಲ್ಲ ಇಂಟ್ರೆಸ್ಟ್. ಎಸ್. ಒಫೆನ್ಸ್ ಎಷ್ಟು ವರ್ಷ?
302 ಲಕ್ಷ.
ಅದು ಗೊತ್ತು. ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು?
Eight years lodge.
8 years. ಎಷ್ಟು ದಿನ?
8 years 5 months lodge.
ಎಷ್ಟು ದಿನ?
For the further extension of 30 days lodge. 60
ಮುಂಚೆ
days.
ಕೊಟ್ಟಿದ್ದು ಎಷ್ಟು?
60 days lodge.
ಆಯ್ತು 30 days ಕೊಡ. 30.
Please lodge.
Number 2.
ಇದ್ರಲ್ಲಿ ಎಷ್ಟು? ಒಫೆನ್ಸ್ ಎಷ್ಟು ವರ್ಷ ಎಷ್ಟು ದಿನ?
302 lodge.
ಹಾ. ಹಾ.
10 years lodge. 10 years 4 months lodge.
ಎಷ್ಟು ಕೊಟ್ಟಿತ್ತು ಮುಂಚೆ?
60 days lodge. 30 days.
30.
Please.
ಅಷ್ಟೇ, ನೋ ಮೋರ್ ಎಕ್ಸ್ಟೆನ್ಷನ್.
Please.
ಇನ್ನೊಂದು ವರ್ಷ ಬಿಟ್ಟು ಬನ್ನಿ.
In the morning, my lord, one of the matter, your lordship may recall, my lord, 307 was booked and no investigation, no action had been taken against the accused in the beginning. Idralli, we have arrested accused number 1 and 2.
ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
ಯಾರಿದ? ಸಂದೀಪ್ ಶಾಸ್ತ್ರಿ ಅಪೇರ್ ಆಗಿದ್ದ?
ಅವರು ಅವರೇ ಇದರಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ, ತಮ್ಗೆ ಹೇಳಿಲ್ಲ ಅಷ್ಟೇ. ಇಲ್ಲಿ ರೆಕಾರ್ಡು ಹಾಕಿದ್ದಾರೆ.
ಹೌದಾ?
ಹೌದು.
ಮಂಡೇ ಹಾಕ್ಬಿಡಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್, ಡೋಂಟ್ ರಿಲೀಸ್ ಇಟ್. ಅಪ್ಲೋಡ್ ಮಾಡಬೇಡಿ. ಯಾರಿಗೆ ಚೆಕ್ ಮಾಡೋದು? ಅಲ್ಲ, ಬೆಳಗ್ಗೆ.
Matter pertaining to Kalburgi bench.
ಅದು ಇದೆಯಾ? ನಮ್ಮೆಲ್ಲ ಸ್ಯಾಟರ್ಡೇನೇ ಬೇಕಾಗಿತ್ತು.
5 matters.
RP, ಎಸ್.
RP
ರಿಪೋರ್ಟಿಂಗ್ ಸೆಟಲ್ಮೆಂಟಾ? ಇಲ್ಲಿ ಬಿಡಿ, ಹಂಗೆ ಇರಲಿ. 27th ಹಾಕಿ. ಇಲ್ಲ, ಒಂದು ಕೆಲಸ ಮಾಡಿ, 30th February ಹಾಕ್ಬಿಡಿ.
ಅವ್ರದ್ದೊಂದು ಮ್ಯಾಟರ್ ಬಂದಿದೆ.
ಲಿಸ್ಟ್ ಮಾಡಕ್ಕೆ ಕೊಟ್ಟಿದ್ದೀರಾ? ಕೊಡಿ, ನಿಮ್ಮ ಫೈಲ್ ಕೊಡಿ. ಒಂದು ನಿಮಿಷ. ಇವ್ರದ್ದೊಂದು ಅದೇ 50 ಗ್ರಾಮ್ ಗಾಂಜಾ. ಒಂದು ನಿಮಿಷ, ವಿಲ್ ಫಿನಿಶ್ ದಟ್ ಗಾಂಜಾ. ಆಮೇಲೆ ಕೇಸು.
The reason for rejection of bail is that he is earlier convicted for ganja offense.
ಅದೇ
Punishment now enhances.
ಇಲ್ಲ, ಪೆನಾಲ್ಟಿ ಅಲ್ಲ, ಪೆನಾಲ್ಟಿ ಒಪ್ಕೊಂಡು ಲೋಕ ಅದಾಲತ್ ರಾಜಿ ಮಾಡ್ಕೊಂಡಿರೋ ಸ್ವಾಮಿ.
ಗಾಂಜಾ ಲೋಕ ಅದಾಲತ್ ರಾಜಿ ಆಗ್ತಾ ಇದೆ.
1,000 ರೂಪಾಯಿ ಪೆನಾಲ್ಟಿ ಆಗಿದೆ. ಕಾಪಿ ಅಲ್ಲೇ ಇದೆಯಲ್ಲ.
Section 37.
ಲೋಕ ಅದಾಲತ್ ಅಲ್ಲಿ ಗಾಂಜಾ ಕೇಸು.
ಅಲ್ಲೇ ಇದೆ, ಆರ್ಡರ್
ನಾರ್ಕೋಟಿಕ್ ಡ್ರಗ್ಸ್ ಲೋಕ ಅದಾಲತ್ ಅಲ್ಲಿ ಕ್ಲೋಸ್.
ಮಾಡಿದ್ದಾರೆ ಸರ್. ಅಲ್ಲಿ ಕಾಪಿ ಕೊಟ್ಟಿದೆ.
ಇಲ್ಲ, ವಿಲ್ ಬಿ ಕ್ಯೂ ಇನ್ ಲೋಕ ಅದಾಲತ್ ಇನ್ಮೇಲೆ. ಅಯ್ಯೋ, ಲೋಕ ಅದಾಲತ್ NDPS ಕೇಸ್ ಕ್ಲೋಸ್ಡ್.
ಪ್ಲೀಡ್ ಗಿಲ್ಟಿ ಮಾಡಿರೋದ ಕ್ಲೋಸ್ ಮಾಡಿ.
ಪ್ಲೀಡ್ ಗಿಲ್ಟಿ ಪೆನಾಲ್ಟಿ ಕ್ಲಾಸ್, ಇದು ಪೆನಾಲ್ಟಿ ಕ್ಲಾಸ್ 1000 ರೂಪೀಸ್ ಆರ್ ಅಂತಿದೆ.
ಹೌದಾ?
In fact, my lord, I have seen one of the orders on a digital arrest. The complainant has not come. Accused has not come. Case has been closed.
ಲೋಕ ಅದಾಲತ್ ಅಲ್ಲಿ
On digital arrest in the magistrate.
ಈಗೆಲ್ಲ ಕ್ಲೋಸ್ ಮಾಡ್ತಾರೆ, ಪೆನಾಲ್ಟಿ ಕ್ಲೋಸ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಮೈಸೂರು ಎಲ್ಲ 70% ಕೇಸಸ್ ಕ್ಲೋಸ್.
ಹೌದಾ?
1,000 ಆಗ್ತಾ ಇದ್ದಾರೆ ಈಗ.
ಸ್ವಲ್ಪ ಸ್ಟಾಪ್ ಮಾಡಬೇಕು.
For accused not.
NDPS ನ ಕ್ಲೋಸ್ ಮಾಡ್ತಾರಾ?
ಪೆನಾಲ್ಟಿ ಕ್ಲೋಸ್.
ಏನ್ ಪೆನಾಲ್ಟಿ ಆಗಿ ಕ್ಲೋಸ್ ಮಾಡೋದು?
2,000.
ಇವತ್ತು ಗಾಂಜಾ, ನಾಳೆ MDMA ಕ್ಲೋಸ್ ಮಾಡ್ತಾರೆ. ಈಗ ನೀವೇನು ಕೇಸ್ ಕ್ಲೋಸ್ ಮಾಡೋದು ಬೇಡವಾ?
ರಿಲೀಸ್ ಮಾಡ್ಕೊಡಿ.
ರಿಲೀಸ್ ಮಾಡ್ಬೇಕಾ? ಸ್ವಲ್ಪ ಇರಿ ಒಳಗೆ.
Non bailable offense.
ಇಲ್ಲ, ನಾನ್ ಬೇಲಬಲ್ ಇಲ್ಲ, ಬೇಲಬಲ್.
ಯಾವ್ದು ಬೇಲಬಲ್ ಆಫ್ ಗಾಂಜಾದ ಯಾವ್ದು ಬೇಲಬಲ್ ಅಫೆನ್ಸ್?
Section 37 ಮೇಲೆ.
ಇಲ್ಲ, ಬರೋದೇ ಇಲ್ಲ ಅದು. ಹೈಕೋರ್ಟ್ ಇಸ್ ಸೆಡ್ ದಟ್ ಇಸ್ ಬೇಲಬಲ್.
ಯಾವ್ದು ಪ್ರಿಂಟ್ ಔಟ್ ತೆಗ್ದಿದ್ದೀರಾ?
ಸರಿ. ಇಲ್ಲ, ಬೇಲ ಆಗ್ತಾರೆ. Last punishment is 1 year.
High Court of Patna.
Punishment is
not binding.
Alla, my lord, also punishment is 1 year.
Not binding.
Punishment is 1 year. Or 1,000 rupees fine.
Offense to be
21
cognizable and non-bailable.
Sorry.
Offense to be cognizable and non-bailable.
ಯಾವುದು?
Section 37.
ಮತ್ತೆ ಯಾವ್ದು ಬೇಲಬಲ್ ಅಂದ್ರೆ?
ಇದೆ ಬೇಲಬಲ್. 21 be bailable. Punishment clause.
21B sir.
Section 37 ಸ್ವಲ್ಪ.
37 is a commercial quantity only. Wrong submission ಮಾಡ್ಬೋದು.
27A wrong submission.
37 commercial quantity.
ಈಗ ಎಷ್ಟು ನಿಮ್ಮ ಪಾಕೆಟ್ ಅಲ್ಲಿ ಇತ್ತು?
53 ಗ್ರಾಮ್ ಇತ್ತು ಅಂತ ಹೇಳಿ.
53 ಗ್ರಾಮ್.
53 1 kg ಗೆ punishment 1 year or fine ಅಂತಿದೆ. ನಮ್ದು ಇರೋದು 53 ಗ್ರಾಮ್. ಅದು entire plant will be seized.
Section 37.
ಅಲ್ಲ, commercial quantity.
ಅಲ್ಲ, that there is no distinction. Your Lordship
No,
is,
interpretations ಇದೆ High Court. Commercial quantity ಇದ್ರೆ it is.
that decision of Bombay High Court has referred for larger bench.
Larger quantity ಗೆ you will.
Larger
ನಾನೇ
quantity.
ಕೇಳಕ್ ಬರ್ತಿದ್ದೆ ಸ್ವಾಮಿ, ಬೇಲ್ ವಜಾ ಮಾಡಿಬಿಡು ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೆ.
ನೀವೇ ಕೇಳ್ತಾ ಇದ್ರಿ.
ನಾವು ಬೇಲೆ ವಜಾ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀವಿ. ಇದೇನ್ ಇಲ್ಲಿ ಕಾಂಟ್ರವೆನ್ಷನ್ ಸಿಕ್ಕಿದಾಗ ಈಗ ಎಲ್ಲ ಮೈಸೂರಲ್ಲಿ ಕಾರ್ಖಾನೆ ಇದಾಗ್ತಲ್ಲ ಸ್ವಾಮಿ, ಎಲ್ಲಾರು ದಿನ ಕೇಸ್ ಆಗ್ತಾ ಇದ್ದಾರೆ ಈಗ.
ಮೈಸೂರಲ್ಲ ಗಾಂಜಾ ಫ್ಯಾಕ್ಟರಿ ಇದೆಯಾ?
ಕಾರ್ಖಾನೆ ಸೀಜ್ ಮಾಡ್ಕೊಂಡದ್ರಲ್ಲ, ಬಾಂಬೆಲೆ ಎಲ್ಲ ಸೀಜ್ ಮಾಡ್ಕೊಂಡದ್ರಲ್ಲ ಸ್ವಾಮಿ. ಮೈಕ್ರೆಲ್ಲ ಸುಮ್ಮನೆ
ನೀವು ಬೆಸ್ಟ್ ಲೋಕದಲ್ಲಿ ಹೋಗ್ಬಿಡಿ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅಲ್ಲಿ ಒಳಗಿದಾರಲ್ಲ.
2 ಕೇಸಲ್ಲಿ ಕನ್ವಿಕ್ಷನ್ ಆಗಿದೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಸುಳ್ಳು ಹೇಳ್ಬೇಡಿ ಸ್ವಾಮಿ.
ಕನ್ವಿಕ್ಷನ್ಸ್
ಬರೀ ಸುಳ್ಳು ಹೇಳ್ತಾರೆ. 2 ಕೇಸ್,
ಯಾರು ಸುಳ್ಳು ಹೇಳ್ತಾರೆ? ಸುಮ್ಮನೆ ಹೇಳ್ತಿದ್ದಾರೆ ಅವರು.
ಒಂದ್ ಕೇಸ್ ಇರೋದು.
why will he tell lies?
ಇಲ್ಲೇ ಬರ್ದಿದಾರಲ್ಲ,
ಸುಮ್ಮನೆ
ಒಂದು ಕನ್ವಿಕ್ಷನ್ ಪೆನಾಲ್ಟಿ ಆಯ್ತು, ಒಂದು ಪೆಂಡಿಂಗ್ ಇದೆ ಸ್ವಾಮಿ. ಈಗ 3 ವರ್ಷ ಆದ್ಮೇಲೆ ಇನ್ನೊಂದು ಕೇಸ್ ಹಾಕಿದ್ದಾರೆ.
ಮಂಡೆ ನೋಡೋಣ ಬಿಡಿ, ಇರ್ಲಿ ಸ್ವಲ್ಪ ಒಳಗೆ. ಆಚೆ ಬಂದ್ರೆ ಮತ್ತೆ ಗಾಂಜಾ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಕಂಡೀಷನ್ ಕೊಡಿ ಸ್ವಾಮಿ. ಯಾಕಂದ್ರೆ ರಿಮೈಂಡ್ ಇಸ್ ಇಲ್ಲಿಗಲ್ ಸ್ವಾಮಿ. ನಾನ್ ಬೇಲಬಲ್ ಅಫೆನ್ಸ್.
Now the issue in Bombay High Court discussed.
But anyway, it is 27 andre it can be sent. Interim ಮೇಲೆ ರಿಜೆಕ್ಟ್ ಮಾಡಿದಾರಲ್ಲ ಅವರು.
ಹೌದು, because of this reason. That earlier conviction and other pending cases.
ಆಯ್ತು, ಸೋಮವಾರ ಮಾಡೋಣ ಬಿಡಿ.
ಆಗ್ಲಿ 20 ದಿನ ಇದಾರೆ ಸ್ವಾಮಿ.
ಇನ್ನೊಂದ್ ದಿನ ಏನಾಗಲ್ಲ.
ಆಗಿ ಪೆನಾಲ್ಟಿ ಒಪ್ಕೊಂಡಿದ್ರು ಅವತ್ತೇ ಕೊಡ್ತಾ ಇದ್ರು. ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಲಾಸ್ಟ್ ರಿಲೀಸ್ ಮಾಡಿ.
Right, we'll do it. We'll upload the operative portion.
Much of it.
But I think your Lordship may have to lay down the law. Interim al ಕೊಟ್ಟು ಬೇಕಾದ್ರೆ, because I think now the Bombay Court is looking at exactly identical issue.
Which is the judgment?
I'll paste it.
ಆಯ್ತು, let it be on Monday. Wait, on Monday ಕೊಡಿ. ಏನ್
ಇಲ್ಲ ಯಾವ್ದು ಇಲ್ಲ,
ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅವರೇ
ಸ್ವಾತಂತ್ರ್ಯ ಹೋರಾಟಗಾರರು
ಅಲ್ಲ, ಅದಂತೂ ಸತ್ಯ ಸ್ವಾಮಿ.
ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ, ಇರಿ.
ರಿಲೀಸ್ ಮಾಡೋದು, ಯಾಕಂದ್ರೆ ಆಗ್ಲೇ 15 ದಿನ ಕಸ್ಟಡಿಯಲ್ಲಿ ಇದ್ದಾರೆ.
ಗಾಂಜಾ ಏನ್ ಸಿಗಾಕೊಂಡ್ರೆ ಇರ್ಲಿ.
ಅಲ್ಲ ಮಂಡೇ
ಫಾಸ್ಟ್ ಓವರ್ 71
ಮೈಲಾಡ ಮಂಡೇ ಮಾಡುವ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಮಂಡೇ.
Fresh matters.
Matter has been settled.
Offense.
Parties are present.
498A 504, my lord.
Party? That's complainant.
This is complainant,
accused.
respondent number 2.
Oh, all right. ಅಲ್ಲೇ ಇರ್ಲಿ. Let them not come in. ಅಲ್ಲೇ ಇರ್ಲಿ. Yes. 498. ಕೊಡಿ. Closed. ನನಗೆ ಕೊಡು.
Presentation.
All right. ಲಕ್ಷ್ಮಿ ಮೇಡಮ್ ಕೊಡಿ, ನಿಮ್ ಫೈಲ್ ಕೊಡಿ. ಓನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆಯಾ? ನಿಮ್ದೆ ಓನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆಯಾ?
Your Lordship, page 155. Your Lordship, may kindly see.
ಓನ್ ಇದೆ.
Please, Your Lordship.
ಇದು ನಿಮ್ಮ ಓನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅವ್ರದಾ?
The complainants. Your Lordship, this is a 40-year-old partition suit going on.
No, one moment. Now, what is the allegation against you?
Allegation against me is I supposedly hurt them, grievous hurt, unlawful assembly in my very own property. They want to raise unlawful assembly, which we are not
447?
able to understand, Your Lordship.
No, but whose own certificate is this?
Own certificate is supposedly of the complainants. Strangely, Your Lordship may kindly see, it's on 29th. But if Your Lordship may kindly see the FIR, the first line, what it says.
Page.
19, Your Lordship.
ವೈದ್ಯರ ಸಮಕ್ಷಮ
Yes.
ನೀಡಿದ ಹೇಳಿಕೆಯ
Yes.
ಸಾರಾಂಶವೇನೆಂದರೆ
Now, if it is based on that, then on 28th, there should have been something. When they
Yes, sir.
call.
ಜಗದೀಶ್, ನ್ಯಾಯಾಲಯಕ್ಕೆ ಕಳಿಸಿದ ದಿನಾಂಕ ಮತ್ತು ಸಮಯ 28/1. ವೈದ್ಯಕೀಯ ಸಮಕ್ಷಮ 29. ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ಡ್ 28.
They're backdating, they should have done. There is a
ಅದು ಸ್ವಲ್ಪ
miss.
ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡ್ಬೇಕಾಯ್ತಲ್ಲ.
When they concoct a document, they should do it correctly, Your Lordship. That's all.
ಅದಕ್ಕೆ that's why it's always said, when you tell the truth, you don't need to remember anything. ಸುಳ್ಳು ಹೇಳಿದ್ರೆ ಮಾತ್ರ ಏನೇನ್ ಹೇಳಿದೆ ಅಂತ ನೆನ್ಪಿಟ್ಕೋಬೇಕು.
Your Lordship, very briefly, these are all related. 40-year-old partition dispute, they have lost in the low court. RFA also they lost. But in the RFA, one item, His Lordship said, let it go back only to see whether they've had any right on it or
But the
not.
learned senior counsel, Srimati Lakshmi Iyengar, appearing for the petitioner.
ಇದು ಕೇಸ್ ಅಂಡ್ ಕೌಂಟರ್ ಕೇಸ್.
Case and counter case ಗೊತ್ತು. The petitioners and the complainant and the petitioner are members of the same family who are in a squabble over a partition suit with regard to partition of the joint family properties. It transpires that the complainant has lost several suits, including a regular first appeal before this court, which, albeit partially, as only a portion of the property was sent back for redetermination. During the subsistence of the said proceeding, it transpires that the petitioners have trespassed into the property of the complainant and assaulted him. The learned senior counsel submits the petitioner's property. Petitioner is in his own property, and there cannot be a trespass or otherwise into one's own property. And that which would this statement would become acceptable in the light of plethora of cases, civil cases between the two in which the petitioner has succeeded. Though this is a case and a counter case, it transpires that the dates of the medical certificate, wound certificate, or the date of the injury and the date of registration of the crime would create a lurking suspicion about the incident happening itself. In that light, there shall be an interim order of stay of investigation till the learned additional SPP would secure and place the records for the perusal at the court, investigation papers. That has happened till date. List the matter on 6th. Howda?
Stay better, protect.
Don't allow, you don't, they will not trouble you. Yes. In that light, there shall be the investigation papers conducted till the next date be placed before the court. In the garb of investigation, the petitioner or his family member shall not be harassed or coercive steps taken against the petitioner. That's as good as stay.
Your Lordship,
Now, Supreme Court says that's as good as stay.
I understand, Your Lordship. The difficulty.
No, I just
is
want to
this-
know the truth because of the wrong dates in that. Investigation is stay up train agala.
He seems to be still in hospital.
No, that's fine.
Let's see.
Your
No, I have
Lordship,
protected you. No
He's
problem.
very
at all.
smartly sitting in an ICU so that even photos of his face are not taken so that it shows there's nothing.
No
Difficulty,
problem.
There's no stay, Your Lordship. Even as of yesterday, they're trying to bring in 3 more new people into the. So if there is no stay, then in the FIR, even without troubling us, they'll try to bring in other family members and add on, which is what we don't want.
Aden madala. Those things, and the learned senior counsel generates an apprehension that other family members also would be dragged into the web of crime by registering separate crimes or into the crime itself. Learned additional SPP undertakes that such an action will not be taken till the next date of hearing. 6th.
But please, Your Lordship had dictated that a portion of it had gone for redetermination. It is not even for redetermination, only certain clarification with respect to rights.
Redetermination, beda. Clarification.
Obliged.
Monday.